What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, everybody, everywhere you happen to be in this fine little world of ours. It's good to see you here. It is 11 p.m. in Korea, and we are here for the Matthew Terry trial. Today, what can we expect? This morning, I think the prosecution only has two more witnesses. I think they have the investigator who investigated his previous stabbing in Michigan and the ex-girlfriend that he previously stabbed in Michigan. I believe those are the last two witnesses. And I think they're going to try to finish them up this morning. And the judge was talking like the jury should be ready to go into deliberations by tomorrow morning. So that indicates to me that the defense may not be spending a lot of time presenting a case, which they don't have to do. The defendant doesn't have to prove anything. They can just sit up and say, we don't think the government has met their burden of proof, and sit down. They don't have to put on a case. The prosecution has to prove what's going on. So that's where we are. Have I gotten any sleep? I got a couple hours sleep here and there. And I don't know if I'm going to be able to do the entire thing today. I'm desperately going to try. We'll see how it goes, at least till lunch, and we'll see how it goes after that. If for some reason I'm unable to fulfill my duties as Lorax, Legal Advices will start a little bit early tomorrow and make up for, and we'll play catch up like we've been doing, but I'm going to try to get through all of it today. Nothing's going on in the court yet. They're still mulling about, prancing around in front of the camera. How are y'all doing? It's great to have you here. And so far, there's been no buffering issues. Shh, don't let law and crime hear that. So what's up? We got some time to kill till the court gets going. And so in the meantime, just welcome all of you here. There's already 342 of you waiting for this trial to begin, which I think is interesting because Law and Crime has 1,900. They had 380 a minute ago. So, hey, we're still not doing too bad. So for those of you that are here, please do a big favor and hit that like button. We've got 164 likes. It's 179 likes now. So we're just about 30%. 50%. Lawyers can't do math. So I'd appreciate it if you do that. Hit that like button. Let's keep us right up. Concurrent viewers and likes the same as long as possible. So that's the like grift. You know where the like button is. You don't think about it. We do. That's the big thing that YouTube pays attention to is the likes on the video. So that's why all of us YouTube content creators beg you to hit that like button, because that's the main matrix that YouTube looks at when deciding whether to recommend videos to you in the end cards or in your recommended feed or in the main screen. That's based a huge part on likes. And subscribe. I don't know where we are on subscriptions right now, but we can check that. Let's, sorry, gonna get a little bit of a throat tickle there. 32,271 likes. Oh, we can easily get up to 32,300 likes today. 30 more likes today. That's my goal. Not likes, subscriptions. My goal is to get up to 30 more subscriptions today, and that'll put us at 32,300. Hey, mods, welcome here. We've got our mods here. Which mods? We see Rose is here. Alan is here. Rose and Alan, looks like you're about it here today so far. We'll see who else shows up as the day progresses. And right straight out of the gate, we have our very, very first super chat of the day coming to us from Michelle. Hey, Michelle, how's it up? Hey, hi. Come here often. How will you stream both? I'm not streaming both. Nick is over there watching people get hit by cars. Well, he's not watching. He's watching people talk about what it's like to see their loved ones get run over by cars. I'm here watching a lady talk about what it feels like to be stabbed in the face. Tomorrow, though, will be the actual sentencing of Brooks. And unless there's something really super amazing going on in this trial, we'll cut over and just watch that a little bit. But hopefully it won't be a big deal. Hopefully the jury will be deliberating by tomorrow morning. We'll just have to see what happens. So, yeah, today not doing the anything with Brooks. We're just sticking here with the Stabby McStab face. I haven't invited anybody yet. We'll have to invite some peeps to join later on. Sorry, kind of getting a little throat tickle again. Nothing like a little seltzer water won't cure. Hey, Flux is here. Bruh, I've been here, says Flux. Yeah, well, you just weren't talking, so I didn't know you were here. Yeah, YouTube was really squirrely yesterday. We had over 1,000 viewers, and it was saying we only had 45. Corn Pope, she was off in some purgatory somewhere. It couldn't communicate with the outside world. But here we are, and like I said, you know all about the like button. Hit the like button, subscribe. We're going to try to get up to 32,300 subscriptions today. Super Chat is not required, but is greatly appreciated. Anything you want to put in Super Chat, I guarantee I'll answer the question. I'll address whatever it is. Whatever it is gets read. And other than that, we'll just kind of try to read as much as I can from the chat and respond. But if you throw your hard-earned money at me in Super Chats, that guarantees you get bumped straight to the front of the comment line, and we'll read those when we can. When there's a lull in the trial or something, then we'll read the Super Chats as we go through. So that's it. Let's bring this up here so you can see the camera while we do this. We'll scoop it here for now, so you can see my big, happy, smiling, dumbass face. And while we wait for the court, the judge is sitting on the bench there, so it shouldn't be too long before things start going forward. The fireworks aspect of the trial is over. No, of that trial. Oh, that trial. Yeah, the Brooks trial. Now it's just, people talking about what it's like to watch their grandma and babies get hit by trucks, which isn't something I really want to do. Ow, we're starting hard today. Throat tickle, is that what Matthew Terry is trying to cure his girlfriend? Ouch. That's pretty rough. What do you got up here? Stingy in the house. Endurance expedition or last wit week-long class? Endurance expedition or last wit week-long class? I don't know what last wit week-long class is, but the endurance expedition is always a good thing. Sorry. Yeah, chat is savage. We have if you're not familiar with the chat, we have the greatest chat on the entire internet right here. You guys rock. Everybody else thinks they have the best chat, but that is demonstrably untrue. The Vice Squad is the best chat. We have the best mods, the best chat. And for those of you that just have this playing on in the background as you're driving around doing your work in the office, whatever, hey, deeply appreciate that. If you get a chance later, come back and hit the like button. Leave a little comment. The YouTube algorithm gods, they like the comments too. 4 words or more and likes. So, hey, this is doing pretty good. We got 500 people here and 300 likes. We're just... I got another nasty gram. Someone left a nasty comment. If you stop talking about likes so much, maybe people would start liking them more. No, you got to talk about likes because you guys don't think about it. You're just watching the video. And it's just the content creators doing the live stream going, oh my God, nobody's liking this. Nobody's liking this. Oh my God. So, yeah, it's something we pay attention to that you guys just don't. It's easy. Even the content creators I watch, so many times I'll just go, oh my God, I forgot to watch. I forgot to hit the like button. Crap. Yeah, no, I wish I only had it once and it was totally asymptomatic. I didn't. 2 people in our office got it, so we all went down to get tested, and they said I had it too, back about a year ago. I was totally asymptomatic, I guess, which is good, but I just had to quarantine at home for a week what felt like for no reason at all. But guy in our office got it the other day. He's home for a week, so I keep hoping maybe I get to stay home for another week. Then I could stream all day, every day. Oh, look at this smug asshole. Oh, sorry, shouldn't start swearing so early in the stream. Look at this smug, arrogant fool. That's what I was going to say. All right, the jury is coming in. We are off to the races. Probably, I don't know. My dad thinks saying dang and heck and suck are swear words, so. Does Terry have bail? I think it's $1 million cash bond, so no, he's in jail.
Ladies and gentlemen of the jury, good morning.
Oh, we're gonna need to pull up the volume.
Back. Happy Tuesday. We got you in the court.
Let me know how the volume balance is.
10 minutes after I expected to start, so I don't know that it's necessary. I can save my spiel about taking full responsibility. We're pretty close to
we'll see how it goes.
Time today. So, first thing, as always, though, that I need to ask you is, was anybody, by show of hands, exposed to anything about this trial between the time you left the courthouse yesterday, or the courtroom yesterday, and the time that you returned into the courtroom today, by way of media, discussion, anything, in any way, shape, or form, about this trial outside of the courtroom, by show of hands?
Did anybody see anything outside of the court? Nope.
We are going to pick up where we left off, and at this time, I'm going to ask the state to please call their next witness.
Show about USS Cyclops mysteriously vanished.
Michelle Rogers.
Cool. Oh, here we go. Here's the old girlfriend. Here is the old girlfriend.
I'm going to do it when she comes in.
All right, this is what we've been waiting for.
Ladies and gentlemen, before this witness testifies, I have a brief instruction. I just didn't want to start reading it, and then she came in like this, so I'm going to wait till she comes down here, and before I swear her in, I'm going to read you a brief instruction. Ms. Rogers, good morning and welcome, ma'am. I'm going to swear you in just a moment, but I need to read an instruction to the jury first. The evidence that you are about to receive concerning other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you for the limited purpose of proving intent, identity, or the absence of mistake or accident, and you shall consider it only as it relates to those issues. However, the defendant is not on trial for a crime, wrong, or act that is not included in the indictment. Ms. Rogers, if you'll raise your right hand, please. Thank you. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God?
Yes, I do.
Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat.
Hey, just in time. She's taking the stand, Steve.
Hey, what's happening?
They've just given the limited instructions.
And then I'll let the attorneys proceed.
Thank you for. I'm going to be on till 11. If I've got an appointment with Megan Fox at 11, but.
I am Michelle Rogers.
And Ms. Rogers, I want to ask you, do you know someone by the name of Matthew Terry?
Yes, I do.
Do you see Mr. Terry in the courtroom?
Yes, I do.
Could you please point to him and describe what he's wearing so we know exactly who it is you're talking about?
He is sitting over here wearing a gray blazer and glasses.
Your Honor, I'd ask the record reflect to identify the defendant.
Record shall so reflect.
All right, Ms. Rogers, I want to ask, how did you come to know Mr. Terry?
We met on a dating app back in, I think it was May of 2015.
And somewhere after you met on a dating app in 2015, did you all start a relationship?
Yes, we did.
Did that relationship continue through March of 2017?
Yes, it did.
By the time we get to March of 2017, are you and Mr. Terry in what we would call a boyfriend-girlfriend kind of relationship?
Yes, we were.
And were you living together?
Yes, we were.
There's a home at 626 Worthington Drive in Lansing, Michigan. Is that the home where you resided?
Yes, that's correct.
And did you reside there with Mr. Terry?
Yes, I did.
I want to specifically ask you about Friday, March 17th, 2017. Was that a holiday?
Yes, it was.
We'll talk about this soon.
For St. Patrick's Day, did you and Mr. Terry have any plans set together as a couple?
Yes, we did.
What were the plans?
The plans were to meet up with a few of his friends and go out to celebrate St. Patrick's Day by drinking.
All right, so your plan was to go out during the day.
What else are you doing on
go
St.
have some
Patrick's
beers,
Day?
Hang out with friends, things like that.
Yes, but not to stay out too late.
That day, did you end up going through with the plan and going out with Mr. Terry?
Yes.
What time of day do you think you went out and started hanging out and drinking?
So we started around lunchtime. It was
Oh,
around
God.
noon, 12:30.
I started drinking at
And
lunchtime.
we met at a place called Clatta's Irish Pub, and we had lunch and drinks there.
And did you all stay out the remainder of the day celebrating, drinking, hanging out with friends?
The majority of the day, not the whole day.
When did the day start to wrap up for you?
I believe it was around 6 o'clock. It was just starting to get dark.
And I want to ask you, during the day, are you drinking?
Yes.
What are you drinking?
It was different at each place. At Clatta's where we started, I believe we each had a beer, and then we split a beer there along with lunch. And then we moved to another bar called Tavern and Tap, and we had, another beer and I think shots there as well. And then moving to another place later on where I only had water.
Okay. So you kind of talked about it, but Mr. Terry is drinking throughout all of this?
That's correct.
Both beer and liquor?
Yes, from what I remember.
And so somewhere when the day is starting to wrap up for you, somewhere around 6 o'clock, did you have a chance to see Mr. Terry?
Before I left, yes.
And can you describe his condition at that time in terms of how sober or not sober he may have been?
When I found him, it was in an adjacent bar that was completely empty. So I went in there and he couldn't even speak English. He was slurring his words so bad. He was just talking nonsense. And
He was
stumbling
talking
all over
alcohol.
himself at that point.
All right, and did you tell him you wanted to go home at that point?
Well, I did, yes, but I left without him because I was upset at his condition.
Okay, and so you end up leaving the bar and going home on your own. Is that somewhere around 6 o'clock-ish?
That's correct.
So at some point, do you see Mr. Terry again later that evening?
Yes, I do.
In between that time, have you been drinking?
Not in between that time, no.
And what
So
time do you think it is roughly when you see Mr. Terry?
It was dark by that point. I would say 9
So
o'clock.
this is how it's going to be, is it,
Okay,
Mike?
so it's been a couple hours.
We'll read this in a bit.
Is that a yes?
Yes,
When he comes, I guess you see him back at the house, correct?
correct.
Describe how he comes home and what happens when he comes home. Tell me what he's like at that point.
So he didn't come to the front door. He came to the back door, which was right off of the kitchen, the sliding door. And he knocked at that door, and I proceeded to let him in. At that time, he was very clearly drunk. He couldn't walk straight. He seemed just very, it's hard to describe, but just you could kind of sense his energy as being very frustrated or angry or upset, just in general. Just a
He
general
blinks a
sense.
lot.
So as the kids say, you got a vibe off of him that he seemed angry.
Correct.
Did you do anything in that moment?
I did not. I went and I sat back down on the couch where I was when he showed up.
And what does he do?
So he went into the kitchen, and I believe he was making a sandwich. He was making some kind of food at the counter, and the kitchen and the living room area is pretty open. So as I was sitting on the couch, I could see him.
And just to help the jury picture that, if you're sitting in your living room, can you see into your kitchen?
Oh yeah, no, none of that today, folks, please. Come on.
Yes, it's an open layout.
It's like an open concept kind of thing?
Yeah, with just the counter dividing the living room and the kitchen.
We're at
Right, so you
potato
can see him
cam
in the
level
kitchen,
already.
He can see you in the living room and tell us what.
Oh, come on. This is so bad. We got so
happens
close.
next?
There we go.
So I remember sitting on the couch watching TV, and then
It's like drunk goggles right there. It's all fuzzy.
Yeah.
the next thing I remember is standing behind the couch, and I'm looking at him in the kitchen, and I remember him coming around the counter and coming at me.
Before that, before we get to the part where he comes at you, do you remember if you guys are having any sort of argument, if anything's being said, either he's saying something, you're saying something, whatever?
Oh my gosh.
The case may be?
I don't recall any of that, no.
Boy, this is going to be a good witness for the state.
So you remember
Yeah.
now all of a sudden there's a moment he's coming at you, and I want you to describe
Come on.
Describe that as best as you can. Do you mean he's just leisurely walking in your direction?
No, he was coming at me very quickly and aggressively to the point where I kind of backed off and braced myself. And
Oof. Come on.
Please. This is
I
potato
actually
vision.
verbally said, what are you doing? Oh my God, what are you doing?
And when you said the words to him, what are you doing? What, if anything, did he do?
He proceeded to knock me into the front door that was behind me. And at that point, then we both fell to the floor.
All right. Do you mean he makes physical contact with you somehow?
Correct.
How does he physically contact
Just with
you?
his body, like just taking his whole body and pushing it into me.
And at that point, do you say anything to him?
I don't think I said anything at that point, no.
All right. So what happens next?
So then we're on the floor and he's just trying to keep me on the floor, and he keeps punching me wherever he can find access to punch me. So whether it be the face, the chest, the back, wherever.
Wow.
And he was a wrestler, and the best way I can describe what he was doing is trying to keep me in wrestling moves and keep me on the floor so that I couldn't escape.
When you say he's a wrestler, you mean like in the WWE, or you mean like a high school?
A high school coach, or a coach, maybe it was not high school, but he was a wrestling coach. And I can't remember if he wrestled himself, but.
So you guys are now on the floor near the front door, and there's a fight happening on the floor. At any point, do you say something to him to try and diffuse the situation?
Yes, so as the struggle continues and I'm trying to break free, there was a point when I yelled at him. I said, I love you, why are you doing this? And he said, no you don't, fuck you, I'm gonna kill you.
All right, and do you remember those words specifically? No you don't, fuck you, I'm going to kill you.
I will never forget them, yes, I remember.
So tell us what happens next in the fight.
He just continues to, for lack of a better phrase, beat the shit out of me. And I keep trying to escape. There is a point where I'm able to stand up, and he continues to punch me in the face. At one point, he gets me onto the floor, and...
Are you still in the same place by the door, or has the fight moved?
No, it moved through the living room, and then where I landed on the floor was, I landed face first. With my upper body like on the kitchen tile, and then my lower half was on the carpet of the living room. And at that point there was blood everywhere.
Where is the blood coming from?
I believe my nose. At that time he had broken my nose. But I remember trying to push myself up, and he was on me, and every time I tried to push myself up I couldn't grip on the floor because there was so much blood. And he would purposely put his weight on me and push me back down, so I was unable to get up.
And through all of this, are you fighting, resisting, trying to stop him?
Yes.
So what comes next?
So I remember laying there, and I was laying on my left side, and I remember seeing the trash can there. There was a black trash can, and at this point he was taking both of his hands and he was taking my head and he was slamming it into the floor. And so every time he would do that, my vision would go.
Wow.
And I thought he was going to knock me out, or I would be unconscious or something at some point.
At some point, does there ever come a moment in the fight where there's sort of a break in the action?
Yeah, so after that, there was a time that he got up off of me for a short time, and I was able to sort of sit up on the floor, and I remember just kind of having my head down and just, I was thinking like, holy shit, that, is this really happening? And I was really disoriented and dizzy, and I was hearing all the shuffling in the kitchen. And then the next thing you know, Mr. Terry comes around behind me and stabs me in the neck.
Oh, God.
You say he stabs you in the neck. Do you know what he stabs you with in the neck?
I didn't see it, but it was a knife.
All right. And when you heard the shuffling in the kitchen, do you keep knives in the kitchen?
Yes.
So looking
Cheers,
back
Mike.
now, when you hear the shuffling noise in the kitchen, is it the sound of someone rummaging in the kitchen looking
Yes.
for something potentially?
Sorry, yes.
All right, so now you are still seated on the floor, and I want you to describe your position and his position at the moment when you feel something plunged into your neck.
Oh,
So again,
wow.
I'm sitting on the floor, and I'm kind of just, again, disoriented, just kind of sitting, with my hand and my head in my hand. And then he comes around behind me and he wraps his arm around my neck and he stabs me in the throat with a knife.
So he's stabbing you from the back.
Yes.
wrapping around you to strike.
Yes.
At that moment, are you armed?
No.
Are you even standing up to put up a fight?
No.
So now he stabs you in the neck with something, which you assume is a knife. What happens?
So at that point, again, it was just kind of the thought, like, holy shit, he just stabbed me with a knife. Like, I need to get the hell out of this house or I'm gonna die in here. And so I remember standing up, and as I stood up, he continued to, try and stop me and try and punch me. I was able to get loose for enough time to be able to turn around, and directly behind me there was the garage door. So I was able to get the garage door open and run to the garage.
All right, now you're in Lansing, so I'm guessing homes might be laid out a little different, but is there access from inside your home to the garage?
Yes, there's a garage door that goes into the garage.
All right, well, we have those here in Florida too, so that's not so different. But at this time of the year in March, is it snowing in Michigan?
There was a light blanket of snow on the ground at this time, yes.
All right, so you now make for the door to the garage, and as you step into the garage through the door, is there a garage opener?
Yes, so I pushed the opener with my left hand as I was running out to try and get the garage door to open so I could escape that way.
And did the garage door start to open?
It did, and I ran towards it, but it was very slow, so I couldn't quite get under it right away before he was able to get to me again.
All right, so now you're waiting for the garage door open enough, and he attacks you again?
Yes.
Describe how he's attacking you again.
He was just trying to stop me from leaving, and we both fell to the ground at that point and somehow had rolled out of, the garage that was open down the driveway.
So now you've spilled out onto the driveway, like out in public.
Correct.
And what's happening there?
So we were rolling down the driveway a bit, and I ended up in a position where I was under him and he was on top of me. He had used both of his hands to take my head and slam it into the cement multiple times. Sorry. So he had the knife, and he had stabbed me 3 times in the right shoulder.
All right, so he's still armed with this knife, even though you fled out of the home and he's chased you.
Yes, and this entire time I'm screaming for someone to come help me.
At any point, do you realize that some sort of like neighbor or person nearby has responded to your calls for help?
Yeah, as I was screaming, I could very faintly hear voices across the street saying, get off of her, and just hear them talking. A lot of it I couldn't make out what they said.
All right, and so we're at a point where Mr. Terry and you are in the driveway, you're still fighting, he's still armed with a knife. Tell me what else he's doing and what you're doing in response.
So again, I'm screaming this entire time, that he's going to kill me and somebody please help me. But he had stabbed me those 3 times in the shoulder, and he went to bring the knife down again, and I had reached up and I grabbed with my right hand the blade end of the knife in midair, and don't ask me how I did it. I just grabbed, and I took the knife and I pulled it. Again, I'm on my back, and I pulled it across my face, and I just remember thinking he was gonna stab my eye out or something as I'm doing this, but I was able to pull the knife enough over that it fell out of his hand, and it fell to my left side. And then I kind of rolled over it and tucked it underneath me so that he didn't have access to it anymore.
And so once you've kind of tucked the knife under your body, rolled onto it, does he stop fighting with you, or does he still
No.
keep trying to get the knife?
No, he was still slamming my head to the floor, and he would reach down with his hand and he would try and fish for the knife real quick, but then I would try to get up, and then he would hold me back down again, and then kind of just back and forth, trying to fish for the knife, and I'd get up and he'd try to fish for the knife, and then he'd push me back down. And there was a point when he had gotten really pissed off because I was kind of holding the knife with my arm as it's tucked under me, and he reached down and he bit me on the forearm here to try and get the knife loose from my grasp.
Is that the only place he bit you?
No. Shortly after that, after
Really?
he fished a couple more times for the knife and couldn't get it, he reached down and he bit me twice on the side of my left cheek to try and get me to let go.
And throughout all of this, are you screaming and yelling for help, asking him to stop, putting up resistance?
Yes.
So does the fight sort of end at some point?
Yeah, so we didn't live that far from the hospital and stuff, and as the neighbors were, I later found out they were on the phone with 911 at the time. We could hear sirens coming. You could hear them coming from around the corner, not too far away. And when we both heard the sirens, that's when he got up off of me and ran back in the house.
And what did you do?
I got up and I grabbed the knife so he couldn't get it back again. And I couldn't see very clearly because my contacts were in, but they were all like covered in blood. But I ran across the street to the voices of the neighbors who were telling me to come over there, come here. And then I proceeded to go across the street and I collapsed on my back in their front yard.
And where was the knife when you went across the street?
I'm not sure where it landed, but I remember when I fell down, I threw it so that if he came back, he wouldn't find it.
So you carried it with you away from the driveway to wherever it is you ended up in the yard of the neighbors?
Correct.
At some point, did law enforcement come and respond, and emergency medical people respond and end up taking you to the hospital?
They did.
Your Honor, if I can approach the witness.
Wow.
I want to show you, ma'am, what's been marked states 67A through H.
Yes,
Did you have a chance to look at these earlier?
I did.
Do these photos fairly and accurately depict the injuries that you suffered in the fight with Mr. Terry?
Yes, they do.
Your Honor, at this time, I'd move into evidence states exhibit 67A through H.
Other than previously discussed, any objections at this time?
Not other than previously discussed.
All right, they'll be admitted.
Permission to publish, Your Honor?
You may.
Ma'am, I'm going to show you 67A. Is this you in the hospital?
Yes, it is.
You are not wearing makeup, right?
No.
Okay, so the discoloration around your eyes, is that bruising?
Yes.
I want to draw your attention over here to what is your left shoulder, but in your picture it's on the right side. Is this an injury you suffered from one of the knives that stabbed into you?
Yes.
I'm glad they're not showing these.
I'm going to show you state 67B. I want to draw your attention right here to the almost dead center of your neck. What is that?
She's a great witness for
Is that
the,
stab wound that you talked about when he came behind you and stabbed you in the neck?
Oh, well, they are. Never mind.
Obviously here, this has been stitched up, but at some point that was an open gaping wound, I assume?
Yes.
Here's State's Exhibit 67C. What are we looking at here?
That's my right eyebrow where I was stabbed.
Here's State's 67D. What are we looking at here?
My right cheek and another stab wound.
Here's State's 67E. What are we looking at here?
Another stab wound.
she's a lucky she's alive, huh?
Yeah.
Boy. This is a death penalty case.
67F. What are we looking at there?
It's my left cheek, and those are the 2 bite marks that he left on me.
Here's State's 67G. What are we looking at here?
It's another stab wound.
And then finally, here's Stage 67H. What are we looking at here?
Those are the 3 stab wounds to my right shoulder that I mentioned.
Ma'am, all of these photos that we see are generally, I would describe them as sort of like your shoulders and up, kind of your collarbone area and up. Is that correct?
Yes.
All of the attacks that you suffered from the knife, or I guess the bite wound too, but really the knife is what I'm interested in. Those are all to your shoulders, neck, and face. Is that correct?
Correct.
That's good for showing up modus operandi there. He's an upper body stabber, not a gut stabber.
And the key to this kind of witness is that it's very similar in a crime that was occurred eventually later
Good
on.
morning, Ms. Rogers.
Good morning.
I'd expect
was
that
a-
she's going to try to say heat of passion,
There are
alcohol
parts of this
motivated.
night that you don't remember, correct?
Yeah.
Only the reason why he came at me.
Right. You don't remember what actually started this incident, correct?
Correct.
But you have memory of everything else that you claim occurred, but not what actually caused and started this to occur.
She's got to be
correct?
careful.
Correct.
You know your blood alcohol level was .124, more than 1.5 times the legal limit that night?
I don't know the exact number, but I was drinking, so
You weren't just drinking, you were intoxicated, right?
I don't know what number.
Gotta be
makes it-
careful on
you
this
know,
kind
what
of
number
witness.
makes it me intoxicated.
You don't want to be
Very
too
careful.
aggressive.
Well,
Yeah.
I was drinking.
If .08's intoxicated legally and you're at 1.5 times that, you'd agree that's intoxicated, right?
Yes, if that's the level.
Okay. And it wasn't just beer, you were drinking shots too.
We had, one shot.
Okay. And you claimed you left the bar upset, but you weren't upset. You were ticked off, right?
No, I was upset.
Didn't you previously say you were ticked off?
I mean, upset and ticked off are pretty similar.
Okay, so now you admit you were ticked off, is that right?
I was angry, upset, frustrated. Pick a synonym.
Well, upset and ticked off are very different, wouldn't you agree?
No.
Okay, so to you, upset can mean ticked off. You were also pissed off, right?
Yes, all of those are synonyms to me.
Okay, so you admit that you left because you were angry, not just upset,
No,
correct?
I left because it was time to pick up our child.
Well, speaking of that, you actually stumbled and almost fell down at Matt's parents when you picked up your child, right?
No, that's not correct.
Didn't you previously say that you did?
No, I never said that I did.
Judge, may I approach the witness?
Oh, this is dangerous questioning here.
Yeah, you got to be
July
careful
14,
on this.
2017, page 92. Ma'am, I'm showing you your statement. Please feel free to read as much of the page as you need, but the part is highlighted.
So,
So you gotta read that to yourself and then wait for the next question.
I'm sorry.
Could you read? have-
And this is the first time she's worn a
Yes.
color other than a dark color. Now she's wearing bright pink to
Previously
question
say,
her.
Yeah, when asked, do you recall stumbling or almost falling down at their house? Did you say that, ma'am?
Yes, but that's not the latest testimony.
That's right, because you've given multiple versions of what happened. Isn't that true?
No, there was a correction to that statement in the transcript after that one. That is not the latest one.
Ma'am, there's no correction. This is taken under oath. Isn't that correct?
There was a correction to that after the hearing after that. There was a correction to correct that. So you do not have the latest one.
Ma'am, is this a transcript of the July 14, 2017 hearing at the testimony regarding child custody?
Yes, it is, but there
So
was
that's shortly after the incident occurred, correct?
correct, but there
And
was
shortly after the incident occurred,
the witness to answer the question?
and shortly after the incident occurred, you were specifically asked, do you recall stumbling or almost falling down at their house? Is that correct? Yes or no?
per that, but it's not the latest testimony.
Ma'am.
There was a correction to that statement because they didn't put it
How
down
many
correct.
times have you given various versions of what occurred?
Oh, she's looking horrible
I've
here.
testified many times and there's not been various versions.
Well, there have been actually, because sometimes you said you didn't have shots and other times you said you did. Isn't
No.
that true?
No, we've had shots.
Okay, now you say that. But do you recall previously, and now you're smiling, do you
No, I'm
recall
not.
previously indicating that you had only had beer?
We had beer and we did have a round of shots.
Okay,
Yes.
now you admit that you had shots too.
I admitted
Admit?
that the last time we spoke too.
Ma'am, that's because you talked over and over and over about this incident. Isn't that true?
I've had to.
Okay. Now, in addition to saying that, now you're saying you weren't stumbling, but right after you said that you were, you actually then drove home with your son in the car after having been out drinking all week. I'm sorry, all day, correct?
You can approach.
Wow.
This is pretty aggressive. I'll tell you, I don't know if I would go this strategy, but the defense, it's their call how hard you're going to come. I'm not sure. You know,
I think she looks horrible. I think that backfired hugely for her.
This defense attorney questioning is backfiring.
Yes. Yes.
Yeah, I wouldn't go this way, but you know, this is a defense call. They've thought it out and strategized it. So I don't know. I mean, I don't know if I would make this call, but obviously she's showing deception and you know, she's lied under oath and this sort of thing, but that doesn't really get your client anywhere. The fact is that she was stabbed, attacked viciously, and I think that the better way to go at it would be to show that the defendant was acting in a heat of passion. He was acting in a drunken state to try to get that as not only death penalty mitigators, but also as heat of passion type things rather than pre-planning first-degree murder.
Well, and she's saying that it was a transcription error and it was corrected later. So all the prosecution has to do is just show the latest version and show it was corrected, and that the one she's waving around was an incorrect transcript, and I think you're in trouble.
Maybe it depends, because there's a way to, like, if you read your depo, you can make additions to correct a transcript within the depo. So if they ask you after the end of a depo, read or waive.
Mhm.
If you read, you can add, you can change things radically, but you can say no, that you can't subtract, you can only add. So she might be saying that, but she might also be saying, no, I gave a later bit of testimony that was different, in which case that is a change in testimony,
Mhm.
which is subject to impeachment. But my question to the defense is, what does that get you? Okay, so she's wobbly, she's drunk, and she's given story. Does that justify her being attacked and stabbed multiple times in the face and neck and shoulder?
It's a no-win line of questioning, I think.
Yeah, but I mean, this is a very aggressive defense. I don't know if it gets you what you want to get from a defense side. To me, I'd be focused on the heat of passion and intoxicated state of my defendant rather than credibility issues for the defendant.
Well, Mike Morrison started us off with the big bucks.
One. Boom.
Got my popcorn ready. Has to be one of the best / most awkward witnesses versus defendant moments I can remember. Would it be in your top 5?
This is
Probably.
Good. This is a big witness.
And you witnessed me taking the shot earlier, so we're even. But you followed that up, Mike, with do you have a PayPal or some other way to send you donations so that YouTube doesn't take their percentage? Not at the moment. For some reason, PayPal is not communicating. I can send from my Korean bank account, but I can't receive from my Korean bank account. So at the moment, this is all I've got. I'm working on another PayPal account that will take care of all of that. But
well, what's going on here is that she wanted to bring up a DUI.
You then drove the infant home.
Yeah, so the defense won.
There was time in between when I left the bar and when that happened, yes.
Ma'am, the question is, did you drive the infant home?
Yes, I did.
Thank you. Now, after that, you actually asked for over $250,000 in damages for this incident, didn't you?
No.
You didn't.
No.
Can I approach?
And Judge, we should approach first so I can show it to counsel.
either she has a really bad memory or the prosecutor is the defense lawyer is way off base on a lot of questions.
Oh, no, I think the defense attorney's got all this in the bag. That's not the question. The question is whether you go there. I mean,
but how would she not know she asked for $250,000?
Exactly. Well, it's amazing what people say on the witness stand. I mean, you say how many prior felonies, and you tell your defendant it's 6. Now repeat after me: 6 prior felonies. Yes, 6 prior. And then the prosecutor gets, so how many prior felonies do you have? I don't know, 2. You're like, you just got telling them. So this is typical. That people want to paint themselves in a good light, and they're hostile. And obviously, this defense attorney's kind of got her rattled a little bit.
But she says it was such conviction. If she said she had 2 felonies, I'd believe her.
I know, but the defense, I'm going to tell you, the defense attorney's got the goods. These people are prepared.
Yeah.
Both sides. And so the witness is the one that's confused. But it doesn't, see, my problem is, as a defense attorney, it doesn't get you anything to show that she's a liar. The fact is that she got attacked and stabbed by this guy.
Yeah.
Why? Who cares? Like, you got a mouth on you.
Yeah, so some people deserve being stabbed 8 times in the face. Alan, Jeff, take my money. You deserve it. Oh, thank you so much, sir. So deeply appreciated for being one of the nicest persons that I know on the YouTube. Cheers. Oh, it's very kind of you. Thank you.
You've got some nice chatters. And Mike Morrison is very generous. That's very kind.
Yes, he is. And so, yeah, definitely. Kyle Mitchell. Lol, why does her having shots matter? That's what Steve's saying. The BAC was already stated. How she got there is irrelevant.
I will say one of the advantages of being a defense attorney, though, is people expect you to be an a-hole. So
yeah.
So if you come in there and you're like, I can't believe they're crossing this witness so hard. Well, it's like people kind of expect us to be jerks. So, and you are defending your client. So I don't know. I mean, I'm not saying that this is not improper. It's a completely proper cross of this witness. I'm just saying, from a strategy standpoint, what are you trying to achieve by being hard on this cross?
Yeah.
What you want is intoxication and invest and in heat of passion out of your client, to me.
Yeah, it's got to be a lot of heat and a lot of passion, though, to go from a drunk argument to being stabbed repeatedly in the face, your throat cut and bitten in a few places on your body.
Right.
Dennis Heaton, thank you so much for the super chat. Why should attempted murder get less time than murder? You're rewarded for failing what you intended to do. Yeah, you know.
Well, it depends on certain. A lot of this depends on the facts. And as I was teaching my crim law class, every sentence has to be individualized. And so you can foresee, like if you've got an old married couple and the wife is suffering from cancers, in pain, and begs her husband to kill her. And so he intentionally kills her as she begs because she's in pain, as a mercy killing type situation of a wife he's loved for 50 years. Okay. As opposed to some guy who stands on the corner and waits and robs you and starts stabbing you and stabs you 20 times, and you fend it off, but you live, takes your money, robs you, and takes your wallet. Well, which one should deserve the higher sentence? The attempted murder where you didn't die and stabbed by the random attack, or this mercy killing of the husband, right? So it depends on facts. So I know that people like to say those type of things, and a lot of it's jurisdictional too, and who your judge is. So things are not as clear cut as they may seem, right? When you lay it out like that.
And so here we go. Patty B Photography asked the question, how can this prior act be let in and AH's couldn't? Why isn't Amber Heard's prior bad acts not allowed in, but this one is? Steve has discoursed on this in the past, so we'll let him talk about it again.
You're playing. This is a fun trial for me because it's Florida. Well, I don't know about Amber Heard. Okay, and that's a civil case.
It was just a prior bad act.
This is under the Williams rule in Florida. Similar fact evidence.
Start over.
Certainly. Ma'am, it is true that you asked for over $250,000
She won.
as a result of this incident you described, correct?
No, that's not correct.
May I approach?
Ooh, time
Stupid.
warp.
She's like, this woman is not ready for this cross. Defense won that battle too.
Yes, I do.
You prepared that, didn't you?
When I was initially
Yes,
asked,
did you prepare that? Yes or no?
this is an initial document, and yes, I prepared this initially.
And you asked for $256,908.53, correct?
No, that's not the final document.
Ma'am, is that the number at the bottom?
Yes, but this isn't the final document.
Sure, did you end up asking for more later?
No, I didn't ask for near that.
You asked for, let's go through this, $1,506.94 to move to another apartment, right?
I was asked to supply any expenses and.
Did you ask for that?
Yes, I did.
Did you ask for additionally 11 months in rent?
Yes,
Did you ask for 12 months in utilities?
yes, I was forced to move my home. It was out of my home.
Did you ask for a storage unit?
Yes,
Did you ask for expenses for a moving truck and rental supplies?
yes, these are all costs that I had to pay due to the incident.
Ma'am, did you ask for lost wages,
Yes,
including lost vacation time that you were actually paid for?
yes,
Did you ask for a lost bonus check you claimed you were somehow due?
yeah, because I wasn't working.
Did you ask for estimated future child support?
I did, but they won't allow any of that.
Did you ask for estimated costs of future therapy that you weren't even sure you were going to have at that point?
Yes, I did.
Did you ask for money for a lawyer?
Yes,
Did you ask for transportation, gas, mileage?
absolutely.
Did you ask
This
for
is great cross,
anticipated
but it's I don't know. It's great.
Yes, for.
I like her answers though. Yes, so what?
Did you
I know,
ask
but
for
the defense
anticipated
attorney's got her
things like martial
pegged
arts
on this. I mean,
classes, self-defense
whether
Look
it
at this
should
guy
be,
smiling over here. Look at this guy smiling at this.
and it had totaled up to over $250,000.
I enjoy the
That's not
skill.
the final document.
It didn't.
But initially, yes.
You did.
Initially, that's not what the final document amount was.
Whenever you want to say you asked for more than $250,000,
I did.
right?
I did ask, yes.
That's what this is really about, isn't it?
No.
Nothing further.
That was weird. Okay.
I don't know. That's a strange choice, but it was well done
Yeah.
tactically, but strategically, was that the right way to go? But it's their case. That witness did not handle that well. That was fun.
No,
Are you going to make money from being here today?
no.
The defense keeps asking you about this $250,000 that you asked for, and you keep saying that was not the final thing. I'm just going to ask you, did you get money?
I think he was ordered to pay me, I think $13,000, of which I've only seen like 1,000
Okay.
before he was incarcerated.
So you got $1,000. That's what you got for this.
Correct.
When she keeps saying $250,000, was that $130,000 you were asking for child support for the child you shared in common?
I don't remember the amount exactly, but yes, we share a child in common.
And Judge, when there's a moment, could we approach?
Sure. Well, why don't you approach now?
When there's a moment.
Yeah.
Okay.
I'm not laughing at this witness or the situation or the murder. I'm enjoying the skill level and the tactics, and this is just a fascinating situation. This trial is really interesting, and so I'm really enjoying it. I mean, and I know that that's sort of sick, but we're watching. I'm a lawyer. I'm a Florida lawyer. This is a death penalty case. These are the best of the best in trial lawyers, and I'm enjoying seeing how these witnesses are approached, and it's just fascinating. So I mean, I don't, it's like, well, why aren't you serious? This is one of those tough things. It's out of context. So why are you laughing at that poor girl who got stabbed, right? I mean, I'm enjoying it. This is a brilliant group of attorneys, and it's a fair courtroom, and it's an interesting witness, very compelling. I mean, she is just devastating for the defense. And just how they came about it, and that defense attorney's prepared, and they made choices. I'm just enjoying this immensely, from a professional view, right?
Mm-hmm. That makes sense to me. It's you take joy in seeing artistry.
Yes, and
not in the crime.
And I don't agree. I mean, I'll just say I don't agree with this defense strategy on crossing this witness. This is not the way I would have done this. I would have treated her much more kid gloves. I would have instead sought to establish that he was completely drunk and out of his mind, and he's a violent drunk, and that he was acting out of heat of passion, not this "you're a liar." I don't think that was the right strategic way to come at her. But I don't know the whole case, and they have a strategy, and they've maybe gamed it out. So, but anyways, so if you hate me, you hate me, right? But I'm just being myself, and I'm trying to add some commentary and some insight here.
Nobody hates Steve. Steve's our fave.
Oh, these little ticky-tacky criticisms get sensitive to us, like, the negative stuff always gets more, in the chat here. You've got a great chat, so I want to make sure I'm adding.
I'm going to ask you to step out for just a moment.
Ooh. There's going to be some serious arguments now.
It'll just be a moment, so all rise for this.
All right, and while the jury's going, we can clear out a few more of these. Love you, Jeff and Steve, says Ember Fox. Great stream today. Did she bring her own lawyers? I don't know if she did, but I would if I was her. It's always a smart thing to have a lawyer when you're going to court.
Maybe.
I mean, I don't know why I don't know why I wouldn't if I was in her shoes.
Everyone may be seated.
I don't know if a lawyer would be necessary.
Come to my attention. I did not hear it, but the defense said that you said it, and the court reporter confirmed that you said it, that Mr. Terry was incarcerated. And it's my understanding that you have been instructed not to say anything about that, about court proceedings, jail, conviction, incarceration, or anything like that. So at this time, I am going to instruct you again.
I didn't catch that.
I didn't catch it either.
Please do not, actually I'm going to take the please out of it, just do not say anything about any court proceedings, about any conviction, about any jail time, about any prison time, about any sentence. Do you understand that?
I do, but can I clarify?
Certainly.
So when I said incarceration, I was talking about his current incarceration, not a previous incarceration. It wasn't referring to the previous.
It doesn't matter.
Okay.
So now that we have that clarity, that no incarceration.
Okay.
Are you able to abide by that?
Yes.
Okay, I appreciate that.
And now the defense lawyer is going to egg her on to try to get her to say it again.
Well,
all right, let's get the jury.
Maybe they know that she's rattled easily, and they're looking for mistrial stuff. I don't know. That's interesting.
Wow. Yeah.
I didn't catch that when it went through.
I didn't either.
Yeah.
Says, why is he even out of prison? Asked Vince Clortho. Attempted murder, 2015. He wasn't charged with attempted murder. He was prosecuted for what was it? What do they call that?
Aggravated battery.
Grievous attempted grievous bodily harm or something like that.
Well, that would be from what I saw. That would be an ag battery, first degree felony, deadly weapon plus great bodily harm. So that would be a first degree felony. I think somebody in the chat said he pled to an attempted ag assault, deadly weapon, which is a third degree felony. So that's a sweet deal for him.
The prosecutor said we went to trial on assault with intent to commit murder, and the jury convicted only for great bodily harm. So they gave her a lesser included, I guess.
Well, see, the defense may know that she's a squirrely witness.
If there's 5 in line for the bathroom, let's just take a break. Let's take a 15-minute break. Yeah. All right. So let them know that we're in break. We'll bring them back in when we finish our break. But we are going to take a 15-minute break. Ms. Rogers, I'll let you step down to enjoy the break. Please do not discuss your testimony with anybody. What we'll do when we decide to reconvene after the break is put you back in the witness stand and then bring the jury back in. So we'll be in recess for 15 minutes, except that, Ms. Brad, you can step down, ma'am. We're on break from testimony. Someone indicated that there was some stuff that we needed to discuss, and that was going to be the need for a break.
All right. Well, we got 15 minutes.
We're going to take after this witness.
No, we'll try to do it now. We may need more time after, but we'll try to handle it now.
Oh, it's okay. You all just wanted to. You didn't want to discuss stuff with the court.
No.
Perfect.
No,
All right. All right. We'll be in recess for about 15 minutes. Thank you all.
Judge is great. I like this judge a whole lot. This is one of the best judges I've seen in a public type trial.
Yeah, in the last trial that was streamed with him was fantastic as well. I mean,
very controlled. The way he instructed that witness, very strong, very assertive. No wishy-washiness at all. Great.
So as I was saying, that's they said that he was charged. He went on trial on assault with intent to commit murder, and the jury convicted only for great bodily harm. Nevertheless, I believe it's fair to consider all the evidence and conduct while he is under supervision. This is a deal with they were trying to redo his parole. They wanted stricter supervision, and the court rejected it. He served 3 years in jail and then 1 year out before they took him off his papers. And then he went to Florida and stabbed this lady five months later.
Wow.
But the interesting thing is, I don't know if you were aware of this. I talked about it in one of the earlier streams. I can't remember if it was one where you were there or not. But the deceased woman in this case went as a character witness for him in the Michigan trial.
Yeah,
they knew each other. They knew each other before he ran off with his other girl that got stabbed. And then when they reconnected while he was in jail awaiting trial.
Amazing. Well, it's amazing how often that happens.
Yeah.
I mean,
this woman here says that she tried to tell her, don't let this happen to you. But she said during the whole trial, she just sat there and glared at her and gave her the stink eye.
This defense, they may know something that we don't about this particular witness, right? And they may be trying to get her to respond. Somebody asked, and I think there's a super chat coming up that's a cheap one, but a good one, which is that any is good. Any super chat is good, right?
Yep.
About what was it? Well, why don't you bring it up and we'll deal with it then.
All right, let's go down the list of super chats here. Nathan Lai, problem is questions coming out like, so you made him stab you almost fatally so you could ask for $250,000. I just thought she was way overly aggressive.
Well, again, defense attorneys do get a pass for being jerks, right? And and they're looking for something. I mean, they have thought this out. I don't know. I would not do that. I don't think that's helpful to the defense. I don't know what the purpose. It's not like she didn't get stabbed, right? Oh, you missed it. You were asking to get stabbed. I mean, that kind of attack, it's not easily explained, right?
Yeah.
So I'm not agreeing with the strategy. I'm impressed with the tactics and the skill level at which that defense attorney executed the the impeachment of her, because that may be why he pled down, or the jury came back, because she was a squirrely victim. She doesn't remember. She was drunk. She changes her testimony. She's, that. So that may be right. So what we got next here?
Jason Gilman Jr. How would a mistrial benefit the defense?
That's the one.
Yeah.
Because they're asking for death. The state wants death. And so if they win, if they get a guilt, and then they're going to go and they'll say, so you want to blow this trial up and make the state work and work and work until they surrender and say, how about if we just let him plead a life? Okay, plead a life. Boom, you win. See, it's you are not, you give everything you've got, every mistrial, every bit of sand, maximum due process, right? And so you blow the trial up, the state just may surrender. This is a complicated trial to conduct. I mean, there's a lot of witnesses, a lot of moving parts, a lot of expense to the state. So if you can blow this up, make them do it again, you might beat them down. They might offer you life. I mean, I've had cases, death cases. I've seen multiple death cases where a defense attorney gets up there and they got their client and they say, yeah, judge, we're willing to plead right now. We'll take life in prison right now, but the state won't offer it. State wants death. And, that's what happens.
Elaine says 2012 Jameson. Elaine would blame victims for not having Amica cream.
What's that?
It's a good Johnny Depp reference. That was one that Amber Heard was saying she was using this Amica cream to hide broken noses hours after it happened and bruises on her cheeks hours after it happened. And it's insane Johnny Depp stuff.
I missed the whole Johnny Depp thing. It's civil. I don't think civil.
VFM number 0035. Thank you so much. This is not a great cross. It may get him death.
Well, I don't know. I don't know if it really hurts the defense anymore. I just think that you could help him. You could help your client by going for the intoxication, heat of passion stuff, because that's mitigation in the sentencing phase. So that's that. But I don't know. That's just what I'm here thinking.
Well, Ember Fox also asked again, actually asked this before the super chat. Legal Vice, did she bring her own lawyers? I had it flagged, but I didn't get a chance to read it before you sent the super chat asking the same thing. I'm sorry you had to send the super chat, but this was already flagged. I don't know if she did or not, but it's just me. If I was ever testifying anywhere, I'd have at least some lawyer with me. It's just maybe I'm being overly lawyerly. If you were going to give testimony anywhere, would you have a lawyer with you, or would you just go, it's not necessary?
I've never, it's amazing, but I have never really seen a witness in a criminal case like this ever bring a lawyer. I don't think it's, because I don't really know the consequence. Why? I mean, I don't really understand what the danger would be to having. I mean, I guess you could have a lawyer, but you're not getting accused of a crime. And, the state's not going to bring a perjury charge against you or anything. So I don't know.
Yeah, I don't know either. Maybe it's just me being the lawyer. Just don't do anything without a lawyer.
Right.
It can't.
And I don't, as a lawyer, pay lawyers for everything. Right. I mean,
whether it can help, probably not. Whether it will hurt, no. So I would just tend to err on the side of caution. Pope Rackets touched me, said, at Legal Vices, could you please ask Stephen if he can give his opinion on the motion to use the defense not answering questions to the doctor in the ER's Fifth Amendment? Did you see any of that?
I'm missing this. Explain.
Yeah, there was the two motions. One was the Williams, and the other was they brought him into the ER. And the doctor saying, well, we have to find out what happened. So they said, what happened to you? And he refused to answer because the police were standing about 15 feet away.
Now, that was not allowed in, right?
That was not allowed in.
Yes, well, that's proper. Okay.
There was a big argument about, is that the state isn't asking him whether or not, what happened. But the defense was obviously arguing, well, the state can still hear it.
Right.
And so there was a big back and forth.
Okay, well, this is an interesting question because the majority rule in the United States is that type of silence can be used against you. Okay, but in Florida there is a special rule. It's based on state constitutional principles, and our right to remain silent is more broad than the rest of the country. I don't know if other states may be more broad, probably so, but in Florida, they're very, very careful about pre-arrest silence being used as indica of guilt. So that is, again, a good move for the judge because they don't need it. And why the state needs to be less aggressive here. They need to be proving less. But generally, what I'm saying is the Florida rule, answer to the direct question, the Florida rule is that pre-arrest silence is generally not usable against a client or defendant. And that's different from most of the country, which I like the Florida rule. I like that because I don't think that's proper. And the state doesn't need it. I mean, come on, they've already got him dead to rights.
Well, that was the argument the state was using was, but he was handcuffed to the bed.
Well, okay. Here's the if you really want to analyze the Miranda implications, Miranda, you have to be in custody and subject to questioning, right? So he was in custody, but he was not being interrogated by a state actor. All right. So you have a state actor. Is the doctor a state actor? But placing somebody in a situation where the state is nominally observing and creating a situation which would compel an answer such as this, I think would qualify under Miranda and would be a Miranda violation. And why? I mean, the judge is smart. Why create error on a case that's going to go down, right? I mean, why would you do that on a death case? I don't know. And I kind of question why the state would even want to get that in. That's overly aggressive state. They've done this. So let's review. If I'm going to criticize, and I think all these parties, the judge is great, prosecutors are great, defense attorney is great. This is a very clean trial, good one. State was too aggressive. They shouldn't have been asking for that. They shouldn't have asked, and they shouldn't have brought in the bloodstain expert. She was boring and useless. And I don't agree with this defense cross, the way they crossed her. I think they could have done it differently. They should have been going for an alcohol. Those would be my three criticisms. Other than that, I may be wrong. That's just an opinion. It's their case, right?
Well, I think everybody would agree with you. Nobody had fun the last 3 hours of yesterday except us.
And we were talking over the witnesses, but that was a terrible witness.
I only got one comment on that. One of those, please stop talking over the witnesses. Only one, and with 1,000 people plus viewing at any moment over a 3-hour period. So everyone else was having much more fun listening to us talk and keeping them entertained while they waited to see if something happened. So I think we did a good job.
Okay. Oh, that's cool. Well,
Atomic Squid says, listening to the X, this guy definitely belongs in a cage.
Well, he's a violent drunk.
Yeah.
And this is the thing. Drugs and alcohol have different effects on people. He may be a complete gentleman when he's not drinking, but a ridiculous, violent, psychopathic murderer when he's drunk. So obviously both of these instances are alcohol related. So, if you're that way, you should know enough not to drink, right? I don't understand. It's like, okay, I could kill if I'm drunk, so no alcohol for me, right? I get sleepy and happy when I drink. But if you know about that yourself, why are you going out and drinking? Oh, I wanted to bring this up. Speaking of which, I'm doing my little book here.
Oh, yeah. Okay.
Which is West Florida Criminal Laws and Rules, 2020. The old version goes home, the new version's it. But jury instruction in Florida 3.6D, voluntary intoxication. Okay. New rule as of 1999. Voluntary intoxication resulting from the use of alcohol is not a defense to crime. Evidence of defendant's voluntary intoxication may not be taken into consideration to show that he lacked specific intent to commit a crime.
So there's no diminished capacity for being drunk.
Right. Now, that being said, it is a mitigator for a death sentence.
Okay.
So you can bring up anything's a mitigator. Okay. He behaved well at trial at the defense trial. That is a mitigator. All right. So anything can be considered mitigator, but it's not a defense to the crime that he's charged that he's drunk. All right. In Florida.
Okay. That makes sense. That's interesting. Okay.
I think there may even be a constitutional problem with that. I've not had the case to test it and look at that specifically, but I'm not certain. That's a legislative action because they'd say, well, people are getting away with murder because they're really drunk and so the legislature passed this. And there may be constitutional. I haven't looked at it, but my little ringer says there's something about negating specific intent through voluntary intox that might make it constitutional. But anyway, this thinking.
Ember Fox says potassium chloride is used in lethal injection. Why on earth do they put it in Dasani water bottles?
Do they?
I guess, apparently.
Never heard of that, but I'm sure it's not enough to kill.
Sure. Wow. Okay. Potassium and chlorine. I don't know. Maybe it's part of a purifier thing. I don't know. Oh. This is ask a lawyer, not ask a chemist.
Yeah, I have no clue. Well, chlorine gas is a poison, but they put chlorine in water. So, I mean, to purify, and you swim in that in the pool, right?
Public execution, yes or no? Not a deterrent.
No. Well, you know my position on the death penalty, but I don't believe it's a deterrent. I mean, hell, people kill in prison to get on death row.
Yeah,
because you don't have a roommate in death row. You know, I've told you about that, about trading your roommate for a television set.
Yeah. We currently have 723 viewers and 525 likes. That is a super good ratio, but we can always do better. So I'd appreciate it on this little break here we're taking if you would reach down there and just kind of hit that like button. And we're trying to get up to 32,300 subscribers. I'm not sure where we are. I got to check the phone to see where we are in subscribers. We need 24 more subscribers. 24 more subscribers today. If you haven't subscribed, if you're one of the 24, I'm sure there's more than 24, but if you haven't, go down and hit the subscribe button. This is what we do. We do trials, we do law-related things, and I make every possible use I possibly can of having Steve on here so that he can talk, and it makes me look like I'm smart because I have smart guests on.
Well, I just try to come on things that I might actually have something to add, you know. I guess I do have I want to tell you, can I tell you about the book?
Yeah. Oh, please tell us about the book.
Well, I'm out of my first editions. All right.
I've got one right here.
Yeah, there you go. That's the first edition. Okay. But I'm reordering the book right now. So I should, by next Monday, you can pre-order the second edition, which I've done a couple things. Number one, I've added a chapter on prosecutorial misconduct and closing arguments, which I left out of the first edition because I thought it was too Florida specific. But then when I look back and everybody loves this stuff, that I'm like, well, I'm going to throw it in too, because then it'll be a complete compendium. I'm planning on sending by email everybody who bought the first edition that chapter, so that way they don't get rot. I know that the Griftmeister would hate me for that, but you're here. I'm happy that people are reading my stuff. Number two is I have upgraded everything about the book. So I made the cover a little better. I think the cover's nicer. I've upgraded the cover to like a foil cover. It's really fancy. I've upgraded the quality of the paper in the thing. It's
I didn't get the leather bound one.
Right. So the paper is better. So it'll be more complete paper. And so the second edition, it may not be the collectible first edition, but who knows how many books. My question to you is, how many of these books am I really going to sell? Because it's such a specialized thing. I mean, how many, the people have been great, and I've sold, I think, 300 books, which is something. But wow. Yeah, but I don't know how deep the market is, because because every time I order 100 books, I think this will be the last, all of a sudden I'll have 100 books sitting on my shelf that won't be able to sell, right? And then my wife will get mad because I've spent all this money on these books and they're just sitting on the shelf taking up space, So I don't know. I mean, it seems like last time I won, last time I was on like this show here, people bought 14 books.
Wow.
So thank you, Mr. Vices.
Well, you're welcome. It's the least I can do to repay you for making me look like I have an intelligent stream.
No, I love I really enjoy being on with you. You have a great mind. You've got a great sense of humor. You've got an interesting practice. I mean, this maritime law stuff is great. I think it's fascinating because it's so obscure, but it's cool. You make what I really love that you do is these Monday, cannibal cases,
Yeah, that's one of those things. It's an accepted practice to eat people if you happen to be in a shipwreck. If you just
It's interesting. It's fascinating. That was a great case, and So, anyways, I really do appreciate you, and so it's an honor to be on with you. Okay, enough schmoozing.
Well, thanks. And we also did the case that sort of became the precedent for, yes, it's acceptable to eat someone in extremis, but you can't help them along to death. You can't murder someone to eat them to stay alive.
See, I know that now. So
Yeah.
when they die of natural causes, I can eat them.
Pretty much. Oh, shoot. And you also have your Rumble page.
Oh, right. Which is really just fun. But I post all kinds of stuff, religion. I post on music, and I've summarized all the chapters in the book. The one thing, also, I'm going to have to leave at 11 because Megan Fox is going to have me on her show.
Cool.
And so that's kind of cool. Megan's great. Do you know Megan?
Yeah, I do.
Yeah, she's brilliant. So,
so that'll be on Locals or Rumble?
Well, she got kicked off of YouTube.
Yeah, so it's not on YouTube. We know that.
What is that? What is going on? YouTube is insane. I mean, these people, she's just commenting and giving her opinion on political issues. That is the highest protected form of speech, is political speech.
Yeah.
And they're censoring people because they don't like what she's saying. Sad.
Yeah, and she's actually bringing up stalkers and their prior criminal records, and that's what gets her booted, because she's saying bad things about people that do horrible things. But
it's weird.
Yeah, whatever. Yeah.
Weird. I don't know. I don't get it. I don't like censorship. I mean, come on. Anyway,
we still got 45 minutes, but when you go over there, make sure you tell her hi.
Gotcha.
All right. Looks like we are back up. She's on the stand and people are staring at each other. So wait, well, how do you get over there? Get back over there. Here you go.
And thank you to the chatters. Most of them are very nice. Occasionally they pick on me.
Legal advice: should I unsub and resub, or does that not count? Yeah, that doesn't really help at all. That's not how any of that works.
See, as a witness, though, she should just answer. Just give the defense what they want. I mean, she did ask for $250,000. It's not the end of the world, right?
See, with that one, I mean, like I said, it just turned out to be her trying to outsmart the lawyers. Did you ask for $250,000? No, I asked for $250,004, which isn't $250,000.
Well, she's trying to say, well, that's not what I got, and that's not what I ended up asking. This seems to be her modus operandi, also, right?
Yeah.
But the fact is that she started out with that, and she's like, she answered the depo in a way. She later changes it, but just go with it. I mean, it doesn't hurt her as a witness. She's not only, I mean, it's being on the stand like that is pressure, and people are not trained in this kind of conflict, in this kind of situation. So I guess it's just human beings and we're flawed, right?
Yeah. Boomer, what does that have to do with anything? There's no, was that because I brought him up on the wrong side of the stream? I don't know. Weird. Now remember this, we started this break with them trying to figure out what all of this error in transcript thing was all about. So, and the judge still hasn't ruled on that, has he? Yeah, he hasn't said what the deal is. They said they wanted to approach, and then they had to talk about something outside the jury. Then they decided to take a break. So I guess we'll have to see how that turns out.
We've been talking about so much stuff, I've kind of lost the train. Maybe somebody.
Yeah, that was the last line of questioning was about the apparent. There we go. About the apparent discrepancy in the transcript and the corrected transcript. That's where we left off.
All members of the jury are present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. I know I said it would be brief, but Deputy Estea told me you all were asking about a break. So rather than bring you right back in and then send you back out for a break, we decided to just take the break then. So we'll probably go up until the lunch break from this point forward. But we are going to pick up where we left off. Mr. Diaz, you may continue.
Ma'am, when we left off, we were talking about the money that you asked for. I think we covered that, so I just want to ask you, you were asked about your level of intoxication, and obviously the number, I guess, that you tested for was higher than what would be in the state of Florida, 0.08. That's the level of intoxication in Florida. You understand that?
Yes.
Okay. Even given that you were intoxicated, were you attacking Mr. Terry, that he had to go arm himself with a knife and then defend himself with a knife?
No.
Were you in a fighting position when Mr. Terry stabbed you in the neck with a knife?
No.
Were you chasing him, or was he chasing you when you were trying to flee from the home?
Good
He was
redirect.
chasing me.
Was he the one that was stabbing you with a knife?
Yes.
Did you ever stab him with a knife?
No.
How many questions, Your Honor? Thank you.
See, that's why I don't. That's why you don't do what she did. See, I.
Yep.
All right, so she can step outside defense. Do you need her to keep around?
This is going to be the last witness.
All right, ma'am, you
State's
can
going to
step
rest.
down.
They're going to do a
You're
JOA.
released for today.
No, the next witness apparently is the investigating officer
Please call your next witness.
Really?
in Michigan. Yeah.
Matthew Krumbach.
Yeah, the Michigan
Krumbach. K-R-U-M-B-A.
Krumbach, the Michigan officer that investigated the Michigan stabbing.
You see, this is why I didn't like that. I didn't like the strategy of the way she attacked her because that is that rehabilitation wipes out anything you got, right?
Yeah.
I
Well,
don't
yesterday
know.
we talked about how they couldn't make the previous bad act a central part of the
Detective
trial.
Krumbach, good morning
Maybe
and
that's why they're
welcome, sir.
bringing this guy in as the
You'll
last
come forward to be
witness.
sworn in. Before
Maybe.
you're sworn, I do have a
Maybe.
brief instruction that I need to read to the jury. Ladies and gentlemen of the jury, I'm
He
going to
looks
read you
all
the
cop.
instruction again. The evidence that you are about to receive concerning other crimes.
How many
wrongs, or
books do we
acts
need to buy to
allegedly
get the
committed
wine
by the
bottle out?
defendant Will be considered by you for the limited purpose.
I don't know.
of
Give me a
proving
number.
intent,
I'm only here for
identity or
30
the
more
absence
minutes.
of mistake or accident, and you shall consider it only as it
I am
relates
signing
to
all the
those
books at this
issues.
point, yes.
However, the
Right now.
defendant is not on trial for a crime.
Thank you.
wrong,
Thank you very
or
much,
act
ex-Cobra
that is
CZ.
not
What is the
included
picture?
in the
Did you see that?
That's mine.
Detective
That's me wearing a tinfoil
Each
hat.
affirmative testimony you give in this proceeding will be the truth, the whole truth.
I have sent books internationally,
Thank you.
but the way I do that is you order it and then you have to donate the difference in
Go ahead, have a seat, make yourself
shipping
comfortable. That
costs, and I
microphone
can
in front
send
of
it
you is fully
abroad.
adjusted. Thank you, sir. You let me know when you're ready, and then I'm going to allow the attorneys an opportunity to ask you some questions.
Doogie Howser there doesn't look
You
happy.
may proceed, Mr. Diaz.
Thank you. Sir, if you would, please introduce yourself to the jury.
Hello, I'm Matt Krumbach.
Jesus.
I am a retired detective with the City of Lansing Police Department.
And what
I don't
would you
know. Is he a
cover?
cop?
I currently work for the Michigan Commission on Law Enforcement Standards, which is the licensing and regulatory agency for all police agencies and police academies in the state of Michigan.
I'm a cop. How about you? Are you a cop?
When did you
I
retire?
talk my cop
I
voice.
retired 1.5 years ago.
And when you retired, then somewhere around 2020, how many years did you have on the force?
I had 25 years.
During the course of your
Wow.
25 years on the force, did you ever serve as a detective?
Yes, sir, I did.
Specifically, did you ever serve as a detective working in what is called a homicide unit or murder investigation unit or major crimes unit, something like that?
Yes, sir, I did.
How long were you in that unit?
8 years.
During the time that you were in, I'm gonna call it the homicide unit, when you were in the homicide unit with Lansing PD, were you the detective who was assigned to a case involving a victim named
That's a hell of a
Michelle
voice.
Rogers and a suspect named Matthew Terry?
Yes, sir, I was.
And do you see Matthew Terry here in the courtroom?
Yes, I do.
Could you please point to him and describe the clothing that he's wearing so we know who it is you're talking about?
He's a subject sitting in the middle. He's wearing dark framed glasses and a blue tie and a white shirt.
Your Honor, that's the record reflects to identify the defendant.
The record shall show his left.
All right, so this investigation, is this
But is he
tied
wearing
to
corduroy?
March 17th of 2017?
Yes, sir, it is.
And
He's a public
specifically
servant,
for
give him a
residents
break.
at 626 Worthington Drive in Lansing, Michigan.
Yes, sir.
You were not one of the first responding officers, correct?
No, sir, I was.
This is
But
why
at
you
some
end on
point,
this
did you
guy.
become
He
the
is
lead
all
detective on the
credibility.
case?
Yes.
As the lead detective on the case, did you respond to the scene?
Yes, sir, I did.
And did you have a chance to walk the scene as it was at 626 Worthington and at the neighbor's house across the street in the front yard area?
Yes, sir, I did.
Detective, I'm going to show you what's been pre-marked as State's Exhibits 68A and B. Do you recognize these photos?
Yes, sir, I do.
And do these photos fairly and accurately depict a portion of the scene as it was at 626 Worthington and across the street at the neighbor's house?
Yes, sir.
Your Honor, I'd move into evidence State's Exhibit number 68A and B.
Other than previously discussed, any additional objections at this time?
Not other than previously discussed.
All right, they will be admitted.
All right, so Detective, I want to first talk with you about the interior of 626 Worthington. Did you have a chance to go inside the house?
Yes, sir, I did.
I don't need to get into all the gory details, but just as a general question, did you see signs of struggle actually inside the residence in the areas of like the kitchen and near the areas of the living room?
Yes, sir, I did.
Did you see signs of struggle in the residence in the door that would go from the kitchen area into the garage and in the area of where the garage door opener would be?
Yes, sir, I did.
Did you see signs of struggle in the area of right where the garage door opens and sort of would connect with the ground between the inside of the garage and the outside of the garage?
Yes, sir, I did.
And did you see further signs of struggle that then would have spilled out onto the driveway of 626 Worthington?
Yes, sir.
Did all of those appear to be an indication of a moving attack through the residence and eventually out of the residence?
Yes, sir.
I want to specifically draw your attention to 68B. Do you recognize what this is?
Yes, sir, I do.
And did you personally see this?
Yes, sir, I did.
As part of this investigation, were you under the belief, or at least working from the theory, that a weapon had been used?
Yes, sir.
Specifically a knife?
Yes, sir.
Did you take the time to go and inspect this knife block in the house?
I did.
And I'm going to zoom in so we can see it a little better. It's a little hard to see, but there appears to be spots in the knife block where knives are missing. Did you observe that yourself?
Yes, sir, I did.
Were there 2 knives missing from the knife block?
There were.
Was there a knife found in the yard across the street at the neighbor's house?
Yes, sir.
Did that knife match these same knives that are black handled with these sort of silver or chrome tips at the end?
They are, sir.
I'm going to show you State's Exhibit A, 68A. Is this the knife that was recovered from the neighbor's house?
Yes.
Wow.
And is this knife consistent in appearance with the knives that we just saw in State 68B
Devastating.
that had at least 1 or 2 knives missing from the block?
It is, sir.
This is the knife in the prior Williams rule case.
Is this the area where Michelle
Which also
Rogers
seems
was
to be a
ultimately
paring
found by
knife.
first responding officers when they came to render aid?
Yes, sir.
I may have other questions, Your Honor. I'll pass the witness.
Boy, this is
They're
why you
wrapping
end
up.
on him. Good witness for the state. That was
The
smart.
last thing they see is the knife in the dirt.
Right.
And they're going to conflate that with the knife in this case.
Well, not just that, but the fact is that he's accused of taking a knife from the kitchen in this case. So it's similar, right?
Yeah.
Get
And the same
drunk,
knife, apparently, yeah.
drunk, grab a knife from the kitchen, stab your girlfriend. Why not?
Yeah. Yeah. it's just- damned. He did use kitchen knives the other, and apparently they were both paring knives, because that was a paring knife, and this one is allegedly a paring knife as well.
And you end on this guy because he's so strong.
Yeah.
3 more books and I'll drink a bottle of wine, but it's got to be in the next 15 to 20 minutes because I've got.
I think we should read this super chat in officer voice. How many books do we need to buy to get the wine bottle out?
I just had to do that.
All right. That was pretty
I want to
cool.
be a Michigan police officer. Do you sign all the books? Yes. He said he signed all the books still. And
Foil-
Flux.
tinfoil hat.
That was for one of our unexplained alien streams we did one day. Flux. She says legal vices talk about how Utah was the most recent state to use the firing squad. Yeah, that was Ronnie Lee Gardner in what year? What year was Ronnie Lee Gardner? I want to say 2010.
I don't know.
But yeah, that's actually a very interesting case. Yeah, it was 2010. He murdered somebody in 1985, went to jail, and then in 84, he was trying to escape. They were moving him into the courthouse in Salt Lake City courthouse to.
Whoop. Did we lose our host? He's frozen in time. Or is it just me? You're frozen. Wake up. Time stop.
Oh, wow. What happened?
Oh, there you are. You're back.
Hi. Where did I leave?
You were there.
Oh.
In that frame.
Oh, what was the last thing you heard from me?
I don't know. What are you saying? You're
Well,
back.
we'll go back to this. Ronnie Lee Gardner was the last person that was executed by firing squad in Utah. 2010, 1985, he killed some people. And then in 2009-ish, I believe, I can't remember exactly when it happened. They were moving him into the courthouse, and he tried to escape. And he ran out of the courthouse, somehow got a gun, and shot a lawyer who just happened to be walking by to death in his escape attempt. And then they shot him, executed him. And since Gary Gilmore was executed by firing squad in 1976, there's only been three executions by firing squad, and they were all in Utah. Gary Gilmore, Ronnie Lee Gardner, and another guy in the 90s. I can't remember who he was.
People are asking about me playing bass. You can see me play a lot of stuff back on my Rumble channel. So which is Crime Law with Stephen N. Gosney, only on Rumble. No YouTube for me. So I said a bad word.
I wonder what they're talking about here.
I don't know. He's got the headphones. Another thing I love about this courtroom is the fact they're giving the defendant access, because I always feel a little bad approaching and talking law and stuff without the defendant, because to me, it's his case, right?
Yeah, and I've never seen this before ever. I think it looks pretty cool.
But it's great. Yeah. Okay. So I got. Let's see.
But people's big objection to this is he's wearing his earphones like a tool.
Well, he is a tool.
Yeah. That's
but
true.
But like I said, it may just be he's a violent drunk. I don't know what he's like outside that. I mean, obviously he's got these girlfriends, right? Hey, baby, want to go get drunk and have a stabbing party?
And why don't I have a girlfriend? He stabbed 2 people. What's wrong with me?
He wouldn't stab me if he didn't care me so much, you see.
See, this is what everybody thinks of you. Oh,
Brittany,
Steve is so friggin' cute.
I don't know what.
Everybody loves you.
Why didn't I get this attention when I was like in high school and was? Oh my goodness.
Officer Happy's back on the stand here.
This officer's great. I don't know how you cross him. I mean,
he's scaring me, and I haven't done anything wrong, and I'm on the other side of the planet from him, and he's making me nervous.
But see, this is why they're close. I thought she'd close with the stabby girl, but see, she's a little squirrely, and they never know what they're going to get with her. But this guy, you know exactly what you're going to get.
Yeah.
And you know that you paint that crime scene with that knife photo. You end with that. Boy, that's killer. Good prosecution strategy there.
Yeah, it was a great last image to show.
So I think the state thinks going to rest on this guy probably. The only misstep is that bloodstain expert. She was terrible.
Well,
no
DNA
purpose.
woman, I still don't think was any better because
yeah, but there was
those numbers. They didn't explain why they were important.
Yes, but it's meat and potatoes. I mean, the DNA person was great. That is killer evidence for the
if you understood it.
But they'll explain it in closing. So you got it in evidence, and they'll be able to explain it in closing. So I'm going to post a Rumble link to my Rumble channel, so you can all watch me play Iron Maiden.
Yeah, Rose has been Maud Rose has been doing that.
Rose is nice. I thought Shane is usually up there. We're done with the sidebar.
All right. Let's see what happens. And if those of you that were watching yesterday, the defense may rest today if it gets that far.
Defense may.
Yeah, because that was the last thing the judge said. So be prepared, in case if it needs to go to the jury. He said something like that.
Well, I don't know what's going to be the defense evidence. I mean, who are you going to put on as mitigators? I don't really know what the defense. They may just rest without putting on any evidence. And then
they have to put some sort of DNA person on, don't they? Or do you think they've done enough they can just explain it?
I don't know. I don't think so. I think you may just put on no evidence and save all your ammo for the penalty phase.
That is kind of where I've been leaning since about day 3. I guess until they brought up all the blood stains yesterday. It was just stand up and say, nothing. We got nothing. Just well, I mean, don't say we got nothing. Just
unless they had some sort of rabbit in the hat of like the third killer. They saw a guy running. Somebody called 911, and there was a guy running away with a knife, screaming at the moon. You know, wouldn't that be cool?
By the state?
Oh, so no questions.
Okay. All right. You may step down at this time, Detective.
Whoa, your mic's hot.
You're welcome.
Law and crime. Is that really loud to you, Steve, or just me?
Ladies and gentlemen of the jury, the state having rested their case, there's some things that I need to talk to the attorneys about, so I'm going to send you out before we turn to the defense. I'm not sure how long this break is going to last. If I determine that the break is going to last a lengthy period of time, I'm going to go ahead and give you a early lunch, but a long lunch. I'm just not sure, and I'm going to go ahead and send you out for purposes of me discussing that. So please do not discuss the case amongst yourselves or with anyone else. Please do not do any research related to the case. All rise for the jury.
All right, this is where the fun begins.
Well, this is a great trial. I'm really glad you're covering this because so now we're going to get a JOA, which is going to get denied, and then you go into jury instructions, which is pretty standard in Florida. It's pretty tight. I don't know. Be interesting about the voluntary intoxication instruction, whether there's any challenge to that constitutionally.
Well, we're at the point where the state has rested, so I suspect that the defense wants to be heard. But before we, I mean, right?
Yes, of course.
Okay. Before we do that, though.
Nah, we're good.
Judge, just in regard, before we get to that part.
Okay.
Just in regard to Detective Kronbach's testimony, I just want to make a proffer of what we would have asked him had the court allowed me to inquire without opening the door to the defendant's convictions.
Excellent. Brilliant. These lawyers are really good.
This is for appeal?
Yes. So the judge shut her down.
Mr. Terry actually gave his version of what occurred that night. You're aware that what he said was that Michelle Rogers smacked him across the face twice. She punched him, and they ended up on the ground wrestling, correct? I would have then asked him. He also indicated that Michelle had a knife in her hand and started swinging at him from 2 to 3 feet away. I would have also asked, Matthew Terry testified that she had to be taken to the ground. He kept telling her to put the knife down, and that he rolled off of her once she stopped struggling with him. I would have also asked Detective Kronbach that Matthew Terry had said that Michelle had the knife in her hand and tried to stab him from 2 to 3 feet away, which is what caused him to have to grab her wrist. He pushed Michelle Rogers away and said that when he couldn't see the knife, he let Michelle get up. Isn't that correct? I would have further asked Detective Kronbach that Matthew Terry said that he saw that she still had the knife in her hand, which is when he had to grab her wrist and her hair because he couldn't grab a hold of her shoulder, and that he was trying to knock the knife out of her hand, correct? I would have further asked Detective Kronbach.
Would those questions be let in just because he was the investigating officer and it was part of his investigation?
Well, I'll stress this. I want to hear what's going on. Let's see. This is cool.
Isn't that correct? I would have also asked that he heard Matthew Terry indicate that the stabbings occurred as Michelle was pushing the knife towards him and he was pushing it back, which is why she ended up getting stabbed in her shoulder 3 times. Isn't that correct?
Interesting.
Because of the ruling, obviously.
Well, and I want to make it clear that I did not rule. The state was objecting to those questions as hearsay, and I had not yet made that ruling, but I did rule that if we got past the hearsay issue and I allowed those questions to elicit that testimony, that would open the door to Mr. Terry's prior conviction in that case. So I did make a ruling on that. It's my understanding that as a result of that ruling, the opening door to the prior conviction, you decided not to ask those questions and not to seek a ruling from me on whether it was hearsay or not.
Correct, Your Honor.
Okay.
Perfect.
All right, so
brilliant.
That's on the record.
Perfect.
So
Some
let's
chess
talk
playing
just
going
now
on there.
about what I'm going
Yes.
to do with this jury, whether we should hang on to them for a little bit of time. I know that we have JOA arguments that you would like to make. Then after that, depending on how I rule, not prejudging, but we have to all the different. I mean, obviously, If I was to grant, or if I was to reduce it to a lesser offense, we would still be going. So, what I want to know is there any other witnesses besides the possibility of Mr. Terry testifying?
No.
All right.
Okay. He's not testifying because she already made the decision not to cross because she didn't want to open the door, so he's not testifying.
Yeah. Whether he wants to testify, because I think we need to do the JOA.
So it could go to the jury today.
It'll go to the jury after lunch.
Somewhere private
Yep.
for maybe 10 minutes before we can
Wow.
give you that answer.
Closing arguments
How long
this
do you
afternoon.
anticipate the JOA arguments?
Yep.
last? Okay.
Short, yeah, no JOA. Here's your JOA. They're going to ask for the lesser, reduce to it.
It's
not gonna go.
All our previous motions and objections, specifically the 2 motions for mistrial, the
See there?
The objections to state witness evidence and the Williams rule, in addition to the statement in the medical records that we objected to prior to their introduction, and our objection to the jury panel as a whole.
Preservation.
The defendant in this case, Mr. Terry, is only charged with 1 count of premeditated first-degree murder. I provided, Your Honor, several cases in the state prior to the judgment of acquittal argument. The testimony that we've heard so far has basically been
Really quickly, a JOA is a judgment of acquittal. If you look at all of the evidence most favorable to the prosecution, there's no way a jury could have reached a guilty verdict, so they just dismiss everything.
Yeah, this is going to get denied. It's pro forma. It's simply a preservation tool. Don't. This is just. Don't worry about this, all right, folks.
And the last text message from Miss Baker's phone that the state introduced.
2 more books and I can drink.
All is good now. When the 911
And I gotta go in
operator was called,
8
the
minutes.
neighbors
10 minutes.
had found
Yeah.
Miss
5 minutes.
Baker on the side of the home, and the investigation pursued from that point.
They're giving
There's
this
been no
person, see, this is a
direct
third
evidence
chair,
related to
so she's on the death
Mr.
case,
Terry
so she
being
gets
the person that
disqualified for,
committed those
this
injuries.
counts
The
as
weapon
one
was not
second
obtained.
chair
There's
in
been
the
no
towards death
statement
qualification. So
from
this is
Mr.
your
Terry admitting his involvement in this case.
up and comer.
And so the 2 areas that I'd ask the court to focus on is the circumstantial evidence. I outlined Hodgins.
One more book.
v. State,
Come on, baby, let's do it.
KINS v. State 175. Southern
Well,
Third,
it's pretty
741,
circumstantial. Even the blood is circumstantial.
2015 case.
It could have got there anyway.
That indicates that there's a
She could have left a
special
bloody
standard of
handprint,
review
and then he
of
could have come along a day
sufficiency
later and left a
evidence.
bloody handprint.
Applies where
I want you on my
conviction is
jury.
wholly based on circumstantial evidence, where the only proof of guilt is circumstantial, no matter how strongly the evidence may suggest guilt.
Oh, there's so
conviction
much to
cannot
talk
be
about. I'm sorry I got to leave. I'll try to come
Yeah.
back this afternoon if you're going to be around.
Yeah, if it goes into deliberations, I'll just kind of end it and then bring it back if they start to announce the verdict. But we'll do the closing arguments at least.
DCA case from 2021. And that case cites Graham v. State, 748 Southern 2nd, 1071, which is another 4th DCA case from 1999. And it outlines that the law guards against an impermissible stacking of inferences. An impermissible pyramiding of inferences occurs where at least 2 inferences in regard to the existence of a criminal act must be drawn from the evidence and then stacked to prove the crime charged. In that scenario, it is said that the evidence lacks the conclusive nature to support a conviction. And our argument would be that that's what we have in this case, is a stacking of inferences used to try to show that Mr. Terry is responsible for Ms. Baker's death. We would also attack the element of premeditation. Premeditation is the essential element which distinguishes first-degree murder from second-degree murder. And I provided to the court Valzort v. State, which we've referred to a lot, related to the Williams rule argument. And that's 75 Southern 3rd, 830.
Oh, really?
That's a second
So this is a
DCA case
senior
from
attorney here.
2011.
Yeah.
In that case also.
She's done a lot of
cites
cross-examination
to Berube
early on.
v. RUBE v. State, 5
I'll tell you,
Southern 3rd,
competent attorneys all around.
734, it's a second DCA case from 2009. In that case, in Valzort, along with the Williams rule arguments.
I got to go
She
get
gave the
a,
opening statement, actually.
Premeditation, and that premeditation is a fully formed conscious purpose
For what
to
it was
kill,
worth.
which must exist for a sufficient length of time to permit reflection as to the nature of the act to be committed and the probable result of that act. Premeditation may be proven by circumstantial evidence. However, where the element of premeditation is sought to be established by circumstantial evidence, the evidence relied upon by the state must be inconsistent with every other reasonable inference. Where the state's proof fails to exclude a reasonable hypothesis.
This has now gone on longer than her
of the
opening
crime
statement.
other than by premeditated design.
But this is good. I mean, these lawyers are all top of the game. You're seeing great lawyers right here.
Both of those are
Both sides.
strangulation cases, but
And the
brought
judge.
to the court.
Mm-hmm.
Coolin v. State,
This is
which is 696 Southern
circumstantial evidence rule in Florida is really tricky.
Florida Supreme Court 1997 case, which involves a stabbing similar to the allegations in this case. And in that case, the defendant and the victim had been hanging out and drinking with a group of people. It also involved an argument, and later the victim was stabbed to death. The court in that case found that although the evidence is consistent with an unlawful killing, they did not find sufficient evidence to prove premeditation, and they reduced the charge to second-degree murder. So based on those arguments, we would argue that based on the impermissible stacking of inferences, the court should grant the judgment of acquittal. But if the court does not find that argument persuasive, we would argue against first-degree murder in relation to premeditation and argue that it should at the very least be reduced to second-degree murder.
Wow.
Mr. Diaz, response from the state?
Your Honor, Mr. Dirks is handling this one state.
I doubt it.
Your Honor, the defendant argues that this is a purely circumstantial case, and
Yeah.
the state would submit that that's far from it.
Yeah.
The evidence shows, as has been outlined, and the court is well aware of, that we have the evidence of the defendant and the victim being together a matter of minutes before the murder occurs. They were out together. The argument that ensued has been discussed. They arrived at home together. The evidence further shows, the direct evidence, not circumstantial evidence, shows that the defendant's DNA is under the left fingernail of Kay Baker. On the north side of the fence, the green U marker.
Yeah, that's direct. That's not
went through
circumstantial.
The DNA, it understands the DNA. There's obviously a struggle. The evidence, the direct evidence of the DNA shows that there's a struggle outside. In the blood.
It shows someone was
the
bleeding
defendant and the
outside.
blood of the
Doesn't show a
victim
struggle.
in a couple places together. That
I watch you on my
direct
jury,
evidence
bud.
shows that evidence of the struggle. So this isn't a circumstantial case at all. There is direct evidence that accompanies the circumstantial evidence, and so we dispute that this is an exclusively circumstantial case. Having said that, the cases cited by the defendant have been overruled. Since May 14th, 2020, that argument that the circumstantial evidence, again, we dispute, must be inconsistent with every reasonable hypothesis of innocence, that special instruction in first-degree murder cases has been overruled in Bush v. State, cited at 295 Southern 3rd, 179. So essentially, the circumstantial evidence rule now that exists is just like every other case. The court must determine whether or not that, based upon all the facts.
Welcome back, Steve. What time do you have to leave?
Right now,
With the
so I'm
evidence
gonna
viewed in a
toast
light
to you, and I gotta go.
favorable to the
All right, we'll bring this down here just to say goodbye to Steve.
Hey, thank you for your chatters and your supporters and for letting me on. I'll try if you're on later and I'm free, I'll try to come back on. But if not, cheers to your guys. All right, this is gonna
And
get
just
denied.
remember, if any asks who Steve is, just tell them
He's the best lawyer in Miami.
in the company of each other with the defendant and the victim, the evidence.
Not
just
Miami.
minutes
But
before
thanks,
the
man.
takes place, all the DNA
God bless you, man.
DNA evidence
Tell Megan hi.
All right,
presented,
bye-bye.
which I don't
See you,
take
Steve.
into
Bye-bye.
account, the manner in which the murder occurred, the multiple stab wounds, the defensive wounds, the extremity, the extreme nature of the injuries that were incurred, the fact that the defendant was found hours later hiding nearby the murder scene. The cases cited by the defendant are nothing like these cases, this case that we have before us now. For all those reasons, Your Honor, both by the facts and the law, the state would request the defendant's motion for judgment equivalent be denied.
Thank you, Mr. Dirks. Anything else, Ms. Bradley?
No, Your Honor.
All right.
I think the prosecutor just should have said,
Everything that guy just said is bullshit.
I do believe
Thank
that
you.
the law in Florida has somewhat, if not significantly, changed since the Supreme Court's decision in Bush. And as to all of the arguments, including the circumstantial evidence, the stacking of inferences, and the premeditation, I am going to deny the defense motion for acquittal.
yeah,
at this time.
they never get
And
granted.
request,
I mean, it has to be so bad to
alternatively,
get granted.
reduce the charges from the first-degree murder. I believe that it is a jury question, and I am going to deny the JOA at this time, as I said.
Judge, I'm sorry. I know I said I don't have anything further, and I'm not disturbing your ruling, but I just did want to put on the record
Absolutely.
that related to Bush, I did provide the court with State v. Huntley, Huntley, which is a 4th District Court of Appeals case from
This guy knows he's never going to see the light of day.
refers to the Bush case. It is a case that I provided to the court in the state that talks about Bush and how the stacking of inferences may evolve, but it still goes back to impermissibly stacking inferences related to Graham v. State, 748 Southern 2nd, 1071. So I did provide that to the court. I just don't want the record to seem like I'm giving you cases that are outdated, because I did give you this one.
No, I see that.
That addresses that issue.
And it does cite Bush, and it does talk specifically about the stacking of inferences, and I am aware of it, but I am going to deny the motion. I appreciate that, though. So that takes us to defense case, and I know that you indicated that you would like some time to talk to Mr. Terry, which I'm absolutely going to grant to you. Additionally, you've indicated there are no other witnesses, so once you've talked to him and then I discuss with him, and we decide whether he decides actually whether he's going to testify or not, we'll know then what the next step is. And how long would you like?
If you could just give us 10 minutes, maybe we could go in the holding area so that we can have some privacy.
Yeah, let me, I will do that, and I will instruct the bailiffs to assist you with that.
Thank you.
All right, so we'll be in recess for 10 minutes. Thank you.
All right, another recess here. Just kind of turn off oldie volume and pop him out here. There we go. Wow. So there we have it. Their entire defense is going to be the state has not proved beyond a reasonable doubt that he is guilty of the crime charged. I mean, what are you going to do? It's not a good look for your client. That's what they got. That's their whole deal. Just the prosecution did not fulfill its burden of proof. And they're not even going to say that. When everybody comes back, it'll be something along the lines of, the prosecution is arrested, defense, it's your case, and they'll just stand up and say the defense rests. That'll be it. I don't think they will say anything more than that or anything less than that. Recess seemed way more fun in elementary school. Yeah, it did. Thank you, Kyle Mitchell. Oh, shoot. Yeah, this is his escape plan. Run. Yeah, see, that's why I'm kind of glad this thing was supposed to have wrapped up last week, at the end of last week, but the holiday and the hurricane kind of delayed it. And then the witness coming from Michigan, those two witnesses, I guess they pushed that back a day. So I was expecting this to be done before today, in which case it would have been on with Nick doing the Brooks thing. So that's why we're here doing this. And I'm kind of glad. I want to sit around and watch hours and hours of people talking about what it's like to watch their kid get plowed by a SUV. Ugh. So in a way, I'm kind of glad we're here just talking about two women getting stabbed in the face and neck repeatedly. Should we watch Brooks while on a break? Yeah, I think that'd be kind of fun. Assuming that law and... Oh, I want to do something... that's a good idea. That's actually a very, 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 very good idea. I wish we could snipe Nick's stream, but that'd be a shitty thing to do. So, hey, thank you someone for putting that idea in my head. But I also know that Court TV... apparently, someone was mentioning that Court TV is also streaming this trial. But before we get there, we have to take care of business. What the business? What the business? Just a map nailed to the wall. Have you always been a short sleeper? Yeah, I've even like when I was a kid, I hated taking naps because I wasn't tired. I wasn't sleepy. I would just lay there. I mean, there was times in high school and college where I wouldn't sleep for 2 nights. I stayed up for 3 nights and 4 days once, and I kind of started to hallucinate. That was kind of weird. But yeah, I mean, I've stayed up for 2 nights in a row a lot of times. I just don't sleep. Even now, it's 3, 4, 5 hours sleep. I'm fine. But sometimes, if I do overdo it, I'll just hit a wall and sleep for 12 hours. But that's very rare. Henry Ford was a short sleeper, invented the assembly Donald Trump president. I'm assuming he invented the assembly line, comma, not the assembly Donald Trump. Then we have the H guy. He had way too much free time. Best stick to streaming and entertaining law nerds. I would agree. And thank you so much for that big old super chat. I could be a dick and say it's only $99.99, so I ain't doing this shot, but I likes me some whiskey. So I think we should do a bone steel thing. I don't have I didn't expect this, so I didn't bring a shot glass. So
cheers, just a map.
That's good. All right. Thank you so much. That is deeply, deeply appreciated. Ooh, that'll clear out the sinuses. There we go. Make sure the voice mod thing is off. I can't see the lights flashing on it weird. So yeah, let's go and look and see if the, now weirdly today, the streaming problem, if there's any buffer, it's like really buffering bad today. Part of that legitimately is my fault this time. I talked to the phone company because I'm upgrading to like the best internet service that Korea has to offer, basically. I mean, right now it's way better than anything else that most people have. It's like it's fast, but now I'm just going up to something like 2 gigabytes per second or something like that. Just because I can. It was weird. They called me in the office today, said that my current plan has expired and they're giving me a free upgrade. But they said there may be possible interruptions between today and 5 p.m. tomorrow. But so if there is buffering problems, it could legitimately be on my end. Korea has been doing 5G for, I mean, just forever. 5G has been a thing here for years. Yeah, so, but like tomorrow morning, they're bringing over the new main router for the house to hook that all up, and then we should be fully live with the new internet stream sometime after 5 p.m. my time. So between 5 p.m. and this starts at 11 p.m. So between that, things will go. But right now, they said it could be a little bit iffy because they're in the middle of making the change. So I just want to see if law and crimes thing is worse than Court TV. So gonna look at the Court TV stream here. Court TV. I don't see Court TV streaming this when they're streaming the Brooks thing. Let's look at their live. Watch live. Oh, the Iowa Spanish teacher murderer. Is that start? Oh, that was 12 days ago. Parkland victim impacts. Well, the only this live right now is Brooks. So maybe it's on their website. I've never streamed from their website. Yeah. So but let's bring this up and I'll jerk around with this in the background. Let's see. We'll bring up Court TV and see what happens here. Court TV scares me though, because they're really big and powerful, and I don't want them to nuke me. Are the local streams? There was like the T whatever it was. Who the heck was that? It was like T somebody or other was doing it. TMJ4. Let's see. Yeah, they've got the good. That's the one we'll go to because they don't scare me. Looks like Brooks is on a break too. Well, crap. All right, I'll keep doing what I'm doing because Brooks is on a break too. Let's see which break ends first. And while we're doing that, this is just so fun, okay? I can't wait for something to happen in one of these two courtrooms so we can go to it. But it was good to have Steve here for a few minutes. It's awesome to see like a Florida lawyer on the ground talk about these Florida cases because it's very, very informative. Something happened real quick, and they left the courtroom. Something happened. They left the courtroom real quick, and the shell interrupted a victim giving a statement. Okay. Huh. Well, if anybody knows why they suddenly left the courtroom or what happened, that would be interesting to hear. Because I don't know. Huh. Well, I guess then while they're doing that, let's just talk amongst ourselves. Yeah, people are saying it's horrible. Yeah, Steve's input was great. The statement by was a kid. Yeah. Victim. I'd be like, just let me at him. Victim impact statements are so hard to do. Especially in emotional cases like this, because you never know what someone can, and you can't tell them what to say or what not to say. I mean, you can give them the general guidelines, like don't do something, but you really don't have any. Oh, sorry, I just kicked Yoda in the face. Oh God, I'm sorry, Yoda. Oh, sorry, pup. I didn't know Yoda was right by my feet, and I just kicked Yoda in the face. I'm so bad. What was I saying? Oh yeah, because you don't know what they're going to say, and there's a lot of cases, especially high profile cases, where the people giving the impact statements just go, they just go for it, and there's no telling what they're going to do. But yeah, it's not something that I'm sad that I'm missing, but yeah, we'll definitely keep doing it on the breaks. Why not? It'll be interesting to see how many people show up for Brooks. If anybody shows up for as Brooks's witness. Let's see. So what are we kick in the face? You must not. Yeah, seriously. I feel so bad. Sorry. Didn't mean to boot my dog in the head. That's kind of mean of me. So someone let me know when Brooks goes back, because they're just kind of hanging right now. Yeah, that's us. We're just chilling, just waiting. Executions. Where'd you go? Bulldog did. Oh, hey, there's Yoda walking around. Dog. That's Strawberry. Dargy. Strawberry is Dargy in Korean. Oh, wait. Hey, what happened? My Godzilla sign fell down. Damn it. Huh. Wonder why that fell down. It's a bulldog, though, so at least you didn't hurt his physical appearance. Aww! Yoda! They're saying you're ugly. They're saying you're ugly, little baby. All right. Enough of me hanging out with my dogs here. Yeah, so again, to recap, for those of you that are just joining while we sit here and try to figure out what's going on, we're in a break. Apparently she is, the defense lawyer is talking to the defendant, making sure that he doesn't plan to testify. And then they'll come back, and assuming he hasn't changed his mind. Now, that wasn't a good voice. That was just my cute doggy voice. Yoda voice needs more. I need more like smoking or alcohol to get the rasp in the Yoda voice. So yeah, I do Yoda and Chewbacca when I get drunk. That's when my friends were. That's when my friends know I've had enough to drink, because they say, "Uh-oh, Chewbacca's coming out to play." Xcomer, the real money is in merch. Oh yeah. My merch, go down there and click that and get the coffee mug. Woo. Get the coffee mug from the merch. It says Legal Vices on one side, and this is a cocktail glass on the other side. Nade, no, I'm not even going to read that. Yoda is the best because he's just crazy. Yeah, my Yoda is just kind of dumb. Not really the smartest dog that's ever come out of another dog. I mean, Yoda's just kind of. That's why. I mean, A1 looks like Yoda, all wrinkled, but also we named him Yoda because he just stares off into space like he's protecting the universe through the power of the Force, rather than doing anything semi-intelligent. So that's kind of why we named him Yoda. They need a beard and glasses. I'm kind of thinking of doing like a Lorax themed like T-shirt or something. Would that be fun? I literally have no idea what kind of merch people are interested in, but I was thinking of like doing a Lorax kind of T-shirt or something. Is that something that's stupid or what? We have 668 people. Some of you have left. We had like 800, which was still a bit, but now nothing's happening. So it's just me sitting here waiting for court to come back. Well, Selena Stovall says, you sound more like Grover on Sesame Street. Well, Grover and Yoda were voiced by Frank Oz, the same person. So that's why they sound similar. Yoda and Grover, both voiced by extraordinaire voice person extraordinaire Frank Oz. Okay. People say they get a Lorax shirt. Cowboy hat or no cowboy hat, Lorax? with your beard and glasses, I'd buy a hoodie for sure. All right, well, I'll get to work on a Lorax clothing apparel line. Why not? We'll see what happens there. Well, we had 666 concurrent viewers there for a second. And the reason I'm bringing that up is for those of you that have joined us late and whatnot and haven't hit the like button, it's minor grift time here. I would deeply appreciate it if you would be so kind as to hit that like button. Hit the like button, get our like numbers up. We're now 666 likes, so that's great. The like button, I know you guys don't think about it. YouTube thinks about it. That's what they like. They like the likes. They like to like the like button. And subscribe if you haven't subscribed. I think that would be really nice to get your subscription here, and I would deeply appreciate it. All right, we've got all the super chats cleared. Yes, we do. So now we're still just sitting here waiting on the oldie trial. Are we coming back? What the business, court? What the business? It's been 10 minutes. Nope. Looking at it, we are still in a holding pattern. How's the Brooks trial? Is that still in a holding pattern? Just a map nailed to the wall. Shooting another super chat. Just a map nailed to the wall says, design a hooded sweatshirt with "Enjoy Your Legal Vices" on it or something close. My wife absolutely loves it when I buy random hoodies from you guys. Well, I don't know if we can design front and back. I think if we had like a Lorax on the front and an "Enjoy Your Legal Vices" on the back, or if I can get some awesome artist type here in the chat to draw a picture of a Lorax with a cowboy hat, a whiskey glass, and a slit cigar with a Enjoy Your Legal Vices logo somewhere on it. That would be cool. So yeah, if any of you artistic folks want to design something like that, you would have my undying thanks for all eternity. That's just a thought. If somebody can do a Lorax with a big cowboy hat, a cigar, a glass of whiskey, and a Enjoy Your Legal Vices motto somewhere on it. Nah, the tinfoil hat would look kind of dumb, I think. I like the cowboy hat one. And so, as I was saying, for those of you that are joining us midstream, we're on this break. She's apparently talking to her client. Her client will come back at some point and announce whether or not he intends to testify in his own defense. The chances of that are as statistically close to zero as you can possibly be without actually being zero. If he wants to go full Amber Heard and testify, he's a bigger idiot than I thought. But then the court will bring the jury back in. The jury will say, the defense will say, defense rests, and they'll go to lunch. And then when they come back, it'll be jury instructions. It'll be final statements, final arguments, and then it'll go to the jury. Maddie Graham says, Legal Vices, read my last 2 comments. All right, let's scroll up, Maddie Graham. We got time. We got nothing but time here. Maddie Graham, got to go searching. Matthew G. Nutty, no. There's 1. And there's 2. Okay. Legal Vices. So I went back and checked out the Brooks case. It was weird. This woman that was reading a victim statement for them literally finished, and all of a sudden you hear a voice that says, Your Honor, we need to take a quick break. And all you see is the sheriffs around Brooks, and then the judge quickly get off the bench. Weird. Okay. Let's scroll back there. Oh, that's this case. Sorry. All right, let's YouTube. Yeah, the chat on TMJ4, is that what it is? Whatever this channel is. Yeah, TMJ4 is doing a lot of speculation too, that maybe someone had an episode or something. How much time do we got here before something happens? All right, I'm just scrolling back here. 18. All right. Well, okay. So we went to. Well, all right. We'll watch this. We'll pull this up and see what happens. All right. Stop screen. Boop. Present screen. Share screen. Chrome. Daryl Brooks.
The state may continue.
Thank you, Your Honor. For group 2, I believe, Kelly, are you in the phone? Jen's going to be for you. Okay.
Why are we whispering?
I'm victim LLO, and on November 25th,
Oh no.
2021, me and my family's life changed forever. My brother and I were headed to parade. We've been scared of parades not letting us feel safe and comfortable, or even being able to run out into the road to fetch candy. For example, when I went to the Arrowhead Parade, all my friends were asking me why I didn't want to go out into the road to get candy, and I said, because of the Walkie Shop Parade. And I was mad because if the parade incident did not happen, I would be able to go onto the road to enjoy something as simple as a parade. When I got to the parade, with my friends. I constantly remember to not go out into the road, to be better safe than sorry. It is the last thing I want to happen again. How could you do this? Think of your kids. Would you do this to them? I'm just a child with a lifetime left to live. I'm also here for my younger brother, victim KKK. When he was hit by the front of the car, he was traumatized forever. I feel his fear. I feel his pain, because when I was hit, I broke down into tears too. On the way to the hospital, we had to lay our head down on the floor because we heard there was a shooter. My fingers, my whole body was paralyzed in fear and fright. When we made it to the hospital, I was terrified because I thought I broke my fingers. And when they asked me what happened, I was too busy crying that I couldn't speak. I still this day. The day after the parade, I couldn't even go to school because of what he did. All my friends were worried about me, texting me, asking if I was even alive. Sometimes I even think of all the others that were hit and how they were in the hospital for longer than me, and how their parents were probably praying that their kids would be okay, and that this would be a once-in-a-lifetime happening.
Okay, the judge is coming back, so we'll skip through here a little bit.
Half of victim KKK.
Your Honor, we need to take a break for a second, please. I'm sorry.
I'm sorry.
It's important. All right, thank you. We'll do that.
Okay, that's all we know. Yeah, just said somebody has to. So we have to take a break. It's important. Well, okay. So the judge he sat down on the bench, started talking, and then he got up and walked away. So don't know what that was all about, but okay. So we have this thing going on here in the Brooks trial too. So weird. It's a strange day in court all around. Wow. All right. Oh, but that's just horrible. I mean, yeah, they shut down after the kid, and then I guess the lady came on to say something, and just as she started talking, done. Yeah, he's cuffed in front today. He's cuffed because now he is a convict. He no longer. The reason they don't like handcuff them in court or put the cuffs where it can be seen is because they don't want to prejudice the jury. They don't want to give the jury the presumption that the guy is guilty. So, oh yeah, he's a defendant. He's got handcuffs on him. So I mean, clearly he must be guilty of something if they have him handcuffed. They don't want to give that impression to the jury during the trial. He's been found guilty. He no longer has that presumption of innocence. That's why he is openly handcuffed now. That's why Brooks is openly handcuffed. Yeah, Flux, we're not doing that. We're just we're waiting for the judge to say something here. But yeah, we're just kind of in limbo in both cases. So let's talk about what's coming up here on legal vices in the future. If this case finishes, it could finish today. They could both give very short statements. The jury could go out. They could get the jury instructions read very quickly. The jury could go out and go, yeah, he's guilty, and come right back in, and they could have the verdict in this case today. I would guess probably morning tomorrow would be more realistic. But it could happen. It could happen today. It could happen late this afternoon. We'll just have to find out. But if this does not go until tomorrow, if it ends today, it ends today. If it ends today and we go into tomorrow, then I really haven't thought of what I would do. I'd probably be on Nick's stream with him for the actual sentencing of Daryl Brooks. And then we'll do O.J. Simpson on Thursday. We'll do some fun, unexplained, creepy, weird stuff on Friday. And then I have to figure out what to do for next Monday's Maritime Monday, which I think I said we would be doing sea shanties. So I think that's where we are on that. But and then we'll find the next trial to stream. Why not? So that's sort of the weekend preview here, as best we can do. It depends whether I'm doing this today and tomorrow, or just this case today, and then we start doing other things tomorrow. It's totally up to the prosecution, defense, court, and jury at this point. A Savage says, I'm a ceramic potter who would love to design for our law peers and mercy here. Wow. That sounds fun. Cool. Like, ceramic figures kind of thing. Ooh, that'd be fun. And and just a map nailed to the wall says the defense isn't going to at least call a DNA expert, or did I miss that part? No, they are calling nobody. They just told the case that they're not calling any other witnesses. And then the judge asked, "Are you calling your client?" And they said, let us go outside and talk about it for 10 minutes, but they're not going to call him. Because if they call him, then he totally opens the door to them being able to come back and go, "Oh yeah, remember that testimony about you stabbing the other girl? You went to jail for you went to jail for years for that, didn't you? You were convicted of doing that, weren't you?" And then it gets really ugly for them. And so there's no way that he's going to testify. And he's got to know he's doomed. He's just got to know he's doomed. Okay. All right, that clears our current round of super chat. Just making sure. Yep. Yeah, we're still kind of trying to find out what happened here. Okay, we've got him coming. Oh, he's handcuffed. Interesting. Hang on. Let's bring this up. They're bringing him back into the courtroom, and he is handcuffed. I guess they just take the handcuffs off when he gets sitting in the seat. Yeah, they're taking his handcuffs off right now. Okay. Yeah, then they'll bring the jury in. Okay, sorry about that. We just read that one. Yeah, that's how they're going through the witnesses apparently.
Now, including Mr. Terry. Ms. Perry, you had an opportunity to discuss with Mr. Terry his decision whether to testify or not during his case in chief?
We have, Your Honor.
Is he prepared for me to address him and ask him questions regarding his decision?
He is.
All right. Mr. Terry, all right, that's fine. If I do need to swear you in, if you'll raise your right hand, please. Do you swear or affirm any testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. Sir, this is the time in your trial where you have a very important decision to make. That decision is whether or not you are to become a witness in your case and testify before this jury. You may have heard me tell the jury in the beginning, in the initial instructions, that you are not required to testify and that they cannot hold it against you if you don't. In fact, there is another instruction, if you decide not to testify, where I will tell them that you've exercised a fundamental right by choosing not to be a witness.
No, he's not going to
that
testify.
They are not to view that as an admission of guilt or be influenced in any way by your decision. It ultimately says no juror should be concerned that Matthew Terry did not testify at trial. I will only give that instruction if you do not testify. The other side of that decision is you have an absolute right to testify.
No, he's not going to testify. The judge is just putting him under oath to ask whether or not he plans to testify. He's going to say no.
Your attorneys would have an opportunity to ask you questions first, and the state would have the opportunity to cross-examine you. Then your attorneys would have the opportunity to re-examine you, redirect. This decision is your decision and your decision alone. However, it is very important that you discuss your decision with your attorneys. So my first question to you, sir, is have you had sufficient time to discuss this very important decision with your attorneys? One thing that I left out, if you take the stand, then because you have a prior conviction, that is something that would come out. And I don't want to know what you've talked about with your attorneys. I suspect that you've talked about that with them, but I want to make sure on the record that I've made you aware of that if you take the stand, then the state or the defense would bring out the prior conviction that you have in the Michigan case. And it's my understanding, and I'm going to verify with the state at this time, that that's his only prior conviction. Is that correct?
That is correct. Well, he has some misdemeanors, but they don't.
Okay, they don't satisfy the statute. So there's just the one prior conviction, but it would come out if you decide to testify. So that's one of the many things that you should take into consideration. Let me ask you again, have you had sufficient time to consider whether you want to become a witness or not?
Yes.
Have you made a decision?
Yes.
What is your decision?
My desire is to testify.
No!
However,
Oh,
I'm
okay.
going to follow my attorney's advice and not testify. Therefore,
Well-
I will not be testifying.
Well, need to be very
Yeah,
careful
very.
here.
You have to be very specific.
Do you understand? I encourage you to consult with your attorneys and to consider their advice. But at the end of the day, it is your decision and it is not their decision. Do you understand that?
Yes, I have decided to follow their advice and to not testify. That is my decision.
Okay, so after consulting with them and discussing whatever you may have discussed, again, I don't want to know, you have made a decision, and your decision is not to testify.
Yes, however, my desire hasn't changed.
No, shut up, dude. Shut the fuck up and sit down.
I have a couple more questions that I ask anyway, but they may be even more important now, and that is whether or not anyone has forced you or threatened you in any way to make this decision.
No.
Are you under the influence of any drugs, alcohol, or prescription medication that might affect your decision?
No.
Ultimately, I need to determine whether your decision is freely and voluntarily made. Do you believe that your decision not to testify, in light of everything, including what you've expressed as your desire, is a free and voluntary decision not to testify?
Yes.
Okay. State have any requests of any questions?
No, Your Honor.
Defense have any requests of any questions? Anything to put on the record?
No, Your Honor.
All right, thank you very much. Mr. Terry, you may be seated. So that means that there are no witnesses from the defense, correct?
Correct.
So when I bring the jury in, the defense is going to rest. Is that correct?
Yes, Your Honor.
I suggest it's 11:30. I suggest I bring them in, allow you to rest, then I send them to lunch. Let's talk about how long. We need to do a charging conference, but it looks like we're going to do closing arguments right after lunch.
Yes.
And perhaps even an early lunch. If I send them to lunch at 11:30, I tell them to come back at 1, that's an hour and a half. Is that
No.
sufficient time?
No, they're waiting.
That's
Is
too
that
long.
sufficient time?
I don't think there will be a lot of hassling over the jury instructions. We've already resolved some of the typos and things, so I think we can do the.
I didn't anticipate either, but I want to make sure you all have a brief opportunity to have a lunch and then be prepared to give your closing arguments. I did warn you yesterday that this may be happening today.
All right.
So 1 o'clock?
Yes.
All right.
Ask that we do the charge conference before we break for lunch.
Absolutely.
Okay.
Yeah. I just want to get them to lunch. So I'm going to bring them in. It's 11:30. I'm going to send them, tell them to come back at 1. We're going to do the charging conference so that we can get all the instructions printed, handed out, and then 1 o'clock we come back and we do the closing. I'll do the instructions and the closing arguments.
That sounds good.
All right. Let's get the jury.
Wow. Okay.
Now, typically I allow you to formally rest in front of me and then ceremoniously rest in front of them. I don't know that that's necessary because I do know that you want to renew all of your stuff. So you're only going to rest once. It's going to be actually in front of them. So it will be, the official resting will be in front of them.
All right. So they're going to have an hour and a half lunch. But during that hour and a half, they're going to go through all the jury instructions and stuff like that. And finalize that. They'll come back from lunch. Then they'll do the closing arguments and the jury instructions,
Until
and then
they say
done.
that they rest their case. You can change your mind. So if you want to lean over and tell Ms. Perry that you've changed your mind, I just want to let you know that until the defense says, I rest, or we rest, you have the opportunity to change your mind. You understand that? Okay.
Corn Pope says, Legal Vices would love your opinion on if you think this is the right decision to not call anyone. Oh, yeah, yeah. They would be stupid if they called anybody as a witness. I mean, who are they going to call? To say it wasn't his blood? That he wasn't there? Try to legitimately put on an argument that it was somebody else? Put him up there so that they can talk about his prior going to jail for stabbing this woman in the neck? Yeah, nothing to be gained. And Matthias Davis, same answer to you. Yeah.
It is. I agree. And I usually do. I felt awkward being just about the only one sitting, while everyone else was standing.
Because he's an arrogant son of a bitch. That's why he wants to testify. But yeah, they have kids. That's why she was asking for like the previous stabbing victim was asking for $100,000.
Yes, we are.
Or plus for child support.
All rise, jury entering courtroom.
Jury coming in.
I hold that against the attorneys.
Okay,
the parties,
hi.
or anyone else. I am responsible for the length of the delay. At this
I don't know why
time,
there's so many
though,
young
we
people
are
there.
going
Could be a
to
high
turn
school
to
class.
the
I don't know.
defense for their case. Defense ready to proceed? All right, thank you. Ladies and gentlemen of the jury, the state having rested their case and the defense now having rested their case, you may recall from my initial instructions that the next step is the arguments of the attorneys and the instructions on the law. Given the time, I'm going to go ahead and give you your lunch break now. It's a little bit of an early lunch, and I'm going to give you an hour and a half. We're going to come back at 1 o'clock for the final
That's a good point. It could be her students. I don't know.
Instructions on the law, and you will begin your deliberations this afternoon. Please do not discuss this case amongst yourselves or with anyone else. Please do not do any research related to this case in any way, shape, or form. Please avoid any contact with any outside media, social media, anything about this case. Please enjoy your lunch, and we will see you back at 1 o'clock. All rise for the jury.
And that's it. Case over. Just the final arguments left. And then we're done. Wow.
Jury has exited. Everyone may be seated. Mr. Diaz, you had indicated that you all have talked about the jury instructions. I appreciate that from both sides. My staff attorney was going to pull them up and make any changes that we make during the charging conference.
And yes, Your Honor, Ms. Bradley had pointed out some like typos and things that I have already corrected, so the staff attorney may see that on her.
So this is where we go through the jury instructions.
Well, I want the most recent copy. If you can email that, and I think it'll go through pretty quickly if you email it to her address or what?
Yes, Your Honor, give me 1 second.
Ms. Bradley, did you want to say something?
Judge, I'd also just at this point renew our...
Oh, yes, I do apologize.
Okay, I will renew all previous motions and objections and renew our judgment of acquittal based on the same arguments and case law stated previously.
Appreciate that, and even at the different standard at this time, same ruling as to all previous motions, objections, and at the renewed motion for judgment of acquittal, even at the higher standard, I am going to deny that at this time.
Yeah, she's got to redo her motions.
When we have the most recent version of the instructions, we'll go through them. You can get, I don't need to print it.
Well, and while they're waiting to send each other emails, I love how they're sending each other emails in the same room. Savvy says, no, like, put your design on mugs, tumblers, whiskey, teacups, etc. and such. They'll be handmade pottery. Sorry, not a sculptor. Recently added candles to our line.
I appreciate
Oh,
the
candles are
numbering
always
on the
cool.
bottom right-hand side. It makes it easier.
Oh, we'll get to this in a bit. All right. So again, they're just waiting for emails to go back and forth here. Yeah, and again, she is a math teacher. We don't know why there's all of these young people here. Could just be her students. I don't know.
This is the person? Yep. While she's pulling that up, remind me, it's probably clear on here. Well, I'm actually missing an instruction. So.
It depends how long the opening statement, I mean, the closing statements are, the closing arguments. If they're short, I would guess, I mean, if they needed an hour,
Remind me though, I know
nobody, they're going to come back quick.
In the beginning as to whether
I
you're
think.
going to do your closings, which is what I believe, and then instructions, or instructions and then closing. Okay, that's what I recall. So the language that I have should be consistent with that. And I do have a stack that is 1 through 20. However, that starts with 3.2, statement of charge, and there is an instruction that I believe is 2.7 that goes right before that regarding closing arguments. So that's what I'm looking for.
Your Honor, 2.7 is in the other packet, which is pages 1 through 6. You should have had a packet of like your preliminary instructions and the instructions during trial.
So you want me to add this to this packet?
No, I just need this. I just want to go over and make sure there's no objections. I don't care about it. In fact, let me verify with the defense at this time. Normally, what I send back to the jury, and I let them know, I don't send back 2.7 unless you want me to. I consider what is now starting with 3.2, pages 1 through 20, as the substantive instructions on the law. I consider 2.7, which is page 6 of 6, as just a procedural thing, letting them know what's going to happen next. So what I suggest is we just leave that as 6 of 6, and that not go back to the jury, and then we discuss 1 through 20, and this is what goes back to the jury. Any objection to that?
No, Your Honor.
All right. So as to 6.6, let me just make sure, let's go over and make sure there's no objections.
You're saying 6.6, it's 2.7.
6 of 6, I agree. I was looking at the bottom page. 6 of 6, 2.7, closing argument. Both the state and the defendant have now rested their case. The attorneys will now present their final arguments. Standard language, any objection?
No objection.
All right. So we're going to hang on to that. Now we go to the stack that starts with 3.2, statement of charge, page 1 of 20. What we'll do is, what I find to be the most efficient is, Mr. Diaz, they're your proposed instructions. I don't need you to say no objection. However, if you have anything that you want to be heard on, or suggestions or anything, you're welcome to do so. But I'm just going to go through with the defense and see if they're in agreement with each of them. So as to 3.2, statement of charge, any objection?
No objection.
As to 3.4, lesser included offense crimes, and we have 2 specific that are listed. Those are second-degree murder and manslaughter. Any objection?
No objection.
No additional requested or any other lesser includeds that you believe should be included?
No, Your Honor.
Thank you. Next, I have 7.1. We're on page 3 of 20, introduction to homicide. It, I suspect, is more than 1 page.
No, it's 1.
It is? Oh, okay. You're right. It is 1 page. Next, I have.
Okay, that was me.
4, 7.2 murder as to count 1, and it includes 3 separate elements. Any objection?
The only thing I would take out is give only
Yeah.
if they're.
Yeah, I see that. So give only if there is evidence that the defendant acted in the heat of passion on legal and
Is the defense asking for the instruction that follows?
I am, Your Honor.
Okay.
Is there evidence they're relying on that meets criteria A? There must have been a sudden event that suspended the exercise of judgment in an ordinary reasonable person. I mean, I don't expect the defense to tell me what their argument is, but all of their argument seems to be someone else committed this crime.
The jury is free to make any reasonable.
What boomerism? There's no boomer thing happened. I told you that there may be interruptions in my internet service tonight. There was nothing boomer about that.
Again, that they were starting to get to bed and talked about them taking off their shoes. And so obviously the jury is free to infer from the evidence, a reasonable inference is that there was some kind of sudden provocation which led to the incident. So we would ask for that.
If the defense wants, I won't object. I'm just very
Okay.
confused. But
All right, I'm glad.
So just delete the sentence in italics.
But we're deleting the italicized give only if
yes,
there
I'm
is
striking,
evidence.
I'm striking that right now on the electronic copy I have here.
All right, well, and as I said, my staff attorney is making those changes, and we can print out multiple copies. I don't know if that's gonna bump that all onto one page. It's still gonna be 2 pages. And actually, what I prefer is that last paragraph on that second page not come up, that still remain
That's the last thing on that page.
the
That's
only thing on
only
that
thing,
page.
correct.
Okay. All right. So, any objection other than taking out the give only if there is evidence, and I will give the heat of passion instruction. Any objection to that 7.2?
No, Your Honor.
Thank you. Next, I have 3.3A, aggravation of first-degree murder by carrying, displaying, using, threatening to use, attempting to use a weapon. This is page 6. Any objection?
No, Your Honor.
Thank you. Next, I have page 7, lesser included offense as to count 1, which is second-degree murder. It also includes 3 elements.
No objection.
Thank you. Next, I have page 8, which is 3.3A, aggravation of second-degree murder by carrying, displaying, using, threatening to use, attempting to use a weapon.
No objection.
Wait, sorry. Oh, go ahead, sorry, go ahead.
Okay. Next, I have that was page 8. Next is page 9, lesser included offense, also as to count 1, 7.7 manslaughter, which includes 2 elements, one with an A and a small b.
Well, we've already agreed, the defense suggested to strike B, so I've already amended.
They're just
it.
working on jury instructions here.
Okay, all right, you're right. I don't have the most recent in my printed out copy, but all right, so
I have it.
other than the elimination of B, is there any objection?
I have no objection to the revised version that was just sent.
And the only difference on the printed out one that I have is the elimination of small b.
And the 2 paragraphs defining culpable negligence.
Okay. So there's been a change that you all agreed upon. So Mr. Diaz, no
Yes.
objection?
Yes, we struck culpable negligence as a theory, and then we struck the 2 paragraphs that deal with culpable negligence.
So let me just look at
Yep.
it.
So these are
All right, so the last 2 paragraphs are gone. Agreed?
Yes, Your Honor.
Okay. Next, I have page 10, 3.3A, aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a weapon.
No objection.
Thank you. Next is page 11, 3.6D, voluntary intoxication.
No objection.
Thank you. Next is 3.7, plea of not guilty, reasonable doubt, and burden of proof, and this is on page 12 of 20.
Judge, I'm sorry. I don't know if you want to go back to 3.6D and just take out the or she.
I'm happy to. Mr. Diaz, a person is voluntarily intoxicated if he or she knowingly consumed. So take out the or she and just person is voluntarily intoxicated if he knowingly consumed.
Yes, Your Honor, I'm fixing it right
There's
now.
there's 2 he or she's in that
I got
last
both of them.
sentence.
I got both.
All right. So is my staff attorney taking that out of 3.6D at the request of the defense of the agreement of the state. And me, I like taking that out. So now let's go to 3.7. I don't remember page 12 if the defense indicated no objection. I don't think so.
I'm sorry.
No, I don't think that I've gotten your response to 3.7.
No objection.
Thank you. Next, I have 3.9, weighing the evidence. This may require some revision. It has paragraphs 1 through 11 on my 12. It's
Yes,
2
Your Honor,
pages.
and that was an error that we already fixed. Paragraphs 10, 11, and 12 on the copy you have are the same paragraphs that repeated below. For some reason, they got put in twice and numbered. I don't know why that is.
Because he was voluntarily intoxicated at the time he did this.
Okay.
Yeah, he's getting drunk
The only additional
voluntarily.
amendment is, I think, number 9 should be removed. So I don't think there's been any.
I agree.
priors.
Has the witness been convicted of a felony? We'll take out.
And then the defendant in this case is become a witness.
And the capitalized, the defendant in this case has become a witness should also come out. Agreed?
Yes, Your Honor.
Yes.
And that still is on the second page.
No, yeah, right. All right. It's still going to be 2 pages, but you've already eliminated 10, 11, 12. We have now eliminated 9, and the bold part about the defendant becoming a witness. Next, I have page 15, 3.9a, defendant not testifying, which is absolutely now relevant. Has the defense had an opportunity to take a look, check the language on it?
Yes, no objection.
All right. Next, I have page 16, 3.9b, defendant's statements.
I had that in the off chance that Your
Okay.
Honor was going to allow anything from the medical records that was considered a defendant's statement.
Well, I'll see if they're requesting it. Maybe,
Yes.
maybe not.
We are.
All right. No objection to it, Mr. Diaz?
No objection.
All right. And it is good as is? No, does it need any changes?
No, Your Honor.
No, it doesn't need any changes, or no, it's not good as is?
It does not need any changes.
So it is good as is?
Yes, we have no objection.
You know me, I want a perfect record.
Good.
Good.
Thank you.
Good judge.
Next is page 17, 3.10, rules for deliberation includes numbered paragraphs 1 through 7.
No objection.
Thank you. Next, I have page 18, 3.11, cautionary instruction.
No objection.
Thank you. Next, I have page 19.
Yeah, Rhoda, we'll get there. It's a
3.12,
starred comment. We'll talk about it in a minute.
No objection.
Somewhere, I actually have the verdict. Here it is. It is 1 page. It's titled Verdict Form Guilt Phase, and then it has suggestions, objections to the proposed.
Hi
verdict
again.
form.
The only thing that I'd ask now, looking at it, is just to remove the portion that says guilt phase. I don't think there'll be any confusion
I
as to
agree.
this verdict.
That's fine. Any objection?
Done.
All right. Anything else?
No, Your Honor.
All right, so we have a verdict form. It does not say guilt phase verdict form. After that, I have 3.13, submitting case to jury. And let me ask you all why it looks so short. It's not usually that short. Has something changed?
I don't know. Double check.
Yeah, there's a substantial part of the standard 3.13 that is not included.
I don't know why that is. I apologize.
You see it though, that there's several paragraphs that are missing?
You're completely correct. The first 2
Wait,
paragraphs
wait.
are there, and then the rest of the paragraphs are not.
Let the record reflect that Mr. Diaz said I am completely correct. Can you mark that?
Sure, we can have it framed afterwards if you.
I will. I intend to. So now that Mr. Diaz is, well, actually, my staff attorney is pulling up the standard instruction. Ms. Bradley, I'll ask that you pull up so that we can discuss the addition of the other standard paragraphs.
I have it.
Did you not notice that it was short? I know that when I went to you, that's exactly the first thing you were going to say. I give you credit.
I wasn't going to say anything. Ms. Bradley, I'm sure, would have meant.
I know she would have. I know she would have. Your Honor, it's just not all there.
Okay, so they're missing part of this, the part of the jury instructions. That's nice.
She'd be happy to say Mr. Diaz is not all there.
You always do say that in court, right?
Yeah, Bailey.
Yeah, ordinarily judges are the
My
only
staff
one that
could
should
have
joke.
asked me There's some in their language that there's a choice between bailiff or court deputy, and I've instructed her. You have in the paragraphs that you included said bailiff, but that is what I
Actually,
used.
at the opening of the trial, you said court deputy is what you said, because you had me change it.
My bad.
So, okay, that's fine. I don't know if you want me to, you don't send the initial instructions back,
No.
right? Okay.
You want bailiff?
Bailiff.
Okay.
Mr. Diaz just wants to point out a mistake I made.
No, I wasn't sure if you were gonna send that instruction back, and I had changed it, because you normally say bailiff, and then you said court deputy, and that's what
Right.
stuck out.
So are we ready to discuss the complete version of 3.13? Ms. Bradley?
Sure.
The one I have in my hand
Probably.
has 2 paragraphs. What is the following paragraph?
It is, many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate.
So that's the 3rd paragraph.
Yes. 4th paragraph is, if you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note.
That's the 4th paragraph.
Next is, if you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for an answer. I will answer any questions, if I can, in writing or orally here in open court.
That's the 5th.
Then, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. And then we always do these.
They work with each other all the time, I would imagine. So does the
And
defense.
to that, apparently that's a choice.
Yes, no objection.
I mean, things are much more informal when the jury's not there. When the jury's there, everything is formal and by the book. When the jury's out,
In closing, let me
Yeah.
remind you that it is important that you follow
they're much,
the law spelled out
much
in
more
the
informal.
instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share.
So, as to the full version of 3.13, I'm surprised Mr. Diaz didn't blame that on Mr. Dirks. Is there any objection?
No objection.
Mr. Diaz?
No objection.
So we have jury instructions.
That's it.
We have a verdict form. I suspect you all would like to eat lunch and prepare for 1 o'clock closing arguments. Is there anything else from either side before we break for lunch?
John, I'd like to address, now that the state and the defense have rested, but we've obviously not proceeded to penalty trial. Ms. Rogers and Detective Crumbach would like to come into the courtroom for the end of this trial. Obviously, they would have to remain outside when we get to penalty phase, and those witnesses are testifying. But I would.
They want to watch the closings.
They want to watch the closings, and they want to be in the courtroom when the verdict is read.
Okay.
Your Honor, I would prefer the sequestration continue to apply throughout. We would not want any sort of state closing arguments or defense arguments to influence any sort of testimony that may occur when the state's attempting to prove aggravation.
Without pulling it up, Mr. Diaz, I mean, they are not within the specified.
They're not next of kin. They're clearly not next of kin.
Right. So, in an abundance of caution, if there was no objection, I would allow it, but with an objection, I'm not going to allow it. There's an objection, correct?
Yes, sir.
All right, I'm not going to allow it.
Yeah, so they want to
How
keep.
many copies we're going to print? We'll print those now, so that you all can take a look at them, make sure that they're as we
Hang
discussed.
tight.
But how many copies does the state want?
I just want one.
And defense?
Yes, please.
3, please.
Okay, so 1 for me, 3 for defense, 1 for state. We'll get 5 copies. If you want to remain in the courtroom, it'll take us a little while, but we'll get you those, and we'll come back at 1 o'clock. Was there anything else from the state?
No.
Anything else, or anything from the defense?
No, Your Honor, I'm just double checking 3.
Don't. There you go.
Because there was an issue with the other one.
Sure.
It's just formatted a little bit different, so I'm just making sure that there's.
If you need to come up and look at my staff attorney's computer screen before we print, the last thing I want to do is print them and then find out that they're.
Right.
Pull up 3.7. No. Our, whatever our current version of 3.7 is. I have it in front of me, so if you have any questions as to the one that's going to be printed, or if you'd like to come up and look at it, you're welcome.
Let's get to lunch.
Judge, can I just clarify, is the defense objecting to the people being in the room when the verdict is read? There's no argument or anything then.
Is the objection include, as previously discussed, it may have included the closing arguments and the reading of the verdict. Is there any objection to them being present for the reading of the verdict?
If we could revisit that, please.
I'm sorry?
If we could revisit that later, I'd appreciate it.
Yeah, the jury's going to be deliberating. I want to go back and look at the rule, and certainly if you have any case law, so they're reserved. They're not saying that they have objection to that. I want to do research on it. If you want to present case law on it, it is something that we will have plenty of time to decide.
I understand. I would just ask to address it.
While the jury's deliberating, once I send them out.
Yes, sir.
Because they won't have a verdict till after they deliberate, so it's
Yes.
something that we can discuss while they're deliberating.
I understand.
3.7 is fine. The only difference is just that it says whenever the phrase reasonable doubt, and the standard says whenever the words reasonable doubt.
What do you want? You get to pick.
That's fine.
Your pleasure.
No, that's fine. I
Which is
just
fine.
wanted to, words, a phrase is fine, I just wanted to make sure, it's just formatted different, so it looks shorter, but it's got all of the other language from it, so that's fine. I have no objection to it.
No objection? Okay. All right, we will print it, we'll provide it to you. Is there anything else from the defense?
No, Your Honor.
All right, it is 12 o'clock. That gives you 1 hour, which should be sufficient time to have a nice lunch, prepare, and we will come back at 1 o'clock for closing arguments. Thank you all. Have a nice lunch.
All right. That's out of the way. Well, all right. The next thing that's going to happen is they're going to come back. Both sides will give their closing arguments, and they'll read the jury instructions, and then the jury's out. That's it. Just to read a few things here, and we have a guest that's coming in. So let me send an invite to this guest. This guest will be here for 10 or 15 minutes, taking time out of their lunch hour to share some information with us. So we'll get to that whenever that happens. But in the meantime, I've started a few things here that we might want to discuss, might want to talk about. I can get rid of this stupid banner here for a second. Boop. All right. First of all, now Flux has said that she's been trying to send super chats and that all of her super chats are being timed out. Is YouTube still being squirrely? Or have any of you tried to send super chats and haven't been able to do that? Just curious. No, it's not Danny. No, not Danny. Totally different person. Someone who's never been here. But anywho, we'll worry about that bridge when we come. We'll cross that bridge when we get there. Rodile says, legal vices, these, I'll tell the jury not to use this as evidence of X or Y. Sounds hollow to me. It's not like the judge telling them sternly not to let something influence them is going to work. Well, that's the theory we like to use. You heard this. Don't consider it evidence. It's just a statement. We like, that's the theory. We like to think that that's the, you have to say it. I mean, and you have to believe they're doing it unless you can prove otherwise. Now, we have a special guest here who, again, is taking time out of their lunch hour just to be here to share some interesting information with us. Let's bring them on here. Here we go. Hello, Jason.
How you doing?
Good. This is Jason. Jason reached out to me and said that he used to live in Michigan, and we don't do anything to...
I still live in Michigan. Yeah,
you still live in Michigan. Okay.
Yep, I just work at a different place now.
Okay. Yeah, we don't want to dox you too much here. Still lives in Michigan, but apparently worked with the defendant, Matthew Terry.
Yep. Yeah. So, and obviously, I sent you some more, information at the.
Yeah, I did a little bit of due diligence to make sure it's not just some rando trying to get here on screen. I've seen a couple of things that indicate that this is actually a thing. So you worked with him. Did you work with him, or you just worked in the same company? You've seen him, met him, know him?
So no, So he was like one of the OG software developers at the company, like back when it started in 97 or so. I don't think he was with it right at the start, but he was somewhere close there. He was one of the OGs. So when I started, I was doing, support stuff. And then when I really started working with him, I was actually a QA engineer. I was doing software testing stuff. It's interesting because I didn't even realize my boss did a review for him, because my boss was the QA supervisor. So he must have had to, pinch hit a review or something. So I was actually kind of surprised, when I heard that, obviously that screenshot I sent you, but yeah. Yeah, and then one of the things about the company, it was, at least before the company changed hands, it was sold back in 2015. And anyone that sees this, that worked at the company, they're going to know who more than likely they're going to recognize me. They know exactly who I'm talking about. So it's like, whatever. But
well, and from the I guess we'll call it the due diligence you sent me, you're still friendly with the people there. You still talk to them, send them messages.
Yeah. Like I said, there was the one group on Facebook, but yeah. Anyway, so prior to the company changing hands back in 2015, let's say that company sponsored drinking events were a regular thing, so to speak. It's kind of cliche, but it was during back in 2017 for the first trial. Which I didn't pay much attention to, because this is back before at least the trial court level stuff was really streamed. It was, like I said, kind of cliche, but it's like, wow, I didn't realize that, because I had actually, like I said, company sponsored drinking events.
Yeah,
one of these, I was getting fed beers by the bartender, basically rapping with Matt and I'm pretty sure it was Michelle. The entire night, and we're both just pretty annihilated, and he didn't seem belligerent at all. So I was like, this is kind of interesting. So I don't know if it was just, there wasn't any jealousy in play at the time. So it's like, whatever. But as soon as, someone's talking to my girl, or I'm perceiving someone, dancing or whatever, maybe that changes. I don't know. But, yeah. So
did you ever see him have a short temper, get angry?
No, that's the weird thing. I watching the chat, the dude definitely.
Oh, you've frozen. Shoot. You're frozen. Come back to us. Come back to us. Jason is frozen. Jason is frozen. I hope it's Jason, not me. Jason. So you're still frozen. There we go. Shoot. Pop back in. Jason, shoot. All right. Yeah, pop back in. Jump back in. Send the text message. All right. Well, we will. Okay. Sending a message to pop back in. All right. Yeah, he's saying he's having a little bit of problems connecting to StreamYard. StreamYard sucks. Just give it another shot. You just I don't know if it's having connection issues or whatnot, but try to give it. It was great, then suddenly it wasn't great. I'll say give it another try if possible. Yeah, it's a crappy platform. It's one of those lowest common denominator things. So it's kind of hard to call a software engineer a boomer. Welcome. I hope we connect. Dang, this is... Well, shit. Yeah, crap. This has been several days in the making too. Yeah, just as it was getting interesting. We're still working on this. It's not like we don't have an hour to get it all worked out. Shoot. Let's see. Alrighty, well, that's for some reason it looks like it's not wanting to connect. Darn. Ugh. Well, shoot. If you can, I know you're listening, Jason, but keep trying to get it a connection. I really want to talk to you. This sucks. Chat is going well. Maybe try it without the video. I don't know. What the hell? What do I? You're the software guy, not me. I'm not giving you any advice. I love chat. It's like, yeah, software engineer guy is being told how to handle his software, but we know. Yeah, YouTube has been squirrely the last couple days. Law and Cuck has been squirrely with this trial from day one. I mean, the first day it was really horrible, and now adding into the mix my internet going through an upgrade process as we speak. Apparently, see what we can do, Jason. If you can come back with audio. I wish I had a way just to do like a call in. All right, damn, it's just not even connecting, is it? That really sucks. That blows. It connected really great there at the beginning, and then just suddenly didn't want to. But let's. I still have you like on here in the background if something works out. Or let's do this. We'll kind of have. We can watch the little buffering thing here and. Jason's tweeting me, did I get cucked by StreamYard? Seems like it. I'm just assuming that your internet is good, your connections are good, and it's just StreamYard. StreamYard, it can be stupid sometimes, especially on a phone. I don't know if you're using a phone or if you're using. It seemed like you were using a desktop, but YouTube is really, StreamYard is really squirrely on a phone, but I don't know what you're using. Yeah, test on Apple phone. It won't let me type test. Test? Seriously? I hope that's test. That's weird. Thanks, Jillian. That's kind of strange. Crap. I'm gonna boot you here again and keep trying to come back as long as you can. I don't know what your lunch schedule is, but this kind of blows. But anyway, like Jason reached out to me and said there was one of these holy crap, I worked with this dude thing. And we've been setting this up over the past few days. Yeah, Brittany, that's what we've done 3 times already. No worries. We've got this all handled. Yeah, other sites seem to be working fine, so it's just the stupid StreamYard thing. Well, shit. Because I mean, that's the problem. Is it's really dumb. StreamYard is idiot proof. StreamYard is absolutely idiot proof, which means it's sort of the lowest of the low, and that sort of has its own problems. And well, we got the name this time. We got the name Jason coming up, so that's an improvement over just a random circle going through. But he reached out to me and he was going to tell me some of the stories about working with him, what he knew, what he thought about when he saw this here. Alan, I have zero capabilities for handling call-ins or even knowing how to begin to do that at this point in time. That's not something I've ever done, ever looked into, ever considered. So what's a South Korean drink, non-alcoholic, that you suggest trying? Milkis, if you can find Milkis somewhere. That's about it. I mean, there's nothing really else I think you would find it. I don't even know if you can find Milkis anywhere. Any drink, any Korean beverage you find, go for it. Rose says, thanks for trying, Jason. We're not going to give up yet. If anybody can figure it out, IT guys can. I certainly can't offer anything useful. This is never been a problem. It's just, whatever. You can go through, did you try turning your computer on and off again? Did you wiggle the wires? Did you unplug everything? Oh, Flux says it doesn't even let me go to the payment for supers. YouTube is screwed up. They did an update a few days ago, and it is just really annoying. It's screwed up a lot of things in the past few days. Yeah, IT crowd, turn it off and on again. He's probably swearing and throwing things at his computer for people saying, "Did you lick it?" That's probably the best. That's probably the best deal here. But I hope we can get this thing worked out, because dang it. If not, hey, there's always tomorrow. Yeah, the fix for everything electronic, yeah. Okay, now, all right. Here's another attempt. We have incoming. We've got Jason. We've got the buffering circle. And again, wow, this is just stupid. Literally the first person that has ever had a problem joining with StreamYard. And today of all days. Well, Jason, you are welcome to try as absolute many times as possible, as many times as you could want to. Let me try something. First of all, hang on here. I have to see if I have any super chats to read here. I'm going to restart my StreamYard and see what that does, because now I'm not even seeing the emoji things that you guys are sending here. But see, it's like weird. Flux can't send super chats. Jillian has said that apparently test on an Apple phone, it won't let her type test, whatever the hell that means, or test or tist or tast. We got that super chat. So we've got super chats coming in, but hell, I don't know. Give me a couple of minutes here I had a list of these starred statements and things that I wanted to read and go over during this hour-long break. But I'll just have to take a picture of it and then read from the picture. But first, we want to make sure we get the super chats out of the way. Then I'll restart it. Then try to jump back in. If I was a juror, I would not. Okay, okay. If I was a juror, I think not putting a defense on would have at least subconsciously influenced me. They're definitely discussing in deliberations. Well, the jury instruction is going to be very, very specific. That the state has the defendant has no obligation to put on any defense whatsoever. The entire burden of proof is on the state, and that you should make no inferences whatsoever from a defendant exercising his right not to testify. That's that. Let's. Oh, okay. Whoa, look at that. We have a clear connection.
Yeah, that was kind of obnoxious. I mean, I wouldn't be surprised because my ISP here is kind of garbage. But there's another one apparently coming in because they were laying down fiber a couple months ago. So
Oh, cool. That's good.
Yeah.
So where we were left off, you worked in the same company as the guy. How many did you work with him regularly, or just meet him at like company get-togethers? Or
no.
what was
I
your
work
interactions?
so at first I didn't work with him regularly because I wasn't an R&D, but when I became a software tester I did because he was a developer and I was a software tester. So yeah, at that point I worked with him quite a bit. So
And I mean, generally, what kind of a guy was he? What kind of vibes were there?
seem like I said, it's kind of cliche. I think I might have said that before I cut out, but it's like didn't get the stabby kind of vibe from the guy. Even when drinking as well. So I don't know if it was just kind of a alcohol plus women equals stabby McStab face, or
Could
what,
be, yeah.
But like I said, I mean, I drank with him and his ex-girlfriend and wasn't getting anything too crazy. So
Wow. So I mean, to me, just looking at him, seeing his demeanor, he seems pretty soft, pretty beta kind of guy. Was he just like quiet that way, or did he have the bravado thing? I don't know.
I mean, he was kind of quiet. I don't know if I'd necessarily say he was a beta, but I mean, and to be clear, it's not like I hung out with him outside of work or really got to know him on a personal level, because I'm sure you guys have all sorts of people coming out of the woodwork. Oh yeah, I really knew this guy, and then plot twist, they didn't. They just want 10 minutes of fame or whatever. So just to be upfront, it's not like oh yeah, I really knew the guy. No, I worked with the guy. I didn't get any kind of crazy vibes from him, but
and no, I mean, from with that regard, I mean, you just literally just sent me a tweet saying, "Wow, I used to work with this guy," and I'm like, "Well, seriously, what?" And then we got a few bona fide checks just to make sure, and said, "Hey, I want you to come on here and talk about this because this has never happened to me before, and the chance of it happening again are probably pretty darn slim." Where someone says, "Hey, I know this murderer guy." Now, I mean, I don't think of how to ask the question. I mean, were you surprised the first time?
Yes. I actually kind of was, because like I said, I drank with the guy, and then once like, oh, he was in a drunken, stupor or whatever and got stabby with his ex. It's like, huh, yeah, that's kind of interesting, I guess. And then this time it's like,
yeah,
well,
what about this time? I mean, that's where I was going with the question is, okay, so now suddenly, I mean, did you know about it before, or did you find it watching this, or?
Yeah, like I said, I knew about it before. It's just I didn't follow the trial because it wasn't, televised like this one is. And actually, I was kind of surprised, because I did hear about this, but I didn't realize it was gonna be televised. And then I saw, YouTube had your thing on. It's like, oh, Jeff's covering this. Well, that's kind of interesting. Huh. All right. But so first time surprised me, second time it's like, guess I'm not surprised, assuming the jury was correct or whatever in the first one. But of course the other interesting thing too is it's like, oh, it's a capital. Well, I don't know if it's proper to call it a capital case or not, but it's like potential for death sentence. It's like,
it's capital murder trial.
Sweet. So I guess I worked with the guy that might go on death row. That's kind of an interesting thing to throw in the old stats book, I guess.
I mean, just for you, there's not too many of those in your life, but
no, this is definitely the only one.
When did you first find out about this second stabbing?
Oh, geez. I think it might have been like May or June time frame.
Okay.
It just kind of dropped off because obviously, like has been mentioned, sounded like he waived his right to a speedy trial.
Yeah.
Because I think this
it happened
what,
in May.
April?
And,
it did happen in May. Okay.
It was like I think it was in May. Yeah.
Yeah.
But still, so it's been a very short time since.
So
this happened.
yeah, because actually another coworker I think told me about it, and I'm like, oh shit, and he actually
What
her.
was
Okay.
that was the next question. So you do find out, okay, he's allegedly at this point, for at least for the next few hours, has stabbed someone.
Yep.
Again, in pretty much the same way and under the same circumstances. I mean, what were you thinking about that? I mean, was it just like a holy crap, or was there an actual I saw that coming, didn't see that coming, or what, he did it again? Walk me through just what you were thinking.
It probably is fucked up as this. Hopefully,
no, go ahead.
Hopefully,
we're
swearing
well
isn't. Yeah. Fun fact: I used to before going to IT, I used to go to a maritime academy, so I do have some sailing experience, so to speak. I was on the engineering side though, but yeah, as fucked up as it sounds, it was just kind of like, sort of. I mean, it was kind of interesting, but it's like I didn't have feelings one way or another, I guess, if that makes sense. It's just kind of
it does. You're like, oh, okay.
Hey,
wow, everybody's playing with new.
Hi.
Oh, hey, cat. What kind of cat is that? That's beautiful.
Mix. I don't know. All our
Wow.
cats are
Cool pattern.
rescues or whatever. But say hi, Amore. Yeah, she's like, get lost.
Okay, I was wondering. I'm just getting boxes from chat like this, and apparently, this is the first I'm seeing about it. YouTube has unleashed some new emojis, and everyone is playing with those. I don't even know what they are, because this is how it looks to me, guys. I have to actually go into the YouTube analytics and open up the little analytics screen to see what this looks like.
The tiny little boxes or whatever.
Yeah. Yeah. I guess this StreamYard has to figure out what to do with it. So for the
StreamYard's
foreseeable
like,
future,
what
I'm
do?
just seeing boxes. So what's been the communication between you and the other colleagues that worked with the guy? I mean,
Really?
the general feeling.
Really nothing too much. I mean, it was just, like the extent of the activity was just the alumni, Facebook group or whatever, where the guys like, well, I don't think you saw that one, but guys like, Matt Terry's in the news again.
So, I mean, it doesn't from the chats that you've sent and what you're just saying now, it doesn't sound like there's actually too many people surprised by this.
I think that's the general consensus at this point. It's like, okay, Stabby McStab face is at it again or something.
He stabbed one girlfriend. Looks like he did it again, allegedly.
Allegedly. Something presumption of innocence, something.
Yeah, so I mean that's got to be wild. I mean, not every day. Oh, hey, wow.
Yep. And don't hold me to this, but I think I do seem to recall he might have had a teenage daughter as well, at least back in 2015. I think. Now, I'm not sure who the mother was. Obviously, it's not, Michelle Rogers or whatever, but
she does have kids with him.
Right, yeah. But I think he did have like a daughter from a previous marriage or something. But don't hold me to that. I just seem to recall hearing him say something about that at work. But again, this is 2015 or whatever. And just as a random bit of trivia, we're actually doing a stand-up at his desk. So basically, for those who don't know, stand-up is basically like you just get a bunch of people together, kind of talk about what you're working on for, at the time or whatever. So anyway, we were doing a stand-up around his desk or whatever. And that's actually when one of our sea levels came by and company sold. So found out about the company changing hands, doing a stand-up at his desk. So just random bit of maybe interesting trivia, maybe not. I don't know, but
okay, we'll just do a little mid interview thing here. We got We got 534 people here now. People are taking a break for lunch, whatnot. We're going to be back in, looks like about 35 minutes. The court should be back. So for those of you just joining us, just waiting, the court's on a lunch break, and we have Jason here with us, who has worked with the defendant in Michigan, and we're just kind of getting a little bit of insight because we have the opportunity, so may as well take it. So here's a good chance for the chat. Chat, if you guys have anything you want to ask, go ahead, and we'll throw the questions up.
Chat's probably like, this guy looks like a goon.
The biggest question so far has been, did he ever get angry? Was he easily angered?
Like I said, I mean, when I worked with him, me personally, I never saw him get angered. Obviously other people had concerns about that, but for whatever reason, I never saw it. So
we do have some advice from chat. WW is Walter White. Go get him. Jason, aka Hank, is was he too quiet?
I wouldn't say he was too quiet. I mean, but
so from what you know, he was just ordinary dude, just the dude in the office.
Yeah, he's definitely quieter than me, but of course I'm just a loud, abrasive asshole. So I think most A1's, quieter than me.
Was he as creepy as he seems?
No,
it doesn't sound like anybody had any weird vibes about it.
No, like I said, I didn't get any weird vibes. But I'll tell you what, though, dude doesn't look like he aged a day since I saw him last. It's like, holy shit, does this guy fucking age? What the fuck?
Well, he looks like he's dropped about 60 pounds since his.
So he actually, like I said, I mean, that's about what he looked like when I worked with him. So, people are like, oh, he lost a lot of, looks like he lost a lot of weight. I'm like, well, shit, that's what it looked like when I worked with the guy. So, I mean, unless, he just put on some pounds in prison or before going to prison, or I don't know, but.
When was this killer in the Marines? Was he still involved with the Marines?
No.
Was there a story?
I don't know exactly what he was in. I did know he was in the Marines. I can't remember where he did, but I seem to recall, because I mean, if you're in the military, you have a tendency to talk shop with people, even if you weren't in the same branch or whatever. I was Army Guard, but as I seem to recall, he did something with like something for like improvised airstrips or whatever. So. Again, don't hold me to that, but I seem to recall him mentioning something about that at some point.
Yeah, the pictures of the truck, the vehicle show him he's rocking the Marine Corps license plate and thing. So
yeah. He was there. There's no he was definitely in the Marine Corps though. Yeah.
You ever offer food and say, "Don't just stare at it, eat it"? Okay. So if I shave my These are random questions too. So if I shave my head, will I get more women liking me? I'll tell you, it didn't hurt when I started shaving. It did not hurt me at all.
Yeah. What was this thing you mentioned? Because I mean, obviously, as you could tell, I also like to shave my head. Otherwise, it just gets large and obnoxious, and it's just easier to do this. I mean, in my case, I just bick it. Trim it down if I do let it get long, and then bick it. But you sound like you used a particular razor or something.
Yeah, it's an electric razor. It's like a forehead electric razor called the Pitbull. It's a Pitbull Platinum is the one I use. It's like about $300, but it was the best $300 I've ever spent in my life. It gets it. I mean, I hate the electric razors. I can't use them on my face because I have soft and delicate skin, and on the head it doesn't work. But this gets it so smooth that it's like it feels like when you shave your head in the morning and then just before you go to sleep at night, it's kind of starting to get a little. It'll shave it that close to give it that feeling. So I highly recommend that thing. I've changed the blade once in a year and a half.
Oh wow, ladies and gentlemen, this stream brought to you by Pitbull.
Seriously,
sorry.
Bring that up. Was he a team player or a loner?
Seemed like a team player to me. Now,
so this guy is just like a normal guy, and nobody saw this. There was nothing to trigger this.
One thing that was brought up obviously not here, but that I actually forgot about was after the company did change hands, he moved from dev over into kind of an ops position because I guess he wasn't getting along with some of the management at that time. But again, that was after the company changed hands because 2017. So the company will have changed hands, and that was around the time when he got stabby with his first ex. So.
All right. Oh, and Flux, who is also a former service member, what if any type of things did you talk about? What did he talk about? I mean, was he just like legit a regular dude?
It seemed like it to me. Now, of course, I'm certainly, not the kind of guy where it's like, oh, I can sense your aura and figure out all that's wrong with you. I mean, that said, if you're kind of a creepy fuck, I'm probably going to be able to read that, but I didn't, get that feeling from him. So.
As a former Marine, was it too many red crayons in his diet? Could have been. And again, you probably don't know the answer to any of these. I mean, how did he take criticism or suggestion?
I mean, like I said, I was a tester and I tested some of his stuff. So whenever I found something, I didn't nothing too crazy, in response to critiques or whatever, saying, oh, this thing's needs to be fixed or whatnot. So.
Wow. So literally, this is just like a guy who snapped really hard twice.
Yeah, and like I said, I think it must have something to do with the combination of alcohol and jealousy, because otherwise,
Well, I mean, this is an interesting thing. This might be something that can be used as a mitigating factor in the penalty phase, assuming he gets found guilty.
Right.
Because they're going to do the same thing they're doing with Daryl Brooks right now. They're going to have a penalty phase where they bring in the victims, and they'll bring in other people to testify for or against the person and say why they think they should either be reduced in punishment or so he could, I would guess, bring people from his past that would say this just isn't him. He just panicked. He just freaked. He just flipped. Some of the people from the old company maybe asked to testify on his behalf, whether they would or not. I don't know.
And obviously I could be the like the odd man out in all of this, and everyone else is like, oh yeah, this dude was creepy as fuck. What the hell are you talking about, Jason? Crazy ass motherfucker. I don't know, but that's just my take, obviously. Of course, I don't know how many people from the old company, watch your stream, but
yeah, one at least.
Yeah, me, the guy that's on here right now.
Yeah, apparently one person here. So that's good. But so I mean, like I said, this is something that could potentially be used to argue against a death penalty and for life imprisonment without parole. Just getting a bunch of people saying, no, this wasn't what he was like.
Basically, just character type witnesses, or what, assuming that's the proper term.
Yeah.
For context, basically every time I've been in court, it's all been civil stuff, more specifically FOIA or firearms related, suing the government. So, yeah. But yeah, so I don't know how like the criminal stuff really works at all. Although I guess I could ask my buddy, since he just passed the bar and he's getting sworn in next week. So I will say, yeah, alcohol.
Jeff doesn't know Patrick Bateman. Well, there's an idea of Patrick Bateman. Yeah, American Psycho is a great movie. Yes, I do know. Anyway, so moving right along from people challenging my knowledge of film. Shame on you. Jason has a nice voice.
It's funny because at the new company, I apparently got picked up to. So the team I'm on, we do monthly trivia sessions, and actually we just had a cross-team trivia session, and I got picked up to host those because of my voice, apparently. Even though I like to joke, I've got a face for radio and a voice for silent film.
Legal Vices, Daryl Brooks doesn't get to argue for mitigation factors. He's facing 6 mandatory life sentences without parole, no matter what. Well, yeah, it's mitigating. I mean, the mitigation that could happen in Daryl Brooks is kind of laughable. I mean, he's facing the
Grounds.
He's facing the sixth. Sorry, I'm just getting like friends texting me at 2:30 in the morning. Go to sleep, degenerate. Yeah, he's facing the sixth life term, minimum mandatory. I mean, he's going to jail forever and ever and ever for 6 deals. But he also gets a certain number of years for the 61 other people he injured, or 66 other people, however many other people he injured. So it's going to be like 6 life sentences plus like 900 years. And he can put on people that will say, no, he was a good guy, which may get him 6 life sentences plus only 700 years. I mean, and that's kind of the same thing that's going to happen here. But here, there's much more at stake. Is he going to die, or is he just going to spend the rest of his life in prison? And yeah, go ahead.
I guess a question that I had, and I'm fortunately in the position that I can ask this. So like, how does that work? I mean, because obviously it sounds like secondary could be brought on, it was a crime of passion. He got jealous and a drunken rage and killed her. Is that something that automatically goes to the jury as part of an instruction, or how does that work?
The jury instructions are going to come soon, and that's just, did he do this? Is he guilty or not? But in the penalty phase,
okay,
it will be. Well, I guess they could technically find him guilty of a lesser offense, like a 2nd-degree murder instead of a 1st-degree murder. But
that's what I'm talking about. Second
degree. But they didn't
versus
put
first
any
degree.
evidence on to show that it was a crime of passion. So probably they're saving it to get his ass off of death row. If they have anybody that's willing to come in and say, he was a great guy, he was a fine guy, he snapped, this is so unlike him, they're probably saving them for the penalty phase to say, so therefore this was just a crime of passion, it was just a fluke thing. He's only stabbed women in the neck twice. We shouldn't put him to death. We should just put him in jail for the rest of his life. Oh yeah, that's nice. Thanks, guys. That's slanderous. Every film before the 1930s. Yeah, whatever. Jeff telling other people to sleep. Yeah, I know. People are just throwing down movie quotes here. What is your schedule? You gonna get back to the office?
Yeah, I got a couple more minutes if you're interested in entertaining.
But does anybody? He's literally left his office to go home to do this at lunchtime. So.
Yeah, humorously enough, I was originally planning on being home today and in the office yesterday, but that kind of flip-flopped. But it's like, whatever. I mean, the office is only like 10 minutes away, so.
I'm not going to ask that question. So anybody else have any other questions that you want answered other than balls or no balls?
Okay, that's funny because my buddy was messaging me on Discord. He's like, dude, chat's asking balls or no balls. I'm like, I'll let Jeff bring that up if he wants to.
Well, go ahead. Balls or no balls?
Balls?
Okay. There you go. So he's answered. Let's move right along. Was he fired? He went to jail.
Well, yeah, I mean, he was fired or released or whatever the HR-esque term is when your employee gets thrown in the clink for stabbing his girlfriend. But yeah, he was still at the company when he got arrested.
What is your favorite network protocol?
What is my wow, okay. That's kind of an interesting question. My favorite network protocol. Let me throw people through a loop. I could just be like OSPF. Congratulations, now you have a routing protocol. How about that? Yeah, I don't know. TCP/IP. Yeah.
I got no idea what you're talking about, so.
I'm not really a network. I mean, I know enough about networking to make myself sound like a clown, but yeah.
Well, you could say anything, and I wouldn't know if I was being a clown or not. What was your first reaction to him stab you? We asked that already, but we'll answer it again. Why not?
I'm presuming this is in regard to the Michigan stabbing, which I was like, that's kind of surprised. And then this time it's like, well, okay.
Tony G being funny here. All I hear is 110110010, etc., etc.
The nerds are congealing.
I understand the hell out of this. Well, good for you. Yeah,
Wait,
TCP/IP. I've heard of that one. I've heard of TCP/IP.
And it's funny because I think it was like one of the first Maritime Mondays that you did. This is actually like right before I changed jobs. Because I know you also got some guys that are actual licensed merchant mariners that watch as well. Because I know a couple of us were, obviously I transferred out and decided to go into IT, but I knew there were a couple that were licensed and we were just rapping about various stuff in the chat. So you got an educated crew watching.
So there you go. Jason just outed himself as a longtime viewer of the channel here.
Oh my!
Perhaps he will let you know who he is in chat one of these days if he deems you clowns worthy.
If people were, I think it was yesterday, like right after you got done with Maritime Monday and like right after the cutover, there are some questions that I answered. When I start getting back in chat, if I type, whenever I type something, I'm sure I don't think there are a whole lot of Jasons in the chat, so it'll probably be easy enough to figure out who I am.
God, is it Brandon? No, if it was Brandon, I would tell him to get off here and start super chatting me. If it's old Brandon dropping $100 super chats like they're going out of style. Jason is Corn Pope. Nah, he doesn't look like her.
No.
Corn Pop, maybe, but we don't know. All right. Oh, this is not a bit. This has been asked a few times.
Wow.
Are you single, and also will you marry me?
I can't say I've ever been asked that on.
We've had lots of Jason's cute. Is Jason single?
No, I am not single.
Sorry, people. Thank you for playing.
I need to get a soundboard like that.
It's just lame. But I just throw it in there whenever I think so. All right, that, ladies, is how you get stabby. Nice, X-Carmen. That's good. Well, we're about 20 minutes away from getting back into trial and about 20 minutes away from you getting back to work.
Yeah,
I want to make sure you get some lunch.
Yeah, and I think the name of the chat should be the I don't know who came up with it. I don't think it was me. I think it was someone else. But the compassionate degenerates.
No,
that seems to sum up the chats because we're a bunch of fucking degenerates. There's no doubt about that. But we're compassionate at the same time.
Yeah, we would be the Vice Squad, the compassionate degenerates.
And you totally need to have pass or smash for witnesses. That needs to be a thing.
Yes,
that's your shtick now.
That's a thing, unless it's just clearly obvious.
Yeah, like blood spatter. No. CSI Busey.
Yeah.
Yeah. I'm not even gonna go there just in case someone recognizes me and they decide to give me.
Poll every witness. Okay, but
exactly.
I guess we have a lot of women. Perhaps the women want to answer those questions, or the guys can too. Whatever. Hey, we're cool.
It's the 21st century. It's a modern age where the men are men and the women can be too. Apparently.
Yeah. And let's see. Sean Walters says I'd usually try to make up some screwed up joke at this point, but I can't disagree with that name for us. Oh well, there we go. And. Jason, it's been awesome having you. This is like a once in a billion opportunity where someone says, "Oh, that dude that just stabbed everybody, I worked with him."
Yeah. No, thanks for having me on. Obviously it's kind of fucked up because at first I'm like, should I do this, or people just think I'm like some self-aggrandizing asshole that's looking for 50 minutes of fame.
I told you to come on. You didn't even offer to come on. You said, "Hey, I know this dude." I'm like, "Seriously?" And you sent the receipts, and I went, "Well, come on,
come on down. You're the next contestant. And The Price is Right."
Right. Is there anything else we should know that you want to say about this guy that you've been waiting to get off your chest about this whole thing? Where are you sitting? No. Is he guilty?
I honestly don't know. I mean, based on the previous things, it's like it could happen, but
If you were a juror, would you vote guilty or not guilty? I'm totally guilty.
The blood is probably the most solid piece of evidence there is, but up to that point, it's like there could be reason. The thing I'm curious, it's like, where the hell did the knife go? How the fuck did he ditch the knife?
We had a couple of hours to do something with it.
True.
It's Florida. Alligator could have eaten it. I don't know. Well, Jason, thank you so much for being willing. I mean, it's got to be weird for you to be here and be doing this, but deeply, deeply appreciate it because that was like way cool to get someone that actually knows someone involved in this trial. Deeply, deeply appreciate it. And anytime you know anybody that's a murderer, let me know, and you're welcome on. And it's great having you in chat.
Yeah, and if you ever want someone that knows Michigan FOIA and firearms law, I can send my buddy your way if you're ever interested. Because, like I said, he's getting admitted. I mean, he already got his bar results, but he's getting sworn in next week, so he'll be getting his P number then. So,
well, and if it was in Wisconsin, apparently it'd come in very handy because they just seem to shoot and eat people there all the time. So, and it's in his neck. Ouch. All right, enough speculation as to which particular orifice the knife is hidden in.
The prison pocket.
Yeah. Again, thank you so much for being here, for being willing to come on and to share what you know, and just to listen. Apparently, he's just an average dude doing an average thing that gets upset at certain life situations. We'll let you get back to work and keep us on in the office.
All right, have a good one.
Thanks a bunch, Jason. Deeply appreciated. Chat. Tell Jason how awesome he is. He'll be looking and reading and hopefully still watching from the office or listening.
Oh, I will be. All right.
Take care. Have a great day. Thanks, bud.
Yep.
Appreciate it. I don't know. I think that was pretty darn cool. For those of you that are just joining, that was Jason. Jason used to work with the defendant, Matthew Terry. He sent me enough receipts that was actually a case. That was actually the case that I invited him to come on. And so, I mean, he was sending me like chats with old office people saying, hey, some of the internal stuff. So, I mean, that lets me know. So that seemed like the real deal, and we deeply appreciate him. He's a regular member of the chat, and he just out of the blue said, "Dude, I know this guy," and that's what started it. So I said, "Hey, let's get him on here." A couple more things, and then we can kill some time with Brooks, so to speak. Yeah, lol, how you froze? Yeah, I'm well aware of that. I wonder if being on TV, asked Vince Clortho, makes judges nervous. Probably not. I mean, maybe before, but judges have been on Zoom for the last 2.5 years. And nothing seems to make this judge nervous. I mean, by and large, by and large, I think they're pretty used to it. So instead of bringing it up again, let's knock it down there. And these are just a few of the comments that I was noting that I thought were kind of interesting and maybe wanted to bring up. Okay. Ms. Construed says, I really appreciate when Legal Vice said, hey, to Steven saying a cheap donation, but a good donation. If I donate $1.99, it's because I appreciate Jeff. That's what I can afford. I'm not a pricey lawyer. He wasn't saying it to be condescending Steve is one of the nicest guys you'll ever meet. But he is on other LawTube people who require a minimum amount of super chat for engagement. And I just don't do that. Other people do it. Hey, cool. That's for them. The super chat has to be at least this much or I'm not going to answer it. Hey, like I said, I don't, it's not mandatory to talk to me. It gets you to the front of the line. But it's not mandatory. There's no minimum amount. It still freaks me out that so many of you throw your hard-earned money at me. And if to some people, a $500 super chat is utterly meaningless. To others, $1.99 is too much. And so I deeply appreciate anything that you guys send my way. And that's why I read everything and everybody equally. I don't even prioritize it from most expensive first. The only ones that get bumped are the $100 and over because that obligates me to drink and I want to get it quickly. But I don't prioritize according to amounts. It's just the order it comes in. Everybody's equal. Just the $100 super chats and above happen to be more equal than others. So yeah, again, thanks to Jason for coming on. That was kind of interesting and fun. Yes, Steve is a great guy. He didn't mean anything by it. I just think he didn't know where I stood on super chats. Sean Walters, just a map nailed to the wall. If at Legal Vices falls asleep before he ends the stream, I think that's what we'll get. Well, what I think I'm going to do, I mean, it's 3 a.m. here. We're coming up on 3 a.m. I bet we'll get through the closing arguments. We'll get through the closing arguments, and then I'll just end it. If the jury comes back today, we'll review the verdict tomorrow. If they come back tomorrow, we'll review the verdict tomorrow. So I'm thinking as soon as they finish the closing statements, which I can't imagine being more than an hour or so. I can't imagine even being that long. Then we'll just cut off the stream. If I happen to be still awake, or something like that, I'll leave my phone next to my head, and if people tweet me, it'll alert me, and then I can come back or whatnot. But I'm not going to stay awake and stare at a blank screen and talk to a blank screen for 5 hours, hoping that they come back. So we'll end the stream as soon as the jury goes out to deliberate. And if they come back today, and if I wake up, I'll start the stream again. If they don't come back today, we'll do it tomorrow. Or if they come back today and I don't wake up, then we'll just do it tomorrow anyway. How long will closing arguments be is the next legitimate question. No idea, but if the opening statements are any clue, the closing arguments, like I said, I'm guessing an hour tops. It's just going to be the prosecutor, and then the jury's going to get up and say they didn't prove their case. Use your common sense, have an open mind, yada, 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 and they'll be done. I'm guessing an hour. That's it. But I could be wildly wrong. It could be 20 minutes. It could be 16 hours. I just don't know. MG Law, Legal Vices, you think we are going to get a jury nullification mentioned during closing? No. The defense lawyer would be crushed by the judge if she even hinted at possibly making a jury nullification argument. Lawyers don't get to do that, and the defendants shouldn't. Alan Walsh, Legal Vices, one of Tug's mods gifted 10 memberships on Saturday night, and YouTube never gave them out. She was charged for them. Well, that sucks. Well, crap. I don't know what to say about that. Julie O says, that's why you're the only channel the only channel that you're a member of? You're a class act, dude. And Steve is great on all channels I've seen him on. Yeah, Steve needs to just do this as a hobby. It's he's a great guy. Sean Walters said, I forgot about that. It was a while ago. I just think, I think Just a Map said something about you were going to stream until we get a verdict. Yeah, that was the plan, but I'm thinking I'm gonna be tapping out before too long. Heidi Peck, see this thing. Heidi Peck says, we love you, Jeff. Unfortunately, I'm not in control of the money, so I can't send it. I don't expect anyone to send super chats. I mention it as an option. I don't beg for super chats. I don't grift for super chats. The only thing I grift for are likes and subscriptions. And how are we doing on our subscriptions anyway? I was trying to get up to 300, 32,300. I haven't checked recently how we're sitting. Right now we are sitting at 32,285. 15 more subscriptions to get me up to 32,300. So let's do that. Come on, I'm sure 15 of you watching haven't subscribed. I would appreciate it if you would get down there and hit that subscribe button. Get me up to the 32,300 just because I'm a nice guy. But you definitely have my appreciation, and you're my face YouTuber. Elbow cough, elbow cough, elbow cough. No, I don't expect it. I don't beg for it. I'm not the send me your super chats. I got to pay the bills. The only time I ever grift for super chats is on what I affectionately call Fuck It Friday, once a month, usually the first or second week of the month, where we just go full on grift, $100 grifts, $100 super chats. It ends up with a shot of premium whiskey. The aggregate $100 super chats from the super chats that are below $100 gets a lesser quality whiskey. But that's the only thing, and it's all in fun. We just grift like crazy. I still owe everybody 8 shots from the last one, by the way. We will catch up on the shots from the last F-It Friday on this Friday, because there was way more shots than I could drink last time. I only got down 26 or 27, and I still owe 8 shots. So we'll get to those shots on Friday. Vince Clortho says, "Hold on, I'm not sure why we're holding on." Yeah, poor Jeff is exhausted. Yeah, no sleep till verdict. Well, it's up to you guys. I'll be checking out. I'll be checking out as soon as the case goes to jury deliberations. So I think that is all we have for the super chats to catch up on. Just scrolling up here to make sure. We got to make sure we get them all read. People hate it when I don't read super chats, and I think they should hate it if I don't read super chats. All right, looks like we're good. All righty, so we've got a few more minutes to kill. Unless anybody has any particular objection. You don't see a subscribe button on my phone. Could that be because I'm a member? I don't know. If you, I don't know. I haven't really looked at it for a while. Guess there's on there. There's on there. Let's see what my phone says. Find it. Probably because you're already subscribed, I guess. Weird. Anywho, someone that's got their phone in front of them can tell them better than me. Yeah, hopefully Steve streams more. If it's green, you're a member. Okay. Alrighty, with that, let's see what we can see in the Brooks trial. All right. We'll do that for a bit until the court comes back in a few minutes. Just kind of see what's up. Well, first of all, let's see where we're up with this court. Okay, we've still got the ceiling. They're still showing the ceiling tiles. Oh, and let's see. The Law and Cuck is doing their guilty, not guilty, or hung jury poll. I'm going to say guilty. And what is their... Okay, even Law and Crime, who usually gets these things wrong, are saying 95% say guilty, 2% say not guilty, and 3% say hung jury. Fun facts there. Let's bring up... Oh, all right. We got Darrell Brooks, who apparently still has his Bible there with him. Where are we?
And so many others. The hardest thing to hear is that she would have preferred to give her life for that of some other person who lost their life. For me as a mother, it is very difficult to be able to tell her that everything will be fine when at the time I was not behind her to protect her from everything that happened. I know that many will say overcome it already, but nobody knows what it's like trying to stand on your feet.
Long time
when
no
the
see,
world
Brooks.
has no floor.
Let me bump the volume.
I hope
too.
justice is done, and I am thankful to each and every one of you who has not left us alone. Policemen, doctors, prosecutors, angels, and all of those people who I could not name who were and are still here to support us. This is just the beginning for many of us, and it will be a long road, but I am sure of one thing, and that is that we will be able to get back up. Thank you very much. Waukesha, let's hug very tight because our children need us. Mother of Victim I. And this next one, they sent us some photos this morning.
Yeah, hope you're feeling like shit, Brooks. So yeah, this lady is apparently reading all of the children's statements that aren't there to testify personally. And for those of you just joining, we're just popping in here to Brooks for a minute. We'll go back to the Stabby trial when it starts again.
Thank you to the entire prosecution team for being so well prepared for this case.
And I will be right back.
Thank you to Victim Witness Assistance for looking out for all of us. My name is Donald Teagues, and I am the father of victim Q, or Eric Teagues. Both of my sons, Eric and Tyson, were marching with the Waukesha South Marching Band in the 2021 Waukesha Christmas Parade. Eric was a junior and Tyson was a freshman. They were there to play Christmas music for the people and start off the holiday season. That came to a quick end when you, Darrell E. Brooks Jr., drove through the parade killing people, injuring people, and ruining what was supposed to be a beautiful event. And we haven't been told when to do the photos, so Christy, if you can use your judgment, thank you. Darrell Brooks, you hit and ran over Eric along with some of his bandmates. Tyson, his younger brother, was just feet away from Eric when you hit and ran him over. Tyson witnessed his brother getting hit and ran over along with other bandmates. Tyson never left his brother's side during this incident. He even took off his jacket to help keep his brother warm while he laid in the middle of the street. He then had to call his mother and try to explain what had happened. As he stood next to his brother, he saw blood coming out of his ear, nose, and mouth, and his leg that was pointing backwards. He would just keep telling Eric he will be fine and that Mom was on her way. He stayed with him until Eric was taken by ambulance to the hospital. Starting that night, Tyson had nightmares and had them for a week. He would wake up screaming and crying. And what made this even worse is he couldn't go to see his brother in the hospital, and my wife and I could not be there for Tyson the first few nights because we were with his brother in the ICU at Children's Hospital. My daughter, who wasn't at the parade but went with her mother to the parade after Tyson called. She stayed with Tyson at the scene and at home when we couldn't be there. She needed to see a psychiatrist to help her deal with what she saw on the streets that day and seeing her brother lying there on the ground not knowing if he would live. She had to be in outpatient care for 2 weeks to help her through what she saw. Eric was an aspiring baseball player for the Waukesha South baseball team and a select baseball player for Styx Academy. He was making his final push to get better and wanting to be scouted by colleges to play in college at an elite level. You took that away from him that November day. He spent 9 days in the hospital. 3 of those were in ICU. Eric suffered from a skull fracture, a major concussion, a C4 fracture, right shoulder fracture, 4 broken ribs, a partially collapsed lung, T6 through T11 fractures, and a left femur fracture that required surgery. He is lucky to be alive. The C4 fracture could have killed him. The femur fracture could have killed him, or the broken ribs along with the lung collapse could have killed him. His time in the hospital was very hard, dealing with nonstop pain from you hitting him and running over him like he was a speed bump.
Ugh.
He had to lay flat for 4 days and wear a C-collar for 7 days because of the C4 fracture. He had a chest tube to drain the blood off of his lung so he could breathe. He had to undergo surgery to repair his severely fractured femur. On top of all of that, he was dealing with a severe concussion. He could not have any lights on or loud noises. He would have events of uncontrolled vomiting and would spike fevers. When he was finally able to leave the hospital, it was in a wheelchair, and he was in that wheelchair for over a month. We had to have a wheelchair ramp built for when we came home. Without the ramp, it would have been very hard to get him in and out of the house. My wife had to take off a month of unpaid leave from work. I had to take off 3 months from work to take care of him and get him to multiple doctor appointments a week. Darrell Brooks, you stated during this whole trial that you are a man, a God-loving man. You are not. A real man would have stopped when they saw they made a mistake. A real man would have admitted the wrong and would not have put all these families through this pain. A man of God would have stopped, admitted to his wrongs, and asked for forgiveness. You sat there showing no emotions for what you did and pretend that reading the Bible was going to help you. But you, Darrell Brooks, are pure evil that is not fooling anyone. You don't know God, but you better start learning because where you are going, you're going to need to start praying a lot. You don't deserve to see the light of day ever again. You should never be able to see your children again. It's too bad this state doesn't have the death penalty because you would be put to the front of the line. I hope you rot in hell, have a miserable existence in prison, and that someone teaches you a true lesson in asking for forgiveness.
Ugh.
The next statement is...
Again, we'll be going back to the Matthew Terry trial as soon as the people come back to the court.
It's been nearly a year since the Waukesha parade incident, and I know my friends, family, and myself still remember it vividly. Personally, I have an injury that could affect me the rest of my life. Doing normal things like carrying groceries or even my school supplies to classes have proven to be more of a challenge compared to what it used to be. And some mornings I'm not even able to lift my arm past my shoulder. It's hard, but I'm living through it because I refused a long time ago that I would have this man, someone who thought of no one and nothing past the incident, control what I can and can't do. I can't remember vividly what happened, just pain sparking up from the back of my head and my shoulder and people standing over me. It wasn't until I woke up the next day after everything and tried to stand up did I realize how much pain I was truly in, and it only got worse the following days. My progress in what I can do with my injuries over this difficult year has been positive. I've rebuilt most of my strength, but I've been told time and again from my family, friends, medical professionals, it may never be what it used to be, and to remember that this may be it. But that's only a possibility to me. Nothing is set in stone. Medicine is a practice because we never have all the answers. I was lucky to have family and friends who could help me physically, but nothing was permanent. All it took was a single thing to throw all progress out the window. If I wake up lying on my side, I already know that that day is going to be painful because simple things like sleeping hurt. Emotionally, the only constant support I've had is that of my friends and family. I've chosen out of my own free will not to see medical professionals for my mental state because I hold the belief that therapy is great and can do many great things for people, but what I do here and now has a bigger impact on myself. Putting a pause on my life to think about what happened to me and the people I know isn't worth it. I wake up at least twice a week to terrors of what happened, seeing and feeling the same things as that night and the days that followed. The endless possibilities of what could have happened, not just to me but others, whether I knew them or not, flood my dreams and scare me to my core. I remember my parents the day after. I had been dead asleep all night from stress and finally running out of adrenaline, to find out that they hadn't slept. My father chose to stay up in the living room where I had been sleeping to watch over me instead of recuperating himself. I may not have completely understood then because I didn't want to, but after a year of dealing with the outcome, I understand. Being who I am, I hide.
Nope, the court's still out.
Right after the incident, I remember
They're still having
friends
lunch.
coming up to me and seeking comfort, to which I had no problem with, but there would be triggers in what they would say that would bring me back. But I pushed it away to comfort others. Humor is the world's medicine, and like most traumatic situations in my life, I've applied humor to this now. I'm sensitive to who I'm with, but when talking, I try to think of something witty or humorous so that I can jump over the obstacle or burden of trauma, and to put it plainly, sadness. This past homecoming, my friends and I had gone to the dance, and one of my friends was driving us to eat afterwards. The place was on the far side of town, and the quickest route was through downtown. It wasn't their fault at all, but we were stopped because a group of people were crossing the road, and it was right near where I was hit, and I panicked. My vision went blurry, and I had flashbacks of the night. My friends had noticed and helped me through it, and we found a better route. I can't remember a time before having that bad of a panic attack where it's hard to breathe, and knowing the reason behind it is just another reminder I won't be the same, much like most people who were affected. During the time of the trial, I've stayed away from news on what's happening. I've overheard conversations with family members. Sometimes it's brought up within my friend groups, most of which have chosen to be understanding of my choices and move away from the topic. Mentally, this past month, I've had more terrors, not always while I'm sleeping, but when I zone out at school or at home. I never show a reaction because I choose to keep that in, but I do change in how I stand or sit, and I noticed I'm more jumpy around people after experiencing these terrors. Hearing about what happened within this case has been a stressful time for everyone in my family. I tend to not sleep as well as I normally do, even on good nights, and I find myself panicking over small things such as schoolwork more than I ever have. Thank you, Victim H. And the final statement from the band is from Victim K. At the time of the Waukesha Holiday Parade, I was your typical carefree teenager. As a 17-year-old at Waukesha South, I had only just begun my senior year, a time that some might argue to be the best year of high school. Sadly, that all changed in a mere instant. I was marching in the parade with the Waukesha South Band, playing the sousaphone, parentheses tuba, when Brooks appeared out of nowhere, plowing into me from behind. He dragged both me and my instrument upon the hood of his vehicle for what seemed like miles, before eventually running me over entirely. Luckily, I was swiftly rushed to Waukesha Memorial Hospital by an officer via squad car for emergency treatment. I was completely alone during this time and positively terrified. The ER medical staff was utterly shocked that I had even survived such a forceful impact. I suffered multiple injuries due to the impact, including ligament damages, deep tissue
All right, we are back
contusions,
in court.
and both a
So
sprained neck and ankle.
let's.
Post-evaluation,
Sorry, band
the
people.
doctors explained.
Let's hang on here. Oh, Brooks is being a dick. So all right, here we go. People coming back in the court and bigging him, and they're still quiet. But we're ready to go. And while we're doing that, we got a couple super chats here to get through. Julie, thank you so much. Petition to switch the state to Florida for Brooks. Yeah, it would have been nice if there was death penalty on the line there. I just have to say that's where Steve and I disagree. I think it should be used more. The Vault 7 Dweller, or the Vault Dweller. I'm not sure how he wants to say that, but I'm still let down that we were all bamboozled about the shock shackles. Yeah, on the Brooks case, we all thought that was like one of the main reasons we were watching, because we wanted to see him get blasted with a shock collar. All right, look, the jury is coming in. They're going to start the closing arguments. We are back. Wait for the jury to come in.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good afternoon. Welcome back. I hope everyone had a nice lunch. I think I know where some of you ate lunch. I promise you I did not follow you there. That's a regular place where I go to grab lunch at Publix. So, thank you all for being back. I do have.
All right, we got to boost the volume, I guess.
Exposed to anything about this case outside of the courtroom between the time that we broke for lunch and the time that you've returned by show of hands. Let the record
The jury instructions in this case aren't going to be very long, and they agreed to do them after closing.
Again, no hands, let the record reflect. Thank you all again very much. As you may recall from the opening instructions, after the attorneys have rested their cases, they have the opportunity to present closing arguments. I have one very brief instruction that I intend to read you before their closing arguments. Then after their closing arguments are completed, I have the more substantive instructions regarding the law that applies to the case. I also want to let you know that this copy of the instructions will go back into the jury room with you, and you will have it in the jury room. So I'm going to give you the first instruction before they give their closing arguments. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember,
Here we go.
what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Diaz, is the state ready to proceed?
Yes, sir. Thank you.
You may.
In the not too distant future, the group of you will retire to the jury room and you will have a chance to start your deliberations. I want to use this opportunity to talk to you about some of the things that you're going to be read by His Honor. He held up the packet of instructions that he's going to give you. We've had a chance to see those in advance, and so I'm going to talk with you about them. But obviously, the words that actually come out of the judge's mouth and the packet he actually gives you, that's the law. So this is the verdict form, and this is the way by which you ultimately tell us what your decision is. And so you may have come into this trial, although I think I addressed it on jury selection, if you remember back 2 weeks ago, thinking that it was either guilty or not guilty, and that's not exactly correct. So on the verdict form, you're going to see four choices. There's first-degree murder, that's choice number A. You're going to see second-degree murder, that's choice number B. You're going to see manslaughter, that's choice C, and then you'll see not guilty as choice D. These are arranged in a particular order for a reason. The highest level of offense is listed at the top, first degree murder, then second, then manslaughter, and then obviously not guilty. As we discussed during jury selection, you may remember my cheeseburger analogy or my hamburger analogy. And
This sound
this
is as loud as it gets.
comes
It's
into play,
600%.
okay? Manslaughter is the hamburger.
So can't do much about the sound.
Cheeseburger, it's everything that hamburger is, but it's got a little bit extra. And then bacon double cheeseburger is first degree murder. It's everything cheeseburger is, but it's got something extra. And so as you go back, you will be asked to decide which of these four options is the correct answer. And I submit to you that having heard all the evidence, including the testimony and the exhibits that you will have a chance to take back and look at for yourself, including the videos that you can watch again, you will apply the law and you will see that the only just verdict is first degree murder. Now, if you're looking carefully at this, you may see that there's also this other part about something here you have to check. During the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use, or he did not carry, display, so on and so forth. And we're going to talk about that too, because that's something that you haven't heard about. You'll get an instruction that applies for that as well. But it's very simple. You will go back, and when you reach your verdict, you will check either A, B, C, or D, as it says. And if there's one of these things that's an or, you're going to check either one or the other. That's it. That's how you ultimately tell us your verdict. So I want to talk with you about some of the rules that you'll get in a variety of places to help you understand the job that you're supposed to do before we even get to the question of, did the state meet its burden, which I submit to you we did. You will get an instruction, which will actually be one of the last instructions the judge reads you, and it's called submitting the case to the jury. It's 3.13. You don't have to write it down because, again, you'll get it. But the first thing is, there are no other laws that apply to this case. The judge has had the chance to review the facts and to address the law, and the packet has been created, and whatever laws apply, that's what's been given to you. So if at any point you find yourself back there thinking, well, like, is there some other law that plays in here? What about this thing that I think might be the law? Remember, we talked about this. Your job is to apply the law as it is, not as you think it should be, or it could be, or it would be.
Very
the judge
good.
is giving you all of the instructions.
Very good statement.
The next one is the verdict form. Let me zoom that out just a little bit. Okay? The state of Florida carries the burden. The government carries the burden. Right? The burden is beyond and to the exclusion of all reasonable doubt. But there's a trade-off for that. If the state of Florida proves to you that the defendant is guilty, you should, not could, not might, not may, you should return a guilty verdict if we have convinced you for the highest offense that has been proven beyond a reasonable doubt. And I return to what I talked about in jury selection. When the state of Florida has convinced you of first-degree murder, I have inherently convinced you of second-degree murder and manslaughter. That's the only way that can work. So I would certainly convince you of the lessers, but you find him guilty of the highest, which again is ranked very easily on the verdict form. It starts at the top. We prove first-degree murder. You find him guilty of first-degree murder.
Good statements. He's
You will
making
receive
good arguments.
Rules for deliberations, and I'll talk about some of these other ones, but I want to talk about this one first, number 5. Whatever verdict you render must be unanimous, which means that each juror must agree to the same verdict. That means that when the time comes to check the box on the verdict form, you have to all agree to check that spot, okay? But why you check it doesn't necessarily have to be unanimous. There is a question that you will ultimately have to answer for yourself. Did the state of Florida prove premeditation? And where and when did premeditation start? And that may be slightly different for all of you, and I will talk about that in a moment. But one of you may think it starts a little bit earlier or a little bit later. The only question is ultimately, do you think the state of Florida has convinced you the defendant had sufficient time to reflect before he committed the crime? And whether you think he had 3 seconds, 30 seconds, or 3 minutes, the state
Jury
has
nullification basically says we know the law says this, but we disagree with the law, so we're finding something
you may
else.
have slight disagreements. You know, you may think there's 7 wounds, there's 8 wounds. You may think that there's this wound is defensive and that wound isn't defensive. You can have these disagreements. The question is, when it comes time to check the box, are you unanimous? And if you're convinced and everybody else is convinced, you are a unanimous under the law. The next is this one. and we talked about this, whether the state has met the burden of proof does not depend upon the number of witnesses it has called, nor upon the number of exhibits it has offered. Now, I think in total you've heard about 31 people in this trial, and there's somewhere in the neighborhood of almost 70 pieces of evidence, not counting each individual photo that is, then clustered inside. But that's not the issue. The issue is the nature and the quality of the evidence presented. That is the issue. And I submit to you that on the nature and quality of the evidence that has been presented, the state of Florida has proven that this case did occur, that the defendant is the one who caused the death.
I need to go grab me some water. I'll
Did
be
so
right
with
back.
a premeditated intent. The state of Florida has met its burden. And so you may say to yourself, well, there's no eyewitness. And that's true. There's no living person standing there to say what they saw. But there is no requirement that there must be an eyewitness. You may say there is no video of the event. There is no audio recording of the event. And those things are true. There is no getting around that. But that is not the requirement. As I discussed with you, there is no formula for guilty. The state of Florida must convince you, and I submit to you the state of Florida has convinced you. It's a question of the nature and the quality, not the number. So I want to draw your attention first to 7.1, which is the introduction to homicide. And again, you're going to see some basic things that we've already talked about. The defendant's accused of first-degree murder. It includes the lesser crimes of second-degree murder and manslaughter. They're all unlawful. If you find that Kay Baker was killed by Matthew Terry, you then consider the circumstances to decide whether it's first, second, or manslaughter. And again, these are all things that we've covered, but we're going to come back to this instruction in a moment. So let's talk about what is murder in the state of Florida. First-degree murder has three elements. Very much like I suggested, there is, top bun, the middle piece of meat, bottom bun, sort of like hamburger, although obviously this has got more bells and whistles than manslaughter. There's three elements. The first one is Kay Baker is dead. You know that to be true. The state of Florida entered a stipulation that is in evidence. You will be able to take that back. The state of Florida and the defense have agreed that Kay Baker is dead. That element is met. There is no doubt there. Then there are two more elements. The death was caused by the criminal act of Matthew Terry. That's the question of identity. And there was a premeditated killing of Kay Baker. That was the intent element. And what you will see is the difference between all of the offenses is the question of intent. The intent gets a higher level as you move up. But I want to stress this because we talked about this. Killing with premeditation is killing after consciously deciding to do so. The decision must be present at the time of the killing, meaning you have to have decided beforehand. You can't decide afterwards. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period must be long enough to allow reflection. And I submit to you that in this case, premeditation starts well before the killing does. It starts before the first knife wound to Kay Baker. But premeditation lingers and continues on through every step of this murder. Every time the defendant makes the choice to again plunge the knife into the body of a woman, to slice her open, to cut her throat, to cause her to bleed to death, every single one of those is an intentional act where the defendant is again making a choice. I stabbed her once, it wasn't enough. Let me stab her again. That still didn't get her. Let me stab her again. Kay Baker suffers multiple wounds on the way to the one that ultimately claims her life. And each of those is an act of premeditation. But again, I submit to you that premeditation starts long before that. And we will talk about that in a moment. So, as part of the instructions, as I told you, you will also get an instruction about the use of a weapon. That thing where you have to check the either or option about did carry, use, threaten to use. That's this instruction. And you'll see this instruction repeated for each of the offenses, which is why on the verdict form, each of the offenses has that option to choose beneath it. This is just one I'm using for example. It's the one for first-degree murder. You'll see that the state of Florida has to prove to you the defendant did carry, display, use, threaten to use, or attempt to use a weapon. And if we did, you should find him guilty of first-degree murder. with a weapon. So you check A for first degree murder, and then you check did carry, use, threaten to use, display, or attempt to use, and that shows that it's with a weapon. That's what this instruction is about. You'll see that a weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design. I submit to you the weapon here is a knife, and you might think that a knife is typically used for in a kitchen to chop vegetables or maybe to chop up some chicken or whatever the case may be, but it's also any object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. So even if the knife in this case is a knife that would normally sit in a kitchen waiting for some chef to come along and use it for its normal purposes, the minute it's picked up and used as a weapon to inflict murder, it's a weapon. It's a weapon at least under the second option there. So I want to talk with you about a variety of things that you're going to see in the instructions, ways by which murder may not be murder, meaning a killing may not be unlawful. One of the ones you'll see is here. This is again in the introduction to homicide. You'll see the discussion of justifiable homicide. A killing of a human being is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant. That is a form of self-defense, right? Someone is trying to kill a person, that person can defend themselves. Matthew Terry was not resisting anyone's attempt to murder or commit a felony upon him when he killed Kay Baker, because Kay Baker was not committing a felony or trying to kill him. There's also the intent to commit a felony in any dwelling house in which the defendant was at the time of the killing. And I submit to you that yes, this case certainly started in a home, a dwelling house, but that's not where it ended. And so that section does not apply. There is nothing under the law that is given to you that says that this killing is justifiable. It's not self-defense, and so it cannot be excused for some justification. You'll also see this instruction for excusable homicide, right?
People
And
just
what you're
need
gonna see
killing.
over and
That's
over
one
are
of
the
the
words
justifiable
accident
homicides.
and misfortune. The killing of a human being is excusable under any one of the following three circumstances. Whether the killing is committed by accident and misfortune, which is not what happened here, in doing any unlawful act by lawful means with the usual ordinary caution and without any unlawful intent. So you don't even have to struggle with the usual ordinary caution and without any unlawful intent, because what happened to Kay Baker is not an accident. It is not a misfortune. It is an intentional killing. Whether the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation.
0.
We're going to get to heat of passion again in a second. But again, it's not by accident, it's not by misfortune, it's not excusable. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Well, first off, there is a dangerous weapon used. That's clear. The knife killed Kay Baker. That's a dangerous weapon. But even still, again, accident and misfortune immediately disqualifies this from excusable homicide. And so it's not justifiable. It's not excusable. You may look to the actual instruction for murder again, right? We saw the top part, and as you move towards the bottom, you'll see here, an issue in this case is whether Matthew Terry did not act with premeditated design to kill because he acted in the heat of passion based upon adequate provocation. In order to find the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, and I wanted to point out to you that A, B, C, and D all end in the words and, because it's got to be all of them. It's got to be all of those things to be excusable under the heat of passion theory, okay? So there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused the death, and Matthew Terry was in fact so provoked and did not cool off before he committed the act that caused the death of Kay Baker. And I submit to you, that does not apply. Whatever argument took place between Matthew Terry and Kay Baker on that night, what Matthew Terry did to Kay Baker was not what a reasonable person does.
Yeah.
It is not how a reasonable person reacts.
Really?
This is not a situation where a man comes home and finds his wife in bed with another man and his whole world disintegrates in a moment. Maybe that would apply then. But that's not what happened here. What you have is an argument that started at 10 o'clock and carried all the way until 12:30, slowly escalating. Multiple chances for the defendant to cool off. Multiple chances for a reasonable person to cool off. Nothing about what happened here is the actions of a reasonable person, and I submit to you that the heat of the moment, based on adequate provocation, does not apply. As we discussed before, you'll hear this. You probably, I think, heard me read these words directly. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. That does not say it is not a defense to first-degree murder, where it could be a defense to second or manslaughter. It's not a defense to any crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked the specific intent to commit any crime. Matthew Terry was intoxicated that evening. You can watch the video. You'll see him drinking. You've heard the testimony of the people who were there, who will tell you that he had clearly been drinking and he was clearly under the effects of alcohol. And you will see the medical records, which will tell you that after he stopped drinking somewhere at 11:30 and is found somewhere about 5 o'clock in the morning, almost 6 hours later, he's still a .072. Because he's had 5 hours to sober up.
Still almost
Voluntary
legally drunk
intoxication is not a defense.
5 or 6 hours after. Cool.
So I submit to you the question is, did the defendant commit this murder, and did he have the requisite intent? I return back to the instructions on murder. And I submit to you that he did. Was the defendant the one who caused the death of Kay Baker? He's the last person with her at the landing. He's the person with her in the car. He's the person with her that gets home. You can see their shoes kicked at the front door. You can see Miss Baker's phone sitting on the kitchen counter. You can see the defendant's phone and the keys to his car sitting on the nightstand in the bedroom. You can see the shorts he was literally wearing when he was at the landing that he's not wearing when he gets arrested, and they're sitting right by the door where he kicked it off. And if you look carefully and go look at the photos, you'll actually even see that Kay Baker got home and changed shirts. In the video, she's wearing a red t-shirt. When she's found, she's got a sort of purple camisole on. And if you don't think she got home, I will submit to you that go look at the photos from inside the house, and the thing that you'll see that hasn't really been discussed is the same thing that every woman knows. After you've been at work all day, after you've been out partying, first thing you get home, the first thing you want to do is you take your bra off, go look at the picture, and you'll see her bra tossed right on top of the hamper when she got home. Kay Baker and Matthew Terry got home. They're alone. There's no forced entry into this home. They are the last two people together 30 minutes before Kay
These are the
Baker.
closing arguments.
And the defense may suggest to you that somebody broke into this home and point to the window that is the screen pushed out. But that's why I took the
I wish
pain
Florida
to
had the
show
electric
you
chair still.
that the stuffed animal sitting on the floor comes from inside the bedroom. It's not out of the house because somebody is climbing out of the window. The stuffed animals that are by the window are not pushed into the room. They're still sitting on the bed where they belong in a kid's bedroom. They're pushed out because somebody went out the window. So Kay Baker and Matthew Terry are alone in a house with no sign of forced entry. There's clearly some argument that happens in the house that leads to not only the master bedroom door, but the kids' bathroom door both being damaged. I submit to you, Kay Baker is the person who goes out that window. She's a small framed female. She runs into her kid's bedroom, she locks her door, she opens a window, and she crawls out a window. Because she's trying to get away from the person that's attacking her, the only person that's in that house, that man. And that's why the front door is open. Because the defendant comes out the front door and chases her down. That's why Kay Baker isn't killed in the bedroom. That's why she isn't killed right outside the window. The defendant is taking the time to run around the house to try to intercept her. That's who did this. He's the last person seen with her, And when the time comes and he's found, he's literally caught red-handed. Red-handed because he's got Kay Baker's blood on his hands. The same hand that ran from Kay Baker, ran along the fence line, got to the edge of the fence, and first started to think about climbing into the bushes, and put his hand on the fence to brace himself. That's Matthew Terry and Kay Baker. That's his hand on the fence. And you might say, well, if he's right there and he's going to climb through the bushes, why doesn't he do it? Because if you look at the path, what happens next is Jonathan Figgins comes outside. He hears a voice, and not long afterwards, the lights are turned on in the backyard of Jonathan Figgins' home, and the defendant is standing at the edge of the fence line. So now he runs away from Jonathan Figgins, he runs away from the light in the backyard of the Figgins home, and he runs diagonal across 6209 to 6207, and then he crosses the bushes. The defendant is the person who committed this crime. He is the one who caused the death of Kay Baker. And so, did he do it with a premeditated intent? I submit to you, yes. Now, I need to be clear. But you will not see in the instructions.
The bedroom door was locked.
Why he did it is different.
But the front door was slightly ajar when the police officers
motive.
arrived.
Matthew Terry was upset at his girlfriend for what he thought was an act of infidelity, dancing with another man. He was so upset about it, he had to argue about it with her friend, then with her, then with her and her friend, and then he had to make another phone call on the way home because an hour and a half later he still hadn't let it go. Now, was he intending to kill Kay Baker at that moment? That seems unlikely. But they get home, and now the couple's having an argument.
Anybody wants to contact me,
Twitter
at TheLegalVices or Gmail at TheLegalVices.com. Not .com. Gmail.com. TheLegalVices at Gmail.com.
Realizes he is no longer in control. He cannot control Kay Baker because watch that video when Kay Baker goes to the bathroom. You will watch him watch her, and he immediately goes in right after her.
Yeah.
And when she comes out and she's dancing with her friend, and he thinks she's dancing with another man, he walks past them, and the first thing he does is he turns and looks back at them. But keep watching the video. Watch Matthew Terry go outside onto the patio and watch him get back up from the table, walk all the way to the door inside the bar, and he peeks in because he's checking on Kay Baker. Because he thinks that he needs to supervise her. He needs to control her. And I submit to you that whatever happened in that home, whether it was an argument about dancing, or it was the threat of the relationship ending, or he just felt disrespected because she told him to sleep on the couch, that's where it started. That's where doors start getting closed. That's where the master bedroom door gets closed. That's where the master bedroom door gets broken. And Kay Baker gets out of that master bedroom and finds her way to the kids' bathroom and to the other bedroom, and she pulls doors closed, and the defendant comes kicking in doors, and Kay Baker is frantically scrambling out of a window. And so the defendant chases after her. And that is where intent starts. Because let's be really clear, some weapon killed Kay Baker, and I submit to you it's the paring knife that comes from the butcher block sitting on the counter where it's the only knife in the house unaccounted for. And if you agree that that's the knife that killed Kay Baker, then someone had to bring it outside the home. And that's the man who brought it. When he grabs a knife, when he chases a woman down who's fleeing, when he's been chasing her in the home, when he's kicking in the doors, the premeditation is already forming. And every step that he gets closer to her as he chases
I'm just going to shut my camera off for a second. Nobody wants to see me stretch. I've been sitting down all day and my back is killing me.
Kay Baker suffered a wound to the back of her neck. A wound that Anna Cox told you had to be higher than the shirt that she's dripping down onto. Jonathan Figgins told you he heard a thud, like somebody hitting the ground. And Anna Cox told you that Kay Baker's throat is open right next to Jonathan Figgins' wall, And very shortly thereafter, and very briefly, she's moved to the place where she died. The place that she never moved from again. Kay Baker got slashed in the back of the neck because someone was chasing her from behind. She was running. She gets hit in the back of the neck, and in the struggle, she gets knocked to the ground. And someone is on top of her. She is either laying on her back, or she is basically laying face down on the ground, and somebody is going to open her artery.
Ugh.
And it's going to spray on that wall that you saw. That is intent. And it's that man's intent. It was that man's intent to kill Kay Baker that night. It was his intent with every single time he stabbed her, he slashed her, he cut her. That is the only reasonable conclusion. Was Matthew Terry angry? Yeah, I'm sure he was. Does that mean he didn't commit first-degree murder? No.
That's what I thought too. I was a little bit panicky.
He was not acting in the heat of passion as a reasonable person. He was acting as a boyfriend who wanted to put a woman under his thumb, who wanted to show her that he was in charge. That's who Matthew Terry was. In a moment, I will sit down. Before I do, I just want to talk with you about this.
Reasonable doubt.
Whenever the phrase a reasonable doubt is used, you must consider the following. And I'm only going to read a portion of it. That's not because I'm trying to hide the rest of it. You're going to be given this in black and white. You can read it for yourself. But a reasonable doubt is not a mere possible, speculative, imaginary, or forced doubt. It is easy. It is too easy to fall into what is possible, to speculate about what might have been, to imagine about what the real story could have been, to force yourself to believe something that defies common sense. That is not reasonable doubt. There was no other person that attacked Kay Baker that night. The defendant did not rush to her aid and get his blood on his hands because he was trying to help his girlfriend. He did not either get chased by the phantom attacker nor chase down the phantom attacker as if it's some narrative that he's the brave hero. Matthew Terry killed
He did not testify, and this is closing arguments.
He ran through bushes, he ran a football field down the road, and what he did was he opened his own neck. He opened his own neck. And then he laid in the darkness and in the bushes for 5 hours until he was found. Do not fall into the rabbit hole of what is possible, imaginary, speculative, or what you have to force yourself to believe. Use your common sense. Look at what is reasonable from the facts. And when you do, it is clear the state of Florida has shown you what has happened. And if you find yourself thinking, I just wish there was someone who had seen what happened that night who could tell me for real, it's Kay Baker. Kay Baker can't say it because Kay Baker is dead, and she's dead because that man killed her.
Wow.
Find the defendant guilty as charged. Thank you.
The end. All right, now we get to see what the defense's argument is here. Let's see if it's as short as the opening was.
Matthew Terry didn't kill Kay Baker.
Okay.
There is not one piece of evidence that they have presented with their 31 witnesses and their 70 exhibits that changes that. He didn't do this. And they haven't proven that he did. Remember, I don't have to prove anything. They have to prove this case beyond and to the exclusion of every reasonable doubt. And I'm going to show you why they haven't.
Yeah, let's see what a reasonable doubt is.
You would still have to examine whether they've met that extraordinarily high burden.
Remember, we talked about the line, where you, as the jurors, get to determine where the line for beyond a reasonable doubt is. And if you get here and you say, look, this is my line for beyond a reasonable doubt, and if they're even slightly back from it, you must vote not guilty. I submit to you, they're way further back than that. We're not even close. But remember that visual. Slightly back from that line. Right here. You must vote not guilty. The state said a lot during their closing. They said Matthew Terry wanted to control Kate. They said he wanted to have her under their thumb. Where's the evidence of that? Where's the evidence of anything they claim happened that night?
Followed her to the bathroom, followed her out of the bathroom,
There
gave her shit because she
zero
danced for 1 second with
of what
somebody,
occurred past
stabbed her in the neck.
11:56 p.m. Past that last text of "It's all good now." As of 11:56 p.m., the evidence shows that there was nothing going on, nothing wrong. Now, we're going to go through every single one of those witnesses, 31, and by the time we're done, you're going to see why there is no evidence, and certainly none that can get you to the line of proof beyond and to the exclusion of every reasonable doubt. I want to start first, though, by talking about the instruction that the state put up in regard to what they have to prove here, because they're claiming that this is first-degree murder. Even if you accepted their version as true, which for 1 second I will ask you to do just to look at this. He's not guilty of first-degree murder.
Why?
There has been no evidence presented about any reflection. So even if you accept their version, he cannot be guilty of first-degree murder. The law requires the period of time for premeditation to allow for reflection. What evidence has been presented that there was any reflection whatsoever? They told you this wasn't justifiable homicide. This wasn't heat of passion. He didn't walk in on her with another man. How do we know that? We know nothing because they haven't given you any evidence of what actually happened in the 30 minutes after that all good now text. So this cannot be first-degree murder, even if you believe their theory. And that is all that this is. It is a theory that they've presented to you. No evidence, just a theory. So let's talk about, though, the 31 witnesses. The first one I want to dispense with, and really it ties in the second one, too. Michelle Rogers and Detective Crumbach. Detective Crumbach just came in to show you the photographs of the two knives, really one knife. But remember, there were actually two there. There was a knife that was outside and two knives that were missing from the butcher block. What happened with that other knife?
Yep, that's her.
Perhaps Matthew Terry was defending himself then. There was another knife missing. But we don't even need to get into the weeds to discuss Michelle Rogers and how inconsequential her testimony was. Why did they put on Michelle Rogers? What does that have to do with Kay Baker? Absolutely nothing. They put her on to manipulate you into thinking they had evidence because they don't. Michelle Rogers' incident has nothing to do with what happened to Kay Baker. Close your eyes for a second. Don't open them until you have the answer for yourself to this question. Go ahead and take a minute to close them. Ask yourself this. When we left at 5:30 last night, if you were asked to vote guilty or not guilty, how would you have voted? When you have the answer to that, open your eyes. If your answer was not guilty then, it should be not guilty now. Because Michelle Rogers' testimony means zero to what happened to Kay Baker. She had nothing to do with this. And they brought her in to try to manipulate you into thinking there was evidence of Kay Baker's murder when there isn't. Let's talk about a few things that did come out during Michelle's testimony, though. Ms. Rogers conveniently remembers everything about what occurred except what started the incident, going back to my comment about 2 knives being missing. Perhaps what she doesn't want to tell you is he was defending himself then. Ms. Rogers tried to claim she wasn't drunk, but when confronted with her prior statements, admitted she was well over the legal limit, about 1.5 times over the legal limit, in fact. She tried to say that she hadn't previously stumbled and fell when she went to Matthew's parents' house in order to pick up their child, who she then drove after being drunk home. Then she had to admit, well, yeah, I guess I did say previously I stumbled and fell. She tried to say, oh, maybe I corrected that in one of my multiple versions later, but she admitted right after it occurred, she did tell people, yes, I did stumble and fall. She tried to say she was just upset. When she was asked if she was angry, she tried to downplay that and said no, until she was shown a transcript where she actually had previously said she was, quote, pissed off. That's certainly more than upset. She tried to say she didn't ask for more than $250,000 in compensation until she was shown the spreadsheet she herself put together asking for over $250,000. And then she slipped in that she only got 13 to 14. I submit to you that's why she was here. Because the woman who said, quote, she was pissed off is still pissed off. Because she got $13,000 to $14,000 from Matthew Terry when what she wanted was $250,000. Don't let her testimony and their manipulation using her change what you knew at 5:30 last night. And that is that they have no evidence that Matthew Terry did anything to Kay Baker. So really, out of the 31, we have 29. And we're going to go through each one, and you'll see why there is still, even with 29 witnesses and 70 exhibits, 0 evidence that Matthew Terry harmed Kay Baker. Remember, this is the woman he lived with, the woman he loved, the woman he moved here to be with. The woman Kelly and Sean Andrews told you he went out with them every other weekend. The woman they had no thought there was going to come any harm to when they left together. This was someone he loved. And nothing they have presented changes that fact. The first witness I want to talk about is Dr. Perkins. She was the medical examiner. She did the autopsy of Kay Baker. She said that the blood doesn't tell us anything except that Kay Baker was there. Of course, we know that. That is where Kay Baker was killed. No one's disputing that. No one's saying she was moved or the body was manipulated in any way. She said that she doesn't know if all the blood was Kay's or if there were 2 victims. Well, we know there were 2 victims because the DNA shows Matthew Terry was injured, and in fact, his blood was found on the scene. She indicated that she doesn't know if all the blood was 1 or 2 victims or if a 3rd or 4th person was involved. Remember that. No indications that prevent a 3rd or 4th person being involved. She also testified that nothing that she had to say tells us anything about who committed the murder. And the reality is that's the question here. Who did this? Not whose blood there is. We know whose blood there is. It's Kay Baker's blood and Matthew Terry's blood because they were both attacked. The question is who killed Kay Baker? Dr. Perkins told us that there was nothing about her testimony or about the injuries that could tell us the sequencing of events, so we don't know exactly how any of the wounds actually occurred. She testified that the wounds could have been inflicted in seconds. That's important because of Jonathan Spiggin's testimony, which we'll get to in just a moment. But remember that. All of
I'm
those
sure we'll
wounds
get to
could
it.
have been inflicted in seconds. And she told you that she can't tell you if Matthew Terry's wounds were inflicted by another. She doesn't know. They want to imply that they may be self-inflicted. But remember, Dr. Perkins, Dr. Devers, nobody could say that those wounds were self-inflicted. Why? Because they weren't.
Remember.
Wait, wait. Nobody can say they were
something's
self-inflicted
unanswered, you can't give them the
because they
benefit of the
weren't?
doubt and
Oh,
go,
that's a
"Well,
little bit
maybe
of a
they're right."
circular logic there.
They have to prove it beyond and to the exclusion of every reasonable doubt. The next witness was Dr. Devers, and I mentioned her as I was talking about Dr. Perkins'
You
testimony.
can't just say
Same thing.
they weren't self-inflicted
Dr. Devers
because they
indicated
weren't.
that she can't say either.
Well, she
whether
can.
Matthew Terry's wounds were
It's the
self-inflicted
defense.
or inflicted by another. Again, that means it is just as plausible that they were inflicted by a third or fourth person. You cannot give the state the benefit of the doubt when they haven't presented you the evidence. The next is Dr. Mendoza. Dr. Mendoza is the ER doctor who actually treated Matthew Terry. She told you that she too, even though she treated him, saw him in person, she can't give any opinion.
No, she doesn't have to make the argument, but she is making the argument.
She told you that there were
It
notations
couldn't have
in
been
the
self-inflicted because it
records
wasn't.
about self-infliction, but that could have just
That's a
been
dumb thing
something
to
that
say.
needed to be ruled out. Not an opinion. She was quite clear. She had no opinion in that regard. She said that sometimes there was confusion when Matthew was brought in, and that doctors sometimes are actually assigned to one patient because someone improperly clicked on it, assigned to the wrong patient. Nurses have this happen, and those things get put in those medical records. They're not accurate. She also indicated, in fact, that sometimes the information that ends up in those records are things that come from EMS or the police officers, and that those things are not right. The notation about Matthew Terry saying he did this to himself is wrong. That came from the police officers, just like Dr. Mendoza said occurs. How do we know that? We'll get to that when we talk about how he was found and what the police did when they found Matthew Terry. But remember Dr. Mendoza's words about how EMS and police officers give information that sometimes ends up in the medical records and turns out to be inaccurate. She also indicated that Matthew Terry's wounds were such that they went through skin, fat, fascia, a layer of sinew, platysema, which is a layer of muscle, and then into the sternocleidomastoid muscle. This was not some little nick. This wasn't just, oh, he's going to pretend to be injured. Remember all of the layers that had to go through for Matthew Terry to end up needing surgery for his wounds. He had surgery. These were serious, very significant wounds, as you can tell from all the blood you saw all over him in the photographs. The next witness was crime scene tech Janicek. Crime scene tech Janicek took photos and collected swabs. The pertinence of that, not just so that you can have the photographs to look at, but really is to look at the damage. Now, the state wants to tell you, oh, there's damage to a bathroom door and there's damage to a bedroom door.
Look at
and
the,
that must mean that there was a fight.
Look at the
inside
mug
the
shot.
house. No, it doesn't. You heard no
If a surgeon did that
about a
cut,
fight inside that house.
then that surgeon
How do we know
has
that
problems.
that damage wasn't there for months? How do we know that that isn't damage left by a landlord who just doesn't really care about keeping up the property? They've presented no evidence. Now, one thing to posit, though, is that third door, the door that was locked, the door that goes into the bedroom that had the window screen out. That wasn't kicked in. Think about that for a moment. Their version is that Matthew Terry kicked in a bathroom door, kicked in a bedroom door, but then stopped, didn't kick in the door where Kay Baker was barricaded? Does that make any sense? If he kicked in the bathroom door, kicked in another bedroom door, and she barricades herself in that bedroom, isn't he kicking in that door too?
That's why she went out the window, dummy.
Wouldn't that make more sense? That's not what happened.
She went out the window.
That damage to the bathroom door and to the other bedroom door is old, and there's no proof to the contrary.
Ugh.
You cannot give them the benefit of the doubt. They have the burden. Remember, there's no disarray in the photographs of that house. There's nothing knocked over. There's no blood other than the blood that the new officer accidentally transferred. There's no incident that occurred inside that home. No evidence whatsoever that there was any incident in that home. Now, they of course will want to say, oh, look at the hanger. Are you kidding? There's a hanger that's bent, so we are supposed to assume.
It's a hanger that
more
was
assumptions they're
unbent.
asking you to make. We're supposed to assume that somebody who kicked in a bathroom door and kicked in another bedroom door stopped and said, oh, maybe I'll just try to use this hanger to get into where she's barricaded and give her lots of time to get out the window. That makes no sense.
Oh, it makes a lot of
was a
sense.
bent hanger.
This is literally the Chewbacca defense.
That doesn't
It makes no
indicate
sense.
about what
This is the Chewbacca defense right
And
here in
certainly
action.
there's been no
You
proof
are literally
that that
watching the
hanger was
Chewbacca
used
defense.
for anything at all. The next witness was Detective Watson. He took a swab of Matthew Terry. Doesn't really tell you anything. The DNA will, of course, talk about when we get to those witnesses. Deputy Bateman, he's the person who took the aviation video that you may recall. It's the video that had the blur of light. That was where, how they were able to get to Matthew Terry. Well, he told you that he got a GPS location to immediately go there. So there's no indication that there was ever any ability to look for other suspects. It wouldn't have mattered by then. It's 5 hours later. Remember the testimony earlier? It took the police an hour to put up a perimeter. 15 minutes to even respond. Whoever did this was long gone by then. But even if they hadn't been, even if it had been a quicker response, aviation, he went directly there. No opportunity to look for other hot spots, other people. Next witness was crime scene tech Douglas. He indicated that, well, they didn't bother to use the Faro system in order to create a crime scene diagram. Their drone photos didn't save for whatever reason. They didn't bother to process the window screen, the screen that the state is relying on to tell you that, oh, Kay Baker must have gone out that must have been her pathway. That's how she tried to escape. They didn't bother to look for prints or DNA there. They didn't even bother looking for footprints. Kay Baker is barefoot. Matthew Terry is barefoot. Did they try to look for footprints? He tells you they didn't even do that. He did indicate, though, that he took a swab from every marker, and not every marker, as we know from later testimony from Detective Redo, was tested. 50 items. They tested 10. They tried to say, oh, we have a procedure. We can only submit 5 at a time. That's ridiculous. He told you all they have to do is ask to submit more. They have to have a reason, he said. Yeah, like a murder trial coming up. They didn't bother. Just like they didn't bother with the Faro. Just like they didn't bother with the drone or having the drone photos in a manner that would reasonably save. Just like they didn't bother to test the screen for fingerprints or DNA. Just like they didn't bother to look for footprints. They didn't bother. Why? Because they assumed it was Matthew Terry, which is obvious when we get to the officers who actually located him and what they did. But first, let's talk about the two first responding officers, Deputy Ellis and Deputy Strahan. People are new. They make mistakes. But Deputy Ellis actually transfers blood from Kay into the home, and Deputy Strahan was brand new in his job supervising her. So the first two people who get there are brand new in their positions, and some mistakes were made. In addition, though, I would just point out, there's really nothing to their testimony that changes the fact that the state has presented zero about who committed this crime. The only thing that they testified to was finding Kay Baker's body. Again, we don't dispute that Kay Baker was there. We signed a stipulation. That is her. We're not saying the body was moved or manipulated in any way. And then they end up going into the residence. But again, no signs of any struggle in that residence. No blood, nothing. The next witness is the neighbor, Douglas Hicks. Well, he tried to say during his testimony that he heard crying or yelling out, but then he admitted that when he originally had reported all of this, he actually had his TV on, and he had previously said it was only gasping and gurgling that he heard. And remember, Ruth Figgins said he was actually drunk that night. So his explanation of crying or yelling really isn't reasonable. What he said that night is it was gurgling or gasping, which we don't dispute. I'm sure Kay Baker, from her very serious injuries,
Sorry, that was rude.
gurgling and gasping. That doesn't tell you anything about who did this.
He was just watching Pornhub.
Jonathan Figgins, he's the one who tried to help her, the husband of the 911 caller, Ruth Figgins. The state said during their opening, well, Jonathan Figgins put on his lights, and that's what made Matthew go in the other
All
direction.
right, we've got a new poll up.
How would that have occurred in those seconds? Think about that. If Matthew suddenly gets
Vote in
there,
our
lights go on,
poll.
why would he go back into the yard? And if he did, just to immediately go to the area where they claim he went to try to get around? How would all of this have happened? Remember the testimony in regard to all of the pink spots on this chart that was their expert's chart are the unknown things, the things that aren't tested. They want you to believe that he gets to you, lights go on, and he goes, I better not go that way, there's lights. So he decides to run back down to O, then run across this way, and then hang out up here a little bit, because remember there was testimony about the concentration of blood being bigger in this area where there's D, G, E, F, H, A, B, C, and then cross over and go that way. Why? How? What on earth would that make any sense? Think about it. If their version is true, if Matthew Terry gets to you and suddenly lights go on, what would make more sense for him to do? Get down in that brush. Go directly that way to Lithia Pinecrest and get the heck out of there. Their version, yet again, doesn't make sense. By their own evidence, by what their own expert said, doesn't make sense.
This is literally, I want to change the
But
poll.
what
She keeps
Jonathan
using the
Figgins
Chewbacca
did tell
defense.
us, and what makes much more sense, is that it took him up to 3 minutes to get outside after hearing that first thud, because he checked on his daughter, he had to make sure it wasn't her, he thought she had fallen out of bed, that it's very dark behind his house and it backs up to Lithia Pinecrest. He indicated that he heard a noise once he got out there. 3 minutes later, he heard a noise in the woods that could have actually been 2 or 3 people. And that Lithia Pinecrest is a very busy road, and you can walk to Lithia Pinecrest in just seconds.
Thanks for
Why
not
does that
screaming into the microphone for 5 seconds. God.
Put this back up just for you to see for a second. DD, S, R, those are the areas right around where Kay Baker was found. If he heard a thud at that time frame when Kay Baker gets hurt, and it takes him about 3 minutes to get up there, it's not going to be just the seconds that the state's theory says Matthew Terry would have gone to you, and then somehow, for whatever reason, they claim go this way. That makes no sense. What makes more sense is in those 3 minutes, all of this back here is happening. You'll understand that when I get through their witnesses and why their witnesses don't point to Matthew Terry, and I tell you what actually happened. But remember this, 3 minutes is how long this could have taken, not the seconds the state claims, where Matthew Terry just got to you and said, ooh, lights are on, I better get out of there. Didn't happen that quick. Jonathan Figgins told us that. It took him up to 3 minutes to get out there. A long time for a whole lot to happen. Now, Ruth Figgins, his wife, she's the one who actually called 911, she indicated that she heard nothing before her husband alerted her to what was going on. She said, as you can actually hear on the 911 call, that it took 15 minutes for that first officer to arrive. Plenty of time for the person who actually murdered Kay Baker to get out of there. She indicated that Kay Baker's feet were dirty. You actually could see that in the photographs. Why does that matter? It matters because Kay had gotten home calmly with Matthew. Matthew, by the way, was barefoot too when he was found. Because they got home, took off their shoes. Nothing was happening between them. Matthew's keys are by the bed. His car's in the driveway.
So?
They're going to sleep. He's in his underwear. As the state mentioned, Kay Baker had taken her bra off because they're going to bed. There's no ongoing argument like
She
they
wears a
want
bra.
you to also believe. It's
See, it's a Chewbacca
contradictory.
defense.
Their own theory
She wears a
contradicts itself. There's no ongoing argument. Nothing is happening at that point. And of course, Ruth also talked about Lithia Pinecrest, how big of a road it is, the fact that there is a stream that is crossable in just seconds, that opens up to a big cow field, all of which
A cow
is
field?
an egress or an ingress. For
I
the
believe we
person
call those
who
pastures,
committed this
law-talking
crime.
person.
We have Corporal Royal who testified. He just talked about how he got the video from the landing. So in regard to his testimony, it's just to set up the video. But let's talk about the people that are in that video, because that's really what's more important. The first person let's talk about is Tara Johnson. Tara didn't know what was actually going on. She was dealing with her husband, who was drunk and wanted to go home and kept bugging her, telling her, let's go, let's go, let's go. Her son was there too, also drunk, wanting to go home. She had been having her Moscow Mule vodka drinks, and she decides to interject in the conversation between Matt, Kay, Sean, and Kelly. Now remember, you heard the testimony, and we'll talk about Sean and Kelly's testimony in just a moment. Sean and Kelly were very close friends of Matt and Kay. They can talk about that kind of thing if there were some tiff, some silliness going on. Tara didn't even know Matt. She only met him that night. But she drunkenly decides to go get involved in this.
Yeah, so it's her fault.
And she's claiming now, oh, there was some argument. Really? She didn't
Really?
know him, so certainly can't judge whether he's upset or not in regard to any way that he would normally react or talk or have a conversation. She's a stranger interjecting. Why wouldn't he get annoyed by her? He wasn't mad at Kay. He was mad at Tara jumping into a private conversation she had no business jumping into.
So he went home and
How do we
stabbed
know
his
that?
wife
Well, because
repeatedly
of
in
the
the
other
neck,
witnesses
his
who
girlfriend.
testified. But before we get to them, remember what Tara said. She said, in the end, everything was fine. When she left, everything was fine. They talked about getting together again for Memorial Day. She sent Kay a text saying she had a good time.
I think it's just a stupid accident, a stupid
Because everything
argument.
was fine, and it wasn't the big deal that she tried to make it out to be, interjecting herself in a situation
She's
she
trying
really
too
shouldn't
hard.
have been in the first place.
She's making bad
And
arguments.
As far as the other witnesses,
She
remember
doesn't
what
have
they
to make
said. Sean
any
Andrews
arguments.
Told you that he and his wife Kelly, they were best friends with Kay. Kelly has known Kay for over a decade. He's seen Kay pretty much every other weekend for a decade. He is also now, because of Kay and Matt dating, seen Matt every other weekend for months. They're all very close. Everybody, of course, at the landing was drinking. Sean testified that there was a discussion. He described it as heated, but said that there was no fight. There was no yelling, and then that seemed fine. But most importantly, what did Sean say? Kay, his wife's best friend, his very close friend of over a decade, there is no way he would have let her leave if he thought there was any issue still ongoing. And he didn't, because there wasn't. There was no issue. Kelly testified, and all the sympathy in the world for Kelly. This was her best friend. Unimaginable losing your best friend in a way like this. But because of that pain, she has made what was not an issue, not an argument, as testified to by her own husband, into something bigger in her own head. So she told you, though, despite making it sound like it was an argument, that there was no yelling. Matt didn't get aggressive with Kay. There was no slapping, pushing, nothing of that sort. She said they stayed an hour after it came up, and the dancing issue didn't even come up again. She said Kay called her and yes, said he brought it up again, but when she, who is close enough to him to actually say, tell him to cut it out or I'm going to kick him in the balls, he said, okay. He didn't yell. He didn't curse. He didn't say stay out of it. He didn't get annoyed with her like he did with Tara, because Kelly and Sean were practically family. Tara was the reason for the annoyance at the landing.
Oh, come
Not
on.
this silly dancing issue. But most importantly, Kelly testified about that text at 11:56.
I mean, she is aggressively
It was all good.
arguing
The text is
for
all
her
good.
client.
So silly. So stupid. And
Can't
that's
fault her
what
for
it was.
that.
It was
I think
silly,
it's a stupid argument.
Nothing. Because next is Nicholas Calicochi. He tried to say now, and he too was.
You don't have to
close with
discredit
Kelly.
every
And in
single
hindsight,
witness.
He thinks, well, maybe it was an accident, an argument rather. So he's trying now in his own mind to rationalize what must have happened. But he told you, the night in question, he said there was no fight, no argument. He described it as, quote, wasn't even a tiff. It was over in 2 seconds, the topic was immediately dropped, and that Matt and Kay went back to their table to have fun. And that's really what it was. It was a 2-second nothing that was immediately dropped. That's everybody who was there that night that testified. Not one reasonable indication that there was any real argument, problem, dispute. You saw the video. There's no large gestures of somebody who's getting heated and upset. In fact, you see Matt go over and put his arm around Kay after it. Kay gets him a drink, or he gets her a drink. They're going on back at the table, talking, drinking, hanging out for another hour with their friends.
Nobody can be buying this. They just can't.
This was nothing. Let's talk about the DNA. The next witness is Alyssa Troutman. She said Matt's DNA and Kay's DNA was there. Okay. Remember during voir dire, during jury selection, I said to you, sometimes there are experts who might testify and you think, oh, they're an expert, it must be really important. But it's not on an issue that actually matters. Remember, the only question here is who killed Kay Baker. Of course Kay's DNA was there. Of course Matt's DNA was there. He was hurt too. But what she said that was interesting was that she put into StarMix that there would be 2 contributors. She didn't put in that there could be a third. And what did she say? I wrote it down. She said, I don't know what the program would have done. She doesn't know what the program would have done if she put in a third person. We have no idea. And by the way, 40 pieces of evidence that they didn't even bother to submit for testing. 80% of the evidence. They submitted 10 out of 50. 80% not even bothered to be looked at.
10 points
Next
for
witness, and
zealously
we're at 21
advocating on behalf of her
witnesses right now. Again,
client,
not one
but
piece of
like
evidence
minus
pointed to
several
Matthew
dozen for
21 is Anna Cox.
just making
She was
stupid
the
arguments.
expert who did the map that we've shown a couple of times. She indicated that Kay's blood may have gotten on Matt as he tried to help her. Common sense, right? Jonathan Figgins got Kay's blood on him as he was trying to help her. So did Deputy Ellis. Matt did have Kay's blood on his hands.
Exactly.
He did touch the wall where you saw the BB because he got attacked and was bleeding too, and he did stumble into the fence as you saw at the U. Because again, Kay's blood was on his hands from him trying to help her, and then when he got attacked and was bleeding, his blood was on his hands too. Anna Cox indicated that she can't exclude that if Matt had gotten Kay's blood on him trying to help her, then was attacked and touched the wall at BB, and then stumbled into the fence at U, that his and Kay's mixed DNA could have gotten on the wall and the fence that way. That's their expert.
There is no evidence of another person, but the defense does not have to prove there was another person.
That's the blood on the wall.
The state has to prove there
Towards the
wasn't
backyard.
another
Where is
person.
where else is that towards? Towards you. Towards the fence where he stumbled into. She indicated that there was a large concentration of blood at H. Now, just to be clear, which H, because there are two. The H we were talking about was the one way over here. Try to zoom out to get this all in one. There we go. The H that we're talking about with the large concentration of blood is over here. Why is that important? Remember that location, and I'll tell you why that's important in just a few minutes. But she said there was a large concentration of blood there. Unfortunately, we don't know whose blood, because they didn't bother to submit it, but a large concentration near where Matt was found. We'll talk about that in just a few minutes. Ms. Cox also said that Matt had a lot of blood on him, and it might have all been his own.
849 likes.
We don't know. If
We need
it's
to get
his blood,
900
his
likes.
Blood, a third person's blood, but it could have all been
Do it.
his own, as Ms. Cox told you. But most importantly, she said she has no opinion to offer you on who did this. And really, isn't that the only question that matters? And she cannot exclude that a third or a fourth person was involved. The next witness was Detective Ritto, the lead detective. Now, he helped look for a knife, but he didn't find one. Why is that important? Well, he told you that he looked where Kay was, he looked in the backyard, he looked where Matt was found, he looked along with Lithia Pinecrest. They looked everywhere. He told you multiple deputies, multiple people using equipment, metal detectors, trying to find a knife. There wasn't one, because the real perpetrator had left with it in the 15 minutes it took for the police to get there. If Matthew Terry did this, they would have found the knife where he was laying, or somewhere close to it.
Not really.
Remember, we have this map.
You had 5 hours to
Concentration
throw
of
it.
blood where he was found. If he did it to himself, if he cut the wounds in his neck like they want you to believe, wouldn't that have occurred where that large concentration of blood was at H, where he was found?
Oh, I'm getting fidgety.
And if that's what happened,
She's annoying me.
he would have still had the knife on him or close by. They would have found it. Why do you think they didn't? Because the real perpetrator had left with it. It wasn't some ridiculously little 3-inch paring knife, little bent bird's knife. If he was going to grab a knife from that butcher block, wouldn't he have grabbed a butcher knife? Wouldn't that make more sense? The next witness,
Okay,
a few more
Chewbacca.
things from Detective Ritto.
All right,
He
Chewbacca,
also
that's
pointed
enough.
out, and I liked the phrase he used, which is why I want to mention it. He said that there were indications Matt and Kay normally arrived and were getting ready for bed. I agree with that completely. There were indications Matt and Kay normally arrived home. Matt's keys to the car that is in the driveway were right by the bed. If Matthew Terry did this, wouldn't he have gotten those keys, gotten that car, and left? Detective Ritto told you that Kay's shoes were off. We know that because of the pictures where she was found with no shoes. Another indication of getting ready for bed. Just like Matthew Terry, his shoes were off. There was no argument going on. They were going to bed. Matthew was in his underwear because they were about to go to bed. And most importantly, of course, that text at 11:56 was that everything was fine. But he also told you that he doesn't know the circumstances of what occurred because there's no evidence of what occurred. Remember that. He also told you that there were blood trails that showed someone fled. Well, of course. But he doesn't know who. He told you he doesn't know who, and that's really the question that they have the burden to answer. And they haven't. And he told you that more than 50 items were collected and 10 sent for testing. 20% sent for testing. Next, we have Detective Van Gilder. He indicated that the only knife missing from the home was that little 3-inch paring knife. Again, I'd ask you to just use your common sense. If Matthew Terry grabbed a knife from that butcher block intending to harm Kay Baker, is he grabbing the smallest knife there? Is he going to grab a paring knife that's curved instead of a big steak knife or a big butcher block type knife? Of course not. It's absurd. That's not what would have occurred. Witness 24 and 25, Detective Gibson and Detective Davis. They testified that they used metal detectors and ground wands to search right where Matthew Terry was found and didn't find the knife. Again, going back to exactly what I've said before about that. That knife would have been there if Matthew Terry did this. But that also ties into the 26th witness, Deputy Polito. Deputy Polito, you might remember, he's the one who...
All of this...
So he told you that his hound can only track
exactly why the judge said the arguments by counsel are not evidence.
If there were other scents of a third or fourth person there, he's not going to be tracking that. Deputy Polito indicated that he stopped Canine Champ because he found a large pool of blood. I submit to you that's right around the H that Anna Cox talked about, where there's that large pool of blood. And that when he pulled out Canine Champ, Deputy Gibson and others came in order to try to find the person who was there. And in fact, it was Matthew Terry, who was just right beside that large pool of blood, because that's where Matthew Terry's neck was cut by the real assailant. Remember, if he cut his own neck right there, they would have found that knife.
Why?
They didn't. Deputy Polito also told you that Matthew Terry had to be walked out of the area by deputies, which you actually got to see on the body cam. You could see, in fact, that Matt was injured. He was staggering. He had to be supported by the next witness, who is Deputy Hall. He's number 27. Deputy Hall told you that Matt was found on his back and that another deputy immediately rolled him over and handcuffed him, despite Matthew being, as described by Deputy Hall, quote, very pale, having serious wounds to his neck, needing to be assisted to his feet, assisted in walking, and that he appeared, quote, on the verge of going unconscious, and quote, on the verge of potentially dying if medical care was not immediately given. So he did immediately get him care, got an EMS, and they transported Matthew to the hospital. Now, the deputy that had rolled Matthew over, that's Deputy Curtis. He's number 28 that we're going to talk about. Remember, though, as we talk about Deputy Curtis, what Kaylin Hall said. Matt was on the verge of dying. Deputy Curtis, though, he assumed, oh, that's got to be the killer. So he immediately rolls him over. Who cares about his injuries? Do they bother to document his injuries? Did Deputy Curtis stop for a moment to see if rolling him over might cause Matthew to die? No, he didn't care. Deputy Curtis made an assumption, immediately rolled Matthew Terry over, handcuffed him, and assumed he must have killed his girlfriend. Because the spouse, the partner, the boyfriend is always a suspect. It's an assumption, which led to the theory.
And because why is it an assumption? Why is the boyfriend? Because boyfriends are usually the ones that do it.
You saw how Deputy Curtis completely disregarded Matthew's physical appearance, his lack of any ability to stand on his own, his paleness, his multiple wounds to his neck, the fact that Matt had blood coming out of his nose, blood all over him. You saw Deputy Curtis just toss him over, cuff him, and you also got to see Deputy Curtis's demeanor on the stand. Think about how he testified. He didn't even want to admit that someone could have gotten away in the hour prior to him getting to his perimeter point. Why? Because he's the one who assumed it was Matt. He's the one who immediately arrested Matt. He's the one who this whole farce was based on. The next witness, Deputy Gianni, readily admitted that someone could easily have gotten away before setting up the perimeter point an hour earlier.
Before.
Deputy Curtis wouldn't even try to give any remote possibility to that, because he didn't want to accept that his assumption was dead wrong. But luckily, Deputy Gianni took photographs of Matt's injuries, so at least we have that, and we have the body cam to show you how Deputy Curtis acted in those moments. We're at 29 witnesses. Not one shred of evidence yet that Matthew Terry did this. Let's talk about number 30. That's crime scene tech dirt. What did he tell you? There were 3 blood trails. One along the fence line. One along
Oh,
the back
come
edge of
on.
the
She's
property,
killing me here.
one straight across
I thought I'd be in
the
bed by now.
decedent's residence. Now, I can't tell you whose blood that was because they didn't test all 50 plus swabs that they took. But it's not my job to tell you. It's theirs. It's their burden. But he did tell you there were 3 blood trails. And we're on the last witness now, Deputy King. Deputy King is who first found that screen off the window. You got to actually see it on his body cam. I'm not going to play the body cam, but I'll show you the picture of it. Remember, though, as I'm showing you this picture, what Detective Redo said when he testified. Now, I had no idea he worked burglaries. They brought that out. But what did he tell you? He said that first floor unlocked windows are points of entry for a burglary if the screen is removed. This is the state's 11E. First floor, unlocked window, screen removed. Now, the state tried to say in their opening, hey, wait a minute, nope, no way, can't be from a burglar because there's a stuffed animal. Really? You saw the photos of the inside of that room. There were a bunch of stuffed animals there. Someone could have taken that off, gently placed it down, not stuffed animal even there yet, crawled in and knocked out with their foot one of the stuffed animals as they're crawling in. First floor, unlocked window, screen out, gently placed against it.
Gently placed
Not
against it?
frantically pushed out onto the ground like it would have been if their theory were true. Remember, what did they tell you? They want you to believe Kay Baker, after Matthew Terry kicked in the bathroom door, kicked in the other bedroom door, chose not to kick in the door where she barricaded herself, giving her plenty of time to frantically push out the window and get out there. And then what did she do? Stop and pick up the screen to gently place it against the side of the house?
While my screen gently weeps.
That doesn't make any sense. If she were barricaded in that room, Matthew Terry would have kicked in that door too. We know that didn't happen because the deputies kicked it in to get into that room. And that screen would be further and away from that window, having her frantically pushed it out, not quietly, gently placed against the side. Doesn't make sense. And it's their burden to prove what happened. We're at the end of the witnesses. There's no evidence. None. Matthew Terry didn't do this. And I don't have to tell you what happened. All I have to do is raise doubt about their theory. But I'm going to tell you what happened. And I'm going to show you how the evidence actually shows that their version is wrong. And what is a reasonable inference of what actually occurred based on the actual evidence. The things that they ignored.
She has now mind. She has no obligation to show
They
any
wanted
evidence.
to read to you the reasonable doubt
But
instruction, so do I, because the part that they never
She's
mentioned
just talking
when
out of her
they
ass at
read
this point.
it is this part that I've highlighted. Let's see if we can zoom in a bit. They read to you the first part because they want you to say that what I'm about to tell you is just speculation and imagination. No, it's not. It's a reasonable inference based on the evidence, and you are allowed to use anything that can be reasonably inferred in order to find out. If after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction of guilt, or if you have a conviction of guilt, it's one that's not stable, but one that wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty, because your doubt is reasonable. A reasonable doubt as to the guilt of Matthew Terry may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. I submit to you, we have a lack of evidence here. We have conflicts in the evidence. We have doubt that arises from the evidence itself, as I'm going to go through in just a moment. But I would remind you of the very last part of that instruction, which is, if you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of first-degree murder. That goes back to the very first thing we talked about. But also in regard to any crime at all, if you have a reasonable doubt, you do not have a conviction of his guilt, an abiding conviction that doesn't waver or vacillate, you have to find him not guilty. Remember those instructions as we're talking about what actually occurred. We started first with the thing we know, really the only thing we know from their theory, which is that at 11:56 p.m., there's a text that everything's all good now. So we know that. We know they got home. We know everything was fine. We also know that they're getting ready for bed. How do we know that? Kay's shoes are off. Matt's shoes are off. Matt's keys are by the bed. All evidence. We also know that there's something that occurs where that screen is gently, quietly placed against the house. I submit to you a reasonable inference is that prior to them getting home, that screen was gently, quietly placed against the house. And someone entered their home, knocking that stuffed animal out as he got in there. He's in the house.
Oh, that's too bad.
What's
I
somebody
was saying
who's
some good
entering-
stuff.
I'm just going to call him a burglar. It'll be easier. What's somebody who is a burglar in a home
I was
going
saying
to
good
do
stuff.
if the occupants come back? He's going to get the heck out of there, right? So he hears them coming in. Where's he going to go? Is he going to go out?
I
the
was
front
saying
door or
before
to
I
the
was so
garage
rudely
where they
muted
may
by
be?
myself.
No.
So the bedroom door was still locked. She was locked in the bedroom. He was locked out of the bedroom. She opened the window, popped the screen out, escaped through the window. He ran out of the house, around the house, and caught her and proceeded to stab her, allegedly.
Because they had no idea he was in there when they came in the house, took off their shoes. And when Matt went into the bedroom and put his keys down and took off his shorts to get ready for bed, Kay went out that
So
front door.
have any of you ever had an argument or a fight without wearing shoes?
What she heard was him getting out of that other that window again. Remember, he would have come in back to the room where he had come in to go out the way he came in, because that's the way he knew he could, which is why the screen is gently placed against the house.
No.
And as he's in there, locking the door to buy him a little bit more time, Kay hears the noise as he's crawling out the window, goes out in her bare feet to see what the noise is.
This is so stupid.
And as
Who
she
is going
turns
to buy
around,
this nonsense?
She's attacked. And that's why her blood is all over the front there. Remember, Kay's blood.
This
right
is so
here.
dumb.
There is no evidence that the other blood is hers. If you look at the key at the bottom that Anna Cox told you was correct, the yellow is Kay Baker's blood. The orange is where
Now look,
Kay
she
Baker
only
and
has to
Matthew
convince
Terry's blood got
one
mixed.
juror.
So the
Only
only place
one
we know
juror.
Kay Baker's blood is right here. And if Matt, as Anna Cox
Maybe
said
one of
could
them's
have
really
occurred,
stupid.
got Kay's blood on him here, trying to help her, which we'll get to in just a moment, and then got attacked, he could have easily gotten her blood here and here as he's stumbling to get away. No yellow here, because they didn't bother to test it. None of that blood is Kay Baker's. So as Matthew Terry was in the bedroom putting his keys on that nightstand that you actually got to see the photograph of, remember his keys were right there. He's in his underwear, he hears Kay get attacked and immediately goes out to help her.
Yeah,
He
to
finds
help
her
her.
laying there, right where she's found. Bends down, gets her blood on
And then
his
he
hands,
runs away and hides from police
Sees
in the
the
bushes
woman
for
he
5
loves.
hours.
dying. And is attacked himself. And that's how the blood ends up here. He's stumbling to try to get himself back to a point where he can see what on earth is going on, and he hits the fence there. And that's how the blood gets there too. He's able to shake it off and then chases the assailant. He's bleeding already. Remember, you can tell from the photographs, you saw blood in his nose, blood on his face, there's blood all over him. He is actively bleeding. And that's why there's some of this blood that is his. You can see the blue is his, the A and the J there, Matthew Terry's blood. But some of that pink is not his, because he goes after the assailant. He goes after the guy who tried
Oh,
to
that's why
end
he was in
Kay
the
Baker's
bushes.
life, and
He was
ultimately,
chasing the
Matthew
person,
finds out later,
not hiding from
did
them.
end Kay Baker's life. But Matthew doesn't know that in those moments.
And
He's
then he
going
just
after
falls down and
the
hides from the
person
police
to
for 5
stop
hours.
him from getting away. And there's a struggle, which is why there is all that blood. Now, when we're here, you can see there's crossing over. Matt gets here. Matt's bleeding here. And the assailant is able to get further down. Now, he's still chasing him, trying to keep up with them. There's a question mark here about whether there's more blood here, because again, they didn't bother to get that
Oh,
evidence.
long
They
time
didn't
no
bother to
super
take
chat.
photos there. They didn't bother to document that.
If she starts talking about climate
as
change, I'm out.
Fox
How
testified
dare
to,
you, Julie?
There's possibly
How
even
dare
more blood
you?
along that area here before we get to over here.
Oh, thank you
And
so
I
much for that
submit to you
super chat. That
area
perked me
where
up.
Anna Cox
It's been too
testified,
long.
There is a large pool of blood is where Matthew is more sufficiently and more vigorously attacked with the other stab wound to his neck. Now remember, Matthew had one stab wound here, one stab wound here, blood in his nose, blood all over his face, blood all over his clothes. So all of this is not just Matthew's blood, but it's also the burglars. And some of this back here, I submit to you, there is more blood there that they just didn't bother with. The police just didn't care. They thought they had their man. And over here, they ignored the fact that Matthew was further and more seriously attacked there and didn't even bother to test that blood. Matthew was attacked where Deputy Hall found him almost dying, pale, lethargic, as he described. And that's why Matthew was still there. Think about their theory. They want you to believe that he just laid there for 5 hours. That's absurd if he were the killer. He would have got up, got to those keys, got to the car. Why would he stab himself over here and then stay on the scene? He had at least 15 minutes where he could have just gone towards Lithia Pinecrest, crossed back over here, got into his car and got out of there. Remember, Jonathan Figgins and Ruth Figgins didn't know who Kay Baker was at the time. They thought it was some teenager. They didn't know it was her. They would have thought nothing of somebody a house over just leaving their driveway, leaving
Speaking
their
of
garage.
thought.
He didn't do that because he was attacked. He couldn't do it. He was laying here injured, almost dying,
Almost dying. Oh,
as Deputy
bullshit.
Hall indicated.
Nobody said he was almost dying. They said he was drunk off his ass. It wasn't even bleeding when the police found him. They could see it was cut, but it wasn't bad, they said. Oh, Lord.
He was found.
He was
They want to
almost
say, oh, he was
dead.
just laying there. He couldn't call out. You heard the
No, he
wound was
wasn't.
there.
He
was
could have
so
called
injured.
out.
He wasn't even sure he could.
Oh! He was drunk off his ass.
Helped up, assisted by the deputies, walked out, medical treatment, and ultimately surgery.
See, this is the thing.
Remember, it's not my job to tell you what happened.
Yeah, but I did anyway.
It's theirs.
Yeah, exactly.
They didn't do it.
That's all she had to say
They
right there.
have to prove
That's it.
their case beyond and to the exclusion of every reasonable doubt. They've given you a theory, a bunch of assumptions, and zero evidence. 31 witnesses, each one we went through. Not one points to Matthew Terry. Their burden is to protect us all. Matthew Terry is innocent. He didn't do this. They haven't proven a thing. And as hard as it is, the law demands that you go back there and vote not guilty. Thank you.
Oh, God.
Does anyone need a break before the rebuttal?
I need a break before
Seeing no
rebuttal.
hands, Mr. Diaz, you may proceed.
Oh, God, there is no break before rebuttal. All right. This guy's just got to say, that story is so full of shit. She's an absolute nut if she expects you to believe anything like that. We laid out the evidence. You know what the evidence says. The evidence shows he was just sitting there. He was hiding from us. He popped the screen out. There's no evidence that he went back in the house. Yada,
You
yada,
heard it.
yada. Done.
Miss Perry told you what happened. It's not evidence, but she told you what happened.
Good
Matthew
start.
Terry is the brave hero who chased down the assailant who murdered his girlfriend in an attempt to apprehend him.
Yes.
So she told you.
The sarcasm.
She didn't have to tell you the story. She said she would do it anyways, and she did. Okay. So, Kay Baker and Matthew Terry are, in fact, the last two people together. He's the last person with her, right? They're home alone, right? They got home. They started to get undressed. Everything was going normal, right? That's what they said. And some man decided to break into their home. Homes do get broken into. He doesn't break a window. He pulls the screen off. The window to a child's bedroom that a mother has left unlocked is left unlocked so it can be opened. He kindly takes the time to raise the blinds, because the blinds are raised, right? They're not pulled down. They're not crawled through. He takes the time to reach inside and raise the blinds, and then he crawls in through the window. And now he's discovered that there's people home. So he decides he's going to get out of there, and he's going to take the time to lock the door first before he climbs back out the window. That's the story, right? He doesn't put the blinds back down to conceal his retreat. He doesn't close the window. He doesn't put the screen back. He just crawls out the window and he walks away. And Kay Baker, and only Kay Baker, hears this noise. And what a woman does in the middle of the night with a man in the house, she says, I'm going to go wander outside alone to try and figure out what the noise is that I hear inside my house.
Based.
That's what happens, right? She has to wander outside. That's clear. She's got to get outside the house. She doesn't die inside the house. She's got to wander outside alone with a man in the house. She doesn't say, honey, I think I heard a noise. Could you go check? And not to be chauvinistic, women are certainly capable of checking for themselves. She doesn't go room to check, right? She just immediately walks outside barefooted. Doesn't take her phone, doesn't use it as a flashlight, doesn't bring it so she can call for help if there's a problem. She fully exits her home, as depicted here in State 64B, which she exits over here on the left side, the side away from 6209. And though she's heard a noise inside her house, she walks all the way past the front of her home, through her driveway. She walks across the yard between her home and 6209. She crosses past 6209 for no appreciable reason, and there she is set upon by the burglar, who is still hanging out waiting to murder her. right? The guy who was in such an effort to get out of there has decided to hang out at 6209, so a woman who's coming walking through the driveway
No, nice
in the
chuckle.
open public space, he's just waiting, and now he's not a burglar, he's a cold-blooded killer. That's what has to happen. Right? There's no suggestion in the story that Miss Perry told you that Kay Baker chased him out of the home. She was running after him to try and stop him. She fully described the notion that the guy got out the window, fully got away, and Kay Baker decided to wander outside alone, doesn't bring her boyfriend, doesn't call the cops, doesn't bring a flashlight, doesn't bring any weapon to defend herself. She wanders out into the night to look for what is a suspicious noise. And she gets murdered. She gets murdered in a most intentional and a most premeditated fashion by the Phantom Killer. And somehow,
He's hanging out on a
Matthew
golf
Terry,
course with OJ's
just
killer.
chilling inside the home in his underwear, hears a noise and decides to wander all the way out from the bedroom, which is in the back left corner of the home, all the way to the front of the home, all the way outside, all the way past the front of 6207, through the yard heading into 6209, past the yard of 6209, and somehow he knows that his girlfriend is laying dead on the ground of 6209. And by the way, the cold-blooded killer is still just hanging out. He's just waiting. He has
Makes
to be.
sense to me.
Right? Because there has to be enough time that Matthew Terry can walk up to the scene, see his girlfriend laying dead on the ground, and make the conscious decision to get on the ground and render her aid, because he wouldn't have to know that the cold-blooded killer is standing right there, knife in hand, ready to murder him. Right? So the cold-blooded killer has now lain in wait a second time for a reason that he doesn't have to think that another person is going to come along, so he can kill a second person in what started in a home burglary. And now he attacks Matthew Terry, right? Because Matthew Terry's got to end up with Kay Baker's blood on his hands. And what the defense has told you is, that's Kay Baker's blood on his hands. Right? That's what they said.
Now, I'm going to sleep as soon as the jury
Blood on his hands
instructions are
because he's
read,
rendering aid to his girlfriend.
which I hoped was an hour ago. Huh.
And now he's being knife attacked. And even though Jonathan Figgins told you that he heard the sound of a female voice, right? Which has to be Kay Baker, because Matthew Terry isn't a female. And I guess you could conclude that the person who was wincing in pain as if they were being injured was the Phantom Killer, but that seems a stretch. Jonathan Figgins hears no noise of a second fight. There's no yelling, there's no screaming, there's no calling for help, there's no anguished noise coming from the mouth of Matthew Terry as a knife is now being plunged into his neck. Not a fatal wound. Nowhere near the level of the extent of injury that's done to Kay Baker. And according to the defense, it's just the one. He stabs him one time in the neck because they still got to leave room for the second neck wound that's going to happen later. Right? Now Matthew Terry has been stabbed in the neck and he is stumbling through the yard. Right? Conveniently depositing his blood and Kay Baker's blood all over the place. And for no appreciable reason, he runs up along the fence line. He's not putting his hand on the fence as if he's supporting himself because he's so weakened and so beat up. He goes all the way down the fence line and doesn't touch the fence with his hand until he gets to the north facing, the facing Lithia Pine Crest. That's where his handprint is. It's on the north facing. It's not where Z and Y and X and W and V, it's none of those. Right? So now the cold-blooded killer is watching Matthew Terry stumble helplessly along a fence line and doing nothing. He's not going to finish this guy off, right? There's no second attack. There's no wound to the back of Matthew Terry. There's nothing. He stabs him once and then watches the guy wander off. And then, if Matthew Terry goes north along the fence line, the killer doesn't run south. He doesn't run east through the front of 6209 or west past the front of 6211. He He doesn't run anywhere opposite the man that he's just tried to kill. He decides to run through the backyard of 6209 and 6207, and somehow, even though 30 seconds ago Matthew Terry was stumbling weakly and helplessly through the backyard, now he finds the strength of conviction to chase him through the yard. That's what you have to believe. He is suddenly possessed of the moral fortitude to chase this man down. He doesn't say, I should probably go help Kay Baker, who's not dead yet. Because when Jonathan Figgins finds her, she's not dead yet. The killer has left the area where Kay Baker is. He's running northwest through the yards, and Matthew Terry doesn't say, go save Kay.
And Mr. Terrible has
Go
just
help
joined
Kay.
the clean and sober level to
scream and
become
yell
our
and
newest
call for
member.
help.
Thank you so much, Mr. Terrible.
Go bang on the
Thank you
door
so
of a
much.
neighbor's house. Nothing.
Yep,
He's now
exactly.
just gonna
Didn't
chase
cry
this
for
man
help.
who's armed,
Didn't pound on the
who's
door.
already supposedly nearly killed him once with a knife through the darkness and through the bushes down the dark side of Lithia Pinecrest, which has to ignore the complete fact that the blood pattern here shows somebody was lingering, hanging out. It's not the Phantom Killer. No one stabbed him with a knife. No one's beaten him up.
Cuts like a
The person who's
knife.
bleeding is him. It's the defendant. He's got to be lingering. Why is he lingering? That's what the blood pattern shows. The person's lingering in the corner. And now the killer goes through the bushes, and Matthew Terry, girlfriend still on the ground, still dying, still bleeding to death. Every heartbeat that she has is killing her. Says, I'm going to keep chasing this guy through the bushes. I'm going to go further into the darkness. I'm going to go further away from people. I'm going to go further away from help. I'm going to go further away from any person who can do anything to make the situation any better. I'm going to keep chasing the guy with the knife.
Nice.
And he runs all the way down the road, a football field, chasing this guy. Just a bit ago, he was
Chris
weakly
Pontak,
stumbling
member
along
for
a
2
fence
months,
line, but
says,
now he's got
I didn't know I got a
the
member
strength
chat.
to chase him
Not
down
being
the
a Vice
football
Squad
field.
girl. Thanks for keeping me not bored, Jeff. All y'all stay
then?
blessed. Well, I think you should come back more often.
We get to hear. State 64A. The killer has.
Oh, nice
run away
being
from
a Vice
Matthew
Squad
Terry.
girl. I
Matthew
said
Terry
not being a
has
Vice
chased
Squad
him this
girl.
whole
Okay,
distance.
never mind.
And now the killer decides to turn and do a second round of attack on Matthew Terry. And miraculously inflicts an almost symmetrical wound on the other side of the defendant's neck. This guy isn't just a killer, he's deadly active.
Nice.
Right? Matthew Terry has no other wound.
I'm a
There's
lingerer.
No wounds to his hands.
Yeah,
The
I'm a
doctors don't have to
lingerer.
repair
I
wounds
linger
to his
around and
hands,
around and around and
right?
around.
Defensive
Yeah.
wounds.
Uh-huh.
You know who's got defensive wounds? Kay Baker. You know why? Because Kay Baker was attacked with a knife. That's where the defensive wounds are. You saw them.
Yeah.
Matthew Terry's got no defensive wounds on his hands. He's got no stab to his abdomen, no stab to his face, no stabs to his arm. This phantom killer stabs Matthew Terry once over by Kay Baker, and then miraculously hits the exact opposite side in an almost mirror identical situation over here. And now Mr. Terry is bleeding all over the place. Even though Anna Cox tells you that there's lots of bleeding that's occurring and it's spattering everywhere, blood is spilling from Matthew Terry everywhere, right? And the killer decides to walk away. He doesn't finish off the eyewitness. He doesn't finish off the person who the killer could reasonably conclude would say, yeah, I saw the killer, this is what he looked like, he was 6 feet tall, he was whatever. Right? He doesn't finish that guy off. He stabs him a second time and then he leaves him. That's what you have to believe. He leaves him. And Matthew Terry is what? Now he is conveniently weak again. Now he is conveniently too weak to walk because he's being attacked, according to the defense, at the back of 6221. Here's State's Exhibit 3A. There's 6221. Right? Matthew Terry has got home after home after home, and even if you say, well, he's stuck in the backyards and there's nowhere that he could go because the backyards are fenced, he's got to go exactly 3 houses and he's at the end of the cul-de-sac, right? He's back on the street. Remember how the defense has gone to such great pains to tell you all how accessible this neighborhood is, how easy it is to take the walking trails, how easy it is to just walk down the cul-de-sac, how easy it is for a person to get in and out. But Matthew Terry, who's now been attacked twice, hasn't the foggiest clue what's happening with his girlfriend, who's bleeding to death in a neighbor's yard. He lays down on the ground. Right? He has no strength left now to do anything, to scream, to yell, to bang on a fence with a stick, to walk. Just walk. Walk a few houses down and get access to the cul-de-sac and find any person. Any person. None of that happens. None of that happens. There is nothing reasonable about that. You can play that game all day long, and you
I like
will
this guy.
exactly do what is
I like this
possible,
rebuttal.
what
This is strong.
speculative, what is imaginary, and what is forced. That is exactly what you would do. The defense tells you that there is no indication that the doors in those homes were broken that night between Matthew Terry and Kay Baker. And I challenge you to go look at all the photos, because the state of Florida put photos in of every room of that home. A home that is filled with 2 children. Kay Baker was the mother of 2 children. And go look and see how clean that home is for a mom of 2. Go look and see how lovingly, how carefully all the dishes are arranged in the dishwasher. Look at the photo of the closet, how all the clothes are hung. Look at the photos of the kids' rooms and how relatively neat they are. I mean, you can guess the relative age of these kids. They've got stuffed animals. They've got a Hot Wheels track, right? And look at the things on the ground. Look in the master bedroom and look at the strike plate and the piece of the lock.
As I was saying, the sarcasm is good. She had no duty or responsibility to make up any story, but she chose to make up a story, and now they can tear it apart.
Apathetic landlord didn't bother to clean up the mess. It would have had to have been sitting there for days. Nobody picked it up. Nobody did anything about it. Go look at the hallway outside the children's bathroom. Go look at the kid's bedroom that doesn't have the open window and look right at the entrance, and you'll see the strike plate on the ground from the bathroom. And right next to it, you'll see a toothbrush still in its packaging, the plastic wrapper. That's been sitting there for a long time, and some kid never picked it up, never moved it. It just conveniently got left there all that time. There is nothing reasonable about any of that. Nothing. Matthew Terry killed Kay Baker. You, as a jury, are tasked with deciding what was in his mind at the moment that happened. But there is only one logical conclusion, and I promise you, it doesn't have the first thing to do with the phantom burglar who turned into the cold-blooded killer for no appreciable reason. One person was angry at Kay Baker that night. One person was arguing with Kay Baker that night. One person was alone with Kay Baker in that house that night. And one person has Kay Baker's blood on his hands, both literally and figuratively. That man. He killed Kay Baker. He killed her with premeditation. He plunged a knife into her over and over again, and when she was in a moment of weakness, on the ground, he opened her neck. not by accident, but on purpose, with one intent. That is who Matthew Terry is. That is who Matthew Terry was on that evening. Do not believe in the phantom burglar. Find the defendant guilty as charged. It is the only just verdict. Thank you.
That was great rebuttal. That was good. That was solid.
You've been sitting for well over 2 hours. I am going to instruct you not to do any research related to the case, not to discuss the case amongst yourselves or with anyone else. It will be a relatively short break, an opportunity for you to stretch your legs, use the restroom if you need to. You'll come back in, I'll read the final instructions, and then you'll begin to deliberate. All rise for the jury.
Ugh. Yeah, we'll just put this on pause here. We'll take it away. So what am I thinking? Yeah, 2 stories, what to believe, says Will Call Magic. Yeah, that was unnecessary. The same way that the defense drug out the ending of their case with those 2 witnesses yesterday is exactly what the prosecutor did. I mean, the defense lady did. The defense lawyer, she had to say nothing. You don't have to put up the plausible story. You don't have to put up the possible scenarios. You don't have to speculate as to what happened. All you have to do is get up and say, the prosecution said they were going to show you this. They didn't. The prosecution said they were going to show you this. They didn't. Nowhere is there any direct evidence to show they couldn't find the murder weapon. The murder weapon's not there. They can be vague, but very, very assertive. But she chose to tell the O.J. Simpson, real killer story and go off into this weird narrative that nobody is going to believe. That was the stupidest fucking thing I've heard. Why would you do that? Because now you've tied yourself to a narrative when you never had to do that. And so all he's got to go do, first of all, the jury's going to be sitting there going, huh? What? That's not what happened, if they were paying attention. But then the prosecution gets to come in and rebuttal and just destroy that narrative that she has chosen to make. And that's exactly what he did. He went hard on the sarcasm. And it worked. Okay, yeah, because this makes sense. This is what they said. So yeah, that makes more sense than dude who, they can't bring up the prior conviction, but the dude which is better? This elaborate story of being chased around, dumping his girlfriend, letting her bleed out while he runs to chase down the guy, and then they're going back into the house and pulling out the screen and gently setting it down. And what's more believable? That, or he just got drunk and stabbed his wife in the face because he's an asshole. That's clearly it. I think the prosecution seriously is doing a great job. Their rebuttal is fantastic, and I think the defense counsel kind of messed up there with the closing. Beth, member for 2 months of the Clean and Sober crew, says, Jeff, thank you for always covering trials and going to work on little or no sleep for us and all the other streams you do. Aw, thank you so much. That's appreciated. But that was just dumb. And like I said, I think the defense counsel made a huge mistake. Well, let's read through the super chats and a couple of the other stuff we've got here, and then we can pick up Brooks for a minute if we are so inclined. Where's the comment? Start. Okay, here we go. Legal Vices, ask Steven next time, could the defense have requested the rest of the pieces of evidence be tested? Yeah, we talked about that yesterday. Ordinarily, you're limited to 5 pieces of known evidence at one time. But he said that in murder cases like this, especially capital murder cases where death penalty's on the line, if you let them know, they will set aside everything else and focus on your case, given the urgency of it. So yeah, they could have tested all of it. Execution, thank you so much for the super chat. It's not what you know, it's what you can prove. Yes. And she's doing a damn good job of saying that. And until she got into wild narrative that just to me is just stupid. Julio, same killer as the Darlie Roudier case. Case closed. I don't know that case. Sorry. And Ladybug Lisa, I'll lose my mind if the jury believes that pile of shit. Yeah. This needs a good solid sentence. She needs to be found guilty, needs a big solid sentence, and needs to. I don't think he's gonna get the death penalty. I think they'll be able to mitigate out of it because he doesn't have a huge history of violence. I'm thinking he'll be found guilty and not get the death penalty. But yeah, the jury's not going to believe that pile of shit. And D Pat, Legal Vices, when the OJ jury was deliberating, were any lawyers or pundits thinking a not guilty verdict, or was it totally unexpected? I think it was largely unexpected. I was expecting it. I remember like cheering when it happened because I don't think the prosecution met their burden of proof. But we're not going to get into that whole thing. You can watch my OJ streams every Thursday right here on Legal Vices, so you can hear me rant about that case. But yeah, I think it was kind of a shock to most people. But that's where we are. All right, we are all caught up. Oh, no, we're not. We're not caught up on Super Chats yet because the Japanese Yakuza 1 just Super Chatted. Let's scroll down here and get this bad boy. All right. Bought a a Nika coffee malt. Yeah, good. It's quite nice. If I remember, it was good as hell. You remember correctly. And a bottle of Tenjaku, another Japanese one. And to finish the story, I bought a Maker's Mark because of Johnny Depp. Never tried it, but it makes me think of Amber Heard. You should like the Maker's Mark. It's very cherry. It's got a lot of like cherry forward flavors. Jeff was the only white guy who cheered. No, it was in my third year of law school, and when it came time to announce the verdict, they wheeled televisions into the mock courtroom. Oh, excuse me. They rolled TVs into the mock trial room, into the auditorium, and turned it on. And of course there was all of the TV cameras from all the stations around the city were in there because they wanted to see how law students were reacting to it. And they read the not guilty, and I just went, yes! And like everybody just sort of looked at me, and the afterwards, a couple of the camera crews they wanted to interview me. And it's like, well, why did you cheer like that? And I said, because I don't think the prosecution handled their burden of the proof. Whether he's guilty or not, whether he's actually guilty or not is beside the point. It's whether the state managed to prove beyond a reasonable doubt that he did it. And I don't think he did. So yeah, I was a weirdo for a while. That was me. Let's put on some Brooks. What do you think? Is the Brooks still on a break? Brooks break? Is it a Brooks break? Let's pull up the Brooks and see if he's on a Brooks break. He's back. Oh, he's back in the courtroom too, because we heard he got sent to the bad boys room. I guess if you're reading chat. Don't fall asleep. Just get a baby bottle. Now, as soon as they finish reading the jury instructions, I'm gonna cash out. If they come back with the verdict today and I don't wake up, then we'll go through the verdict tonight. If they do come out with a verdict and I do wake up, I'll jump on stream and we'll stream it. And if it goes into tomorrow, it goes into tomorrow. Daniel Roudier says, Julio, kid stabbed by mystery burglar and she had superficial wound to her neck. The woman who did the silly string at cemetery in Texas. Someone did silly string at a cemetery in Texas? Okay. Love the MMs, OJ and trials. Yeah, Maritime Mondays, OJ and trials. No, thank you much. That's kind of what we do here. And the Japanese Yakuza, again, sending another super chat. Hibiki has been my favorite Japanese whiskey of all time for some reason. I love the Japanese whiskey coming from Europe. Yeah, that's my Hibiki shelf right there. I've got a Hibiki Harmony, a Hibiki Master Select, and in the middle is a Hibiki 17 year, which they just don't make anymore. And if you can ever get your hands on a 17 year, do it. Digger's going to sleep before me. You coward. You lame. Ha ha. It's only 5:14 a.m. here. All righty. Thank you so much for those super chats, guys. That was good to see those again. It was a while. I had to listen to that. That story she put out. That narrative was so dumb. It was pointless and stupid. Nobody is going to believe that happened. But again, she's zealously advocating for her client, which is what she has to do. She is aggressively arguing for him, and all it takes is for one juror to have reasonable doubt, and you get a hung jury. You convince them all, you walk. Alrighty. The law and crime camera is still out in the Terry trial, but looks like Idiot Stick is saying something on the other channel, so let's bring up Idiot Stick here.
Revenge.
Oh no, he's just pounding his chest. Wait. Get that
Imagine
butter.
God's love. Give us a blanket and comfort. When I see a blue light, I see this community's commitment to help heal and support each other. Judge, you have witnessed the same evil I have. You have endured a very emotional and draining trial as I have. I ask for the full punishment within your power. I ask you to send this evil animal to life in prison with no chance for parole for the callous murder of my wife and 5 others and injuring 61 others. He should never have the opportunity to hurt another person and has forfeited his right to be a free man ever again by his violent actions against innocent lives, both young and old. You are a very evil, evil animal. Amen.
Gotta wonder if he actually has any feelings at all.
Thank you. I have one very brief statement from a young woman who was marching with the grannies, and then we have, I believe, 3 statements from one more family before the next group will have to be brought in. This is a statement from a young woman who was holding the banner with the grannies, and she marked down that the crime made her feel sad, mad, scared, and then also wrote in valuable. Asked if you were the judge, what would you do to the offender? She checked, send them to prison.
There are no
And then her own idea,
subtitles
make
for
the
this.
offender go through the physical and emotional pain
I'll be right
I
back.
went through.
Thank you. My name is Taylor Kulik. Standing next to me is my oldest son, Robert. I am the oldest daughter of my mother, Jane Kulik, and it is on her behalf that I will be making a statement today, as she's unable to speak for herself. November 21st, 2021, the day my life was forever changed. The day my mom was murdered. It's still hard to believe that my mom was killed while marching in a Christmas parade. I will never forget that day. When I received the phone call stating that my mom had been hit, I rushed to the hospital to find her. Within minutes of arriving at Waukesha Memorial, people of all ages flooded into the ER. Many injured, many searching for their family members, just like we were. It was complete chaos. After 3 hours spent searching and waiting, finally, a nurse came and asked us to sit down. My heart sank. I listened as they told us how my mom was unconscious when she was loaded into the ambulance, that they tried to save her, but the damage was too severe for her to fight. She was dead upon arrival. She didn't even make it to the hospital. It hit me like a ton of bricks. My mom was just murdered. She was dead. I did not sleep at all that night. All I did was cry. I sobbed for the loss of my mother. I bawled for the pain of my children losing their grandmother. And I wept for the rest of my family as we had all just lost an absolute gem. Next picture, please. I still cry, even as we approach 1 year without her. This year of all the firsts without my mom has been difficult, to say the least. Every holiday, birthday, and monumental life moment, each of those moments another reminder that she's not here. She was known for giving cards on every occasion, and she showed up to everything she was invited to. She was always present because she genuinely cared. You could tell by the way her smile lit up the room or how contagious her laughter was. Her presence alone was just a sense of comfort, a feeling of home. She was supportive, encouraging, and just so laid back that you couldn't help but get along with her. These are just some of the reasons we all love and miss her so much. Next picture, please. Her name was Jane Kulik. Her sister called her Pain, so she was Auntie Pain to my cousins, and known only as Grandma to my kids. But for me, her name was Mom. Mom and I were super tight. I could talk to her about anything in the world. We used to text each other almost every day, talk on the phone almost at least once a week, and go out to lunch, just her and I, every other week. Every day, I'm missing those text messages. I miss hearing her voice on the phone and receiving her adorable voicemails, or seeing her face light up when I unexpectedly pop up at the house. To simply say I miss my mom is a dramatic understatement of my true feelings. I'm devastated, a bit lost, and I can't fully describe how it feels other than a piece of me is missing. My smile is not so bright. I don't laugh the same anymore because I'm just not the same. I have never experienced such a painful level of sadness for so many consecutive days. I have never felt this level of heartache for myself or for my kids. Even though we talk about it, I can only imagine how my kids have felt this past year. Not only are they coping with the loss of their own grandmother, but also they've had to watch me, their mom, grieve my mom. My oldest son is dreading his upcoming birthday, just like we all did this year, as it's his first in 15 years without her. My mom always said they had a special bond, and they really did. She had a unique bond with each of her grandkids, as she did with each of us.
Yep,
My
Jerry's
other
back.
son, Darius, was worried that he would forget
Hang
his
on.
grandma's voice.
We're going back here just a second.
Beyond a reasonable doubt, you will next need to decide if he is guilty of any lesser included crime as to that count. The lesser crimes included in the definition of first-degree murder are second-degree murder and manslaughter. Matthew Terry is accused of first-degree premeditated murder in count 1. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find K.E. Baker was killed by Matthew Terry, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Matthew Terry may be found guilty of first-degree murder or any lesser included crime. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, K. Baker is dead. Number 2, the death was caused by the criminal act of Matthew Terry. Number 3, there was a premeditated killing of K. Baker. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix an exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Matthew Terry did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Matthew Terry was in fact so provoked and did not cool off before he committed the act that caused the death of Kay Baker. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. If you find that Matthew Terry committed the lesser offense of first-degree murder, and you also find a reasonable doubt that during commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Matthew Terry committed in count 1 the lesser offense of first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of first-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt.
Now, all of this, the jury will
Kay
be able to
Baker is
read
dead.
the instructions. They
Number
don't have
2,
to remember
death
it
was
all.
caused by the criminal act of Matthew Terry. Number 3, there was an unlawful killing of Kay Baker by
No,
an
he's
act
not.
imminently dangerous
Lame.
to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that Matthew Terry committed the lesser offense of second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as 1, any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2, any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Matthew Terry committed in count 1 the lesser offense of second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty
Back in a
only of
flash.
second-degree murder. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. Number 1, Kay Baker is dead. Number 2, Matthew Terry intentionally committed an act or acts that caused the death of Kay Baker. The defendant cannot be guilty of manslaughter by committing a merely negligent act or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Matthew Terry committed the lesser offense of manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon is defined as 1. Any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or 2. Any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Matthew Terry committed in count 1 the lesser offense of manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of manslaughter. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he knowingly consumed a substance that he knew or should have known could cause intoxication. Matthew Terry has entered a plea of not guilty. This means you must presume or believe he is innocent. This presumption of innocence stays with him as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome his presumption of innocence, the state has the burden of proving that the crime with which he is charged was committed and that he is that person who committed that crime. Matthew Terry is not required to present evidence or prove anything. Whenever the phrase reasonable doubt is used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt.
And that's
Such
what
a doubt
her
must not
scenario
influence you
was.
to return a verdict of not guilty if you have an abiding conviction of his guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction of his guilt, or if you have a conviction of his guilt, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty because your doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of Matthew Terry may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. If you have a reasonable doubt, you should find him not guilty. If you have no reasonable doubt, you should find him guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Has any pressure or threat been used against a witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The evidence which has been admitted to show other crimes, wrongs, or acts allegedly committed by the defendant will be considered by you only as that evidence relates to proving an intent, identity, or absence of mistake or accident. However, the defendant cannot be convicted for a crime, wrong, or act that is not included in the indictment. The Constitution requires the state to prove its accusation against Matthew Terry. It is not necessary for him to disprove anything, nor is he required to prove his innocence. It is up to the state to prove his guilt by evidence. Matthew Terry exercised a fundamental right by choosing not to be a witness. You must not view this as an admission of guilt or be influenced in any way by his decision.
That's
No
what we were
juror
talking about
should
earlier.
be concerned that Matthew Terry did or did not testify at trial. A statement claimed to have been made by Matthew Terry outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence whether his alleged statement was knowingly, voluntarily, and freely made. In making your determination, you should consider the total circumstances, including but not limited to 1. Whether when he made the statement he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude that his out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There's no reason for failing to follow the law. Everyone is dependent
These are just
upon
standard
you to make
jury
a wise
instructions.
and legal decision. This case must be decided only upon the evidence that you
instructions,
have
not
heard from the
decisions.
testimony of the witnesses and have seen.
We're
in the
reading
form
the jury
of
instructions
exhibits
now.
in evidence and these instructions. This case must not be decided
Nope,
for or against
sorry.
anyone because you feel sorry for anyone or because you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in any way. Whatever verdict you render must be unanimous, which means that each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding
Very
a verdict
standard
is
instructions.
exclusively your responsibility. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think that I prefer one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser offense as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense which was proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must also be in writing, and for your convenience, the form of verdict has been prepared for you. Thank you. I have it here. It is one page.
All
I know
right.
you can't read it from there. I'm going to hold it up. What I do is I take it out of the stack. As I indicated, the instruction to go back with you, the verdict will be on top of the stack. It reads
Here
as
we
follows:
go.
State of Florida versus Matthew
Last
Robertson
page.
Terry, and then it has the title verdict form. Under that it reads, we the jury find as follows as to count 1. Then in parentheses there are instructions that say check only A, B, C, or D, plus any other specific findings. Then it says, then A reads, the defendant is guilty of first-degree murder as charged, and under that there is 2 statements with lines next to them. The first says, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use a weapon. Or the second line reads, during the commission of the crime, he did not carry, display, use, threaten to use, or attempted to use a weapon. Under that, choice B reads, the defendant is guilty of second-degree murder, a lesser included offense. And then there's the same 2 choices. I'll read them both. First, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use.
I don't think we'll get a
weapon.
verdict
Or,
today. It's getting
under
late.
That, it reads, during the commission of the crime, he did not carry, display, use,
I think it'll be
threatened
tomorrow
to
morning.
use, or attempted to use a weapon. Under that, choice C reads, the defendant is guilty of manslaughter, a lesser included offense, and under that, 2 findings. The first, during the commission of the crime, he carried, displayed, used, threatened to use, or attempted to use a weapon. Or the second reads, during the commission of the crime, he did not carry, display, use, threatened to use, or attempted to use a weapon. Then choice D reads, the defendant is not guilty. Under that, it says, so say we all, dated this blank day of November 2022. And then there are 2 lines, one for the foreperson of the jury to sign their name, and one for the foreperson of the jury to print their name. In just a few moments, you will be taken to the jury room by the bailiff. The first thing that you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to return the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction that I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is
in closing, I love those words.
Out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law.
His
No
in
juror
conclusion
has
is
the right to
taking a
violate
while.
Rules we all share. That is all of the instructions, and as I said, I am taking the stack, and that will be coming back to you, as well as the exhibits. It may take us a little bit of time to get those back to you. I'm putting the verdict form on the top of the stack of instructions. There's one last thing before I send 12 of you back there. There's 13 of you in that box.
Have to get rid of
We always
one.
select alternate jurors. In fact, in this case, we used 2 of our alternate jurors. I'm going to ask Mr. Christian Gonzalez to remain behind. Mr. Gonzalez, you are our alternate juror. I will have some additional instructions for you But I'm going to send the rest of the jury back to begin deliberating at this time. Take your
yay.
notepads with you into the jury room now. All rise for the jury. You need to keep them? Okay. Yes.
That's it. There you go. Whew! It is in the hands of the jury now. I don't think there's any way they're coming back with a verdict today. It's already 4 p.m. there, so I figured they'll go for maybe 1 or 2 hours, and I would expect the verdict to come back in the morning. All right, they're gone, so let's bring them back up. They're talking to the lawyers here for a second. What? They didn't give us audio. Oh, come on. They forgot to turn the audio back on. Boo. Oh, well, we'll leave this up in case the audio comes back on. First, the results of our poll. Stabby McStabface, guilty. Of course, I'm not an idiot. That was 84% of you. Shaggy Defense, wasn't me, succeeds. 6%. And jury is stupid and can't decide, gets 10%. All right. We've got all the super chats read. We've got the poll read. We are good to go. And apparently they're not going to turn up the volume on what the judge is saying here because they're stupid. So bearing that in mind, ladies and gentlemen, we're at the end of the trial. The verdict is probably coming tomorrow morning, my time. Or it gets to be like late. Yeah. It'll be after midnight my time. So I guess it would still be morning. Morning in Florida time. They'll have the verdict. I'm pretty sure. I can't imagine it going into lunchtime. So thank you so much to everybody that watched this. Thank you so much, everybody that gave the super chats. Thank you, mods, especially you mods that stuck with it. That's great. That stuck with it from the very beginning today until now. You guys are great, as you know, because you are the Vice Squad. You only have to be here once to be the Vice Squad, and so you're all the Vice Squad. You know you're the best damn chat on the entire internet. Please do me one big giant favor and hit that like button if you haven't already done so. We're going to drop this here in just a minute. But please hit that like button on your way out. And my goal today was to get to 32,300 subscriptions. Let's see. And how many did we get? We got... I'm 14 short of my goal. I just need 14 new subscriptions, and that'll get me to my goal that I set for myself today. So if you haven't subscribed, I would be deeply honored and deeply appreciative if you would reach down there and click that like button. That would make me very, very happy. And reach down even a little bit further and hit that subscribe button. That would make me really, really super happy. I'm 14 away from the goal I was setting for myself. And we join the memberships. We've got some merch down there, but here's what's coming up real quickly for the rest of the week. Assuming this thing finishes tomorrow, we'll do this tomorrow and the Brooks trial. Hopefully, the actual sentencing will be tomorrow. Thursday, OJ Simpson, Friday, The Unexplained, and then next Monday will be Maritime Monday. Guys. Oh, wait. The Japanese Yakuza had something to say here. Let me scroll down here and see if I can find it again. Where'd it go? It keeps scrolling away from me. Oh, now they turn the microphone on.
I emailed it to Jeanette. Can you just print the one page? Or no?
Last time
I didn't know.
printed out in a different
Legal Vices, you showed my first super chat and read my second. So first one is not read. I read them both. You put two of them close together.
Well, I'm not placing it up here yet because we're putting a slightly altered.
You actually had 3. You had the.
So.
Oh, you're right. I apologize.
We'll leave it here for now, and then when we get the new.
I apologize. You are correct. Sorry about that.
It might be pretty now. I'll invite you all down to take a look at it, approve it, and then we'll substitute it.
Okay, they're not talking about anything important. No. Japanese Yakuza. It was me. I did not read it. You are absolutely correct. I'm a dork. The Japanese Yakuza about an hour ago said was at the liquor store today and asked for ID. You have to be 20 to buy at a liquor store here in Sweden. And she said, "Oh, you're that old? I'm 25. I'm 28 and felt old as fuck." Sorry for not reading that. Japanese Yakuza says I was drinking, so no clue. All right, well, that was not a big thing that the whatever it was the court had to do. They apparently didn't need to include us in any of it. So I'm going to end this here. We will see you tomorrow at 9 a.m. Eastern, 2 p.m. UK time for hopefully the verdict. You guys, again, mods, chat, those of you that are just going about your day and your night or whatever with this on in the background, thank you all so much. Hit that subscribe button. And how many did we get? What was the final subscriber number? I just asked for 14 more and we got 0 more. So you must all 400 of you must still be members. Must be members already. 14 short of my goal. Oh well, we'll get that tomorrow. Good night actually it's good morning from Korea. It's starting to get a little bit gray outside. It is 6 a.m. I'm going to sleep for 3 hours. Take care. And as I always say, do not forget to enjoy your legal vices. Bye now.